fresh matter for admission.
Fresh matters.
That's on Monday,
Fresh matters.
Next week, man.
Fresh matter insurance company tomorrow.
Huh?
Tomorrow, insurance company fresh matter.
My lord,
Yes.
criminal matters, my lord.
Huh?
Criminal matters. Criminal matters.
Huh.
Additional SVP of unavoidable circumstances today and tomorrow will not be available, madam. Matters may be taken next week.
What matter? Serial number 44, it's a further hearing matter. It can be had on Monday in the light of this development.
Yes,
Monday, 2:30 ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ರೆ. We'll finish it off. 44, further hearing it. My submissions have been completed in this matter. And that day it may take not more than 10 minutes from my side.
My lord, serial number.
Serial number 44 for Monday. ಮಿಕ್ಕಿದೆಲ್ಲ ಕ್ರಿಮಿನಲ್ ಮ್ಯಾಟರ್ಸ್ ಡೇಟ್ ಏನ್ ಕೊಡೋದ್ ಬೇಡ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂತ ಹೇಳೋಣ.
yes.
I'm grateful.
Serial number 38, my lord.
Huh?
So 38, my lord. In this 38, my lord. Petitioner respondent already in intimation, my lord. Next week, my lord. Senior is out of station, my lord. Already other side in
You are for the petitioner.
petitioner, my lord.
Mr. Prashant Kumman.
Yes,
I am
my lord.
on behalf of Shankar, I appear.
ಏನ್ರಿ ಡೇಟ್ ಗಿವನ್ ಮ್ಯಾಟರ್ಸ್ ಏನ್ರಿ ಇದು?
ಔಟ್ ಆಫ್ ಸ್ಟೇಷನ್ ಇದಾರೆ NB ದಿವಾಂಜಿ ಔಟ್ ಆಫ್ ಸ್ಟೇಷನ್, ಅದಕ್ಕೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಮಾಡ್ಬಿಡ್ತಾರೆ.
Serial number 38, at the request of learned counsel for the petitioner, release this matter on 18th of December. Yes.
Bill number 1, admission matters. Anil Rathod.
My lord, appellants had wrongly filed the suit for declaration and possession without seeking the partition and possession, my lord. Kindly permit them to file the appropriate suit of partition before the trial court, my lord, with liberty to withdraw the appeal.
You want to withdraw the appeal?
Yes, my lord. Liberty to file the appropriate suit for partition before the trial court, my lord.
Where is your memo?
Kindly permit, I will file memo.
Please file memo.
Obliged.
You want to file it today?
Yes, my lord.
It's better you file the memo with the signature of the party.
Yes, my lord.
If you are withdrawing an appeal,
Yes, my lord.
it's a serious matter.
Yes.
So it's better you file an memo with the party.
Yes.
So that tomorrow he cannot say,
No,
no, I was not informed.
No, my lord.
It is
Monday.
better to file a memo
Yes, my lord.
which has the signature of the party.
Appeal. Okay. Monday I will file, my lord. Parties are.
At the request of learned counsel for the appellant, release this matter on 16th of December, Monday,
Obliged.
next Monday.
Obliged.
Serial number 2, Ex-parte.
This petition is by the husband, madam. The petition for divorce was dismissed by the trial court. Present appellant, my lords, now is aged about 62 years. Last date of hearing, my lords, since the other side was not there.
Huh?
Last date of hearing, my lords, since last 2 hearings, the other side was not there. Since both are, my lords, living separately from 2010. And there was admission to that effect also in the cross-examination. And there is allegation that he has married. Therefore, we, in fact, it's
See, if the other side is not coming, at this stage, we cannot dispose of the matter.
any date.
Admit and call for records, that's all. Admit, call for trial court records.
Serial number 3, Liga M. Chimko.
Matters called out. There is no representation for the appellant.
Liga M. Chimko. Serial number 3.
There is no representation for either of the parties. Full stop. List this matter after winter.
Serial number 4, Sachin M. Mahajan.
Suit for, commercial suit, my lord, for recovery of money is partly decreed. The appeal is, my lord, for that portion of the, my lord, claim which is not decreed. The relevant portion of the order is at page number 155, internal page number 65. All those claims, my lord, which are made in page number, internal page number 64 of the judgment, they are decreed. They are rejected. Contractor, my lord, who has completed the work of KVJNL, he filed, my lord, the suit for recovery for the amounts, my lord, which he is entitled to, along, my lord, with the interest for delayed payments. There were several, my lord, claims involved under various heads. Now, the appeal is confined only to that aspect.
ಏನ್ರಿ ಇದು ಅಪೀಲ್ ಮೆಮೋನ ಇದು?
My lord, it is
90 pages.
It is, my lord, it has been
ಯಾರ್ ಮಾಡಿರೋದು ಇದನ್ನು?
Mr. Gurraj Joshi, my lord, from Bangalore. Gurraj Joshi, my lord, from Bangalore. Even I was, my lord, for a minute. This amount of length, my lord, my lord, I will see, concede, my lord, it is not required. It is an argumentative appeal, my lord, where portions of the judgment are called out, portions of the judgments of the
ಏನು
apex
what
court
is
are
the
called out.
there is no interim prayer.
There is no interim prayer.
Issue notice to the respondents.
My lord, may I request, my lord, Krupasagar Patil, who had appeared in, my lord, the connected writ petition to
Learned government advocate is directed to take notice for respondent number 4. Learned counsel Shri Krupasagar Patil
for respondent number 1 to 3, my lord.
is requested to take notice for response number 1 to 3.
3.
Learned counsel for the appellant is directed to serve copies of the appeal memo along with annexures on the learned government advocate as well as learned counsel Shri Krupasagar.
Seal number 5, Manvendra Reddy.
The first appeal is suit for partition, my lord, and ex-parte degree, my lord. Therefore, I mean, permitted to contest them.
No delay.
And no delay.
What is the interim prayer?
Yes,
Say the execution on
a decree.
we will direct the trial court not to
Draw final decree.
draw the final decree.
That serves the purpose.
ಅಲ್ಲ ಇದು ಫೈನಲ್ ಡಿಗ್ರಿ ಅಲ್ಲಿ ಲ್ಯಾಂಡ್ ಅಕ್ವಿಸಿಷನ್ ಅಮೌಂಟ್
Partition suit ಅಂದ್ರೆ
ಪಾರ್ಟಿಷನ್ ಸೂಟ್ ಅಕ್ವೈರ್ ಆಗಿದೆ
ಹಾ
ಲ್ಯಾಂಡ್ ಅಕ್ವೈರ್ ಆಗಿ ಡಿಗ್ರಿ ಮಾಡೋದು
ಹಾ
ಅದ್ರಾಗ 1/9 ಶೇರ್ ಇದೆ ಅಂತ ಆರ್ಡರ್ ಅಮೌಂಟ್ ಇದು ಆಲ್ರೆಡಿ ಅವಾರ್ಡೆಡ್ ಇದು ಲ್ಯಾಂಡ್ ಅಲ್ಲ ಇದು
ಎರಡು, I think,
ವಾದಿಯ ದಾವೆನ ಡಿಗ್ರಿ ಮಾಡಲಾಗಿದೆ ವಾದಿಯರು ದಾವಾಸ್ತಿಗಳಲ್ಲಿ ಮತ್ತು ಭೂ ಸ್ವಾಧೀನ ತೀರ್ಪಿನ ಅಡಿಯಲ್ಲಿ ನೀಡಿದ ಪರಿಹಾರ
there are other,
ಪತ್ನಿ ಪ್ರತ್ಯೇಕ ಹಿಸ್ಸ ಹೊಂದಿರುತ್ತಾರೆ ಅಂತ ಆದೇಶ
there are other properties also.
ಅದರ್ ಪ್ರಾಪರ್ಟೀಸ್ ಮಾಡಿ ಮಾಡ್ಬೋದು FDP ಇದು
ಇದನ್ನು
ನಂಬರ್ ಇದು
ಡಿಗ್ರಿನೇ ಸ್ಟೇ ಮಾಡಿದ್ರೆ ಯಾಕಂದ್ರೆ
ಇರೋದು
ಅದು but ಅದನ್ನು ಶೇರ್ ಆಗಿ ಮಾಡಿದಲ್ಲ ಅದು ಅದನ್ನು
ಲ್ಯಾಂಡ್ ಅಕ್ವೈರ್ ಆಗಿರೋ ಶೇರ್ ದುಡ್ಡು ತಾಬಾರ್ದು
ಅದೇ that is also one.
ನೀವು ತಾಬಾರ್ದು ಅವ್ರು ತಾವ
ಅದೇ ಸ್ಟೇ ಆಗ್ಬಿಟ್ರ ಡಿಗ್ರಿನೇ ಸ್ಟೇ ಆಗಬಿಟ್ರೆ ಎಲ್ಲ ಎರಡೂ ಆಗಿ
ಇದರಲ್ಲಿ ಯಾವ ಪ್ರಾಪರ್ಟಿ ಅಕ್ವೈರ್ ಆಗಿದೆ ಯಾವ ಪ್ರಾಪರ್ಟಿ ಅಕ್ವೈರ್ ಆಗಿದೆ 4 ಪ್ರಾಪರ್ಟಿ ಅದ
ಎಲ್ಲ
ನಮ್ ಕಾಂಪ್ರಮೈಸ್ ಆಗ್ತೇವೆ ಅಂತ ಹೇಳಿ ಅವರು ಡಿಗ್ರಿ ಮಾಡ್ಕೊಂಡ್ರು.
ಯಾವ್ದು ಎವಿಡೆನ್ಸ್ ಮಾಡಿಲ್ಲ ನೀವು
ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಇಲ್ಲ ಏನು ಕ್ರಾಸ್ ಮಾಡಿಲ್ಲ ಏನು ಎಕ್ಸ್ಪೈರ್ಡ್ ಡಿಗ್ರಿ
ಅಲ್ಲ ಡಿಫೆಂಡ್ಸ್ ಹ್ಯಾವ್ ನಾಟ್ ಅಡ್ಯೂಸ್ ಎನಿ ಎವಿಡೆನ್ಸ್
ಸರ್ ಮಾಡಿಲ್ಲ ಸರ್ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಇಲ್ಲ ಎವಿಡೆನ್ಸ್ ಇಲ್ಲ
ಅದು ಆನ್ಸೆಟ್ ಪ್ರಾಪರ್ಟಿ ಅಂತ ಹೋಲ್ಡ್ ಮಾಡಿದ್ರೆ
ಅದೇ that's why there is no defense at all, my lord.
ಹೌದು
Therefore permitted.
Details ಇಲ್ಲ. ಈ ಇದ್ರಲ್ಲೂ ಅಷ್ಟೇ.
ಅಲ್ಲ ಅವ್ರು ಎಕ್ಸ್ಪರ್ಟ್
ಇಲ್ಲಿ ಈ ಇದ್ರ ಬಗ್ಗೆ ಭೂಸ್ವಾಧೀನದ ಬಗ್ಗೆ ಯಾವ ಸರ್ವೆ ನಂಬರ್ ಅಂದ್ರೂ ಹೇಳಿಲ್ಲ. ಅವ್ರ ಪ್ರೇಯರಲ್ಲೇ ಇಲ್ಲ.
ಆಪರೇಟಿವ್ ಪೋರ್ಷನ್ ದಲ್ಲಿ
ಪ್ರೇಯರಲ್ಲಿ ರಿಚ್ ಅಮೌಂಟ್ ದಿ
ಯಾರು
ಸೋಷಿಯಲ್ ಪ್ರಾಪರ್ಟಿ ಅದನ್ನು ಏನಿಲ್ಲ. ಅಮೌಂಟ್ ಎಲ್ಲ ಸ್ಟೇ ಮಾಡೋಣ.
ಡಿಗ್ರಿನೇ ಇಟ್ಸ್
ಬಂದ್ಮೇಲೆ
ಸಪೋಸ್ ಇವರು ಆನ್ ದಿ ಬೇಸ್ ಆಫ್ ಬಾಡಿ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್
ಸ್ಟೇ ಆದ್ರೆ ಇವರು ಮಾಡಕ್ ಬರಲ್ಲ.
ನಾನು ಮಾಡೋಣ.
Issue notice to the respondents. Full stop. In the meanwhile, there should be an ad interim order of stay of the impugned judgment and decree passed in OS number 65 of 2019 on the file of the senior civil judge and JMFC, Mudde Bihala till the next date of hearings. Full stop. It is made clear that even the appellants will not be permitted to withdraw the compensation amount till the next date of hearing.
CL number 6, Commissioner Reddy.
It is a ex-parte judgment, my lord. It's good for partition, my lord. Since appellant was not served, not appeared before the court, my lord.
Not served.
And not appeared for the court, my lord, it's a partition. Though the fathers of this appellant and respondent number 1 have partitioned in their lifetime, my lord. Once again, he has filed the suit, got ex parte order, my lord, and ex parte order of partition, my lord, of all the suit properties, which are already partitioned and they are in exclusive position of the all the respective positions, my lord. And they have filed the FD proceedings now, my lord. After that, we got to know about the that judgment, my lord.
ಒಬ್ರು ಮಾತ್ರ
ಒಬ್ರೆ
ಒಬ್ಬರಾದ್ರೆ
ಒಬ್ಬರೇ.
3 ಜನ 1 and 3 expert 2 only contest.
Who was the employee of a government employee, my lord, he did not appear for the court. Though filed wakalat
ಅವರು ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕಿಲ್ಲ,
ಹಾಕಿಲ್ಲ.
ಅದಕ್ಕೆ ಡಿಗ್ರಿ ಆಯ್ತು.
You did not file miscellaneous petition.
No, my lord, because only after FD proceedings, I came to know about the judgment and decree and after this honorable court, my lord.
So there is a delay.
There is no delay, my lord, because without, immediately
No
after
delay.
judgment, they filed FDP, my lord, for partition. Because of the ex-parte degree, they wanted to get executed the order, my lord. When I came to know about.
The judgment was passed on 26th of June 2024.
Yes, my lord. Yes, my lord.
ಅಲ್ಲಿಂಗ್ ಇದಿದೆ ಹಂಗೆ 26th of June 2024. So this is filed on 21st of September.
September.
Issue notice to the respondents. Full stop. The trial court is directed not to draw up the final decree till the next date of hearing. Yes.
CL number 7, Babu Rao Mangani.
My lords, in this case, the matter was already heard. As far as the sentence is concerned, 7 years, 7 years sentence, my lords.
Mr. Additional SPP is not here today. Morning itself, he has made a statement. We'll have it on Monday.
Please.
Release this matter on 16th of December.
CL number 8, Harshvardhan R. Mali Patil.
Respondent 2 to 4, my lord, appearing. Your lordship, this matter was heard for some time last occasion.
This matter, my lords, relating that dismissal of an employee wherein the 11 charges were framed against him, my lords. And your lordships heard this matter on day before yesterday. my lords.
ಏನದು?
In respect, the learner single judge, as my lords, set aside the order of dismissal and order for reinstatement.
Kindly pass forward.
And this is only in respect of the, my lords. This matter, my lords, your lordships have heard with respect to the reinstatement concern, my lords. Your lordships expressed that since there is an liberty is reserved to the respondent number 4, the present appellant herein, to hold a fresh inquiry. Since what has happened is, my lord, there were 11 charges were framed against the present respondent number 1. And out of the 11 charges, 6 charges documents were furnished. The other remaining charges, no documents were furnished. And the respondent number, my lords, as continues to hold the inquiry and no evidence is recorded. And therefore, your lordships have directed, my lords, to get an instructions in respect of the reinstatement concerned. The only inquiry can be continued against him so that it can be disposed of within 6 months without reinstating as per the order of the learner single judge.
Pass over.
Obliged.
Only one request is that, my lords, this matter can be disposed of.
ಅದು ಬರ್ಲಿ ಅವ್ರು.
Namdu one request under respond number 4, he made a certain allegations against him before the Lokayukta. Other than the respond number 4, my lords, if any officer is appointed, let them complete, my lords, the inquiry proceedings within 3 months so that without reinstating.
Yes.
CL number 9, Preeti Patil Melkundi.
In this case, my insurance company challenging liability, my act policy is there, my lord. The car is not covered with the liability, only act policy, my lord. The insurance company challenging liability, only the policy is act policy, my liability policy, man.
Liability.
Yes, my liability.
No delay.
No delay.
No delay. Learned Counsel Shri Veerani V. Nandi.
Lordship, I am appearing for the respondent.
Huh?
I am appearing for the respondent's lordship.
ಅದೇ
Claimants
ತಾನೇ?
report.
Veerani.
Like KV petitioner, sir.
Who is this? Veerani B. Nandi.
Veerani V. Nandi. I am the.
Neva.
Yes, sir.
So you have filed wakalat.
Yes, sir.
You want to show the name of Mr. Ravi V. Patel.
Along with
alla ಬರೋದಿಲ್ಲ.
ಆಯ್ತು ಯಾರು
ನಿಮ್ಮ ಹೆಸರೇ ತೋರಿಸ್ಬೇಕು ಅಂದ್ರೆ ನಿಮ್ಮ ಹೆಸರೇ
ನಮ್ಮ
ತೋರಿಸ್ತೀವಿ.
ಹೆಸರು
Learned counsel Miss Veerani V. Nandi has entered appearance for response number 1 and 2.
Yes.
And
1,
what
2, 3.
about the others?
Others notice folks. Others notice folks.
Issue notice to the other respondents. Next para. In the meanwhile, there shall be an ad interim order of stay of the impugned judgment and decree passed in MVC 577 of 2018 on the file of the senior civil judge and additional MACT, Basava Kalyan till the next date of hearing, subject to the appellant depositing 50% of the award amount before the tribunal within a period of 6 weeks from today.
We don't call for records, man. Call for records, man.
Call for trial court.
Lordship, that claimants respondent number 1
ಅಲ್ಲಿ
and 2.
ಡೆಪಾಸಿಟ್ ಅಲ್ಲಿ ಮಾಡಕ್ ಹೇಳಿದೀವಿ.
Yes, ma'am.
ತಂದ್ಬಿಟ್ರೆ ಕಷ್ಟ, ಅದು ಬೇಡ. ಲಾಸ್ಟ್
Otherwise,
we will see afterwards. Yes.
The Lordship, respondent 1 and 2 praying the Lordship, they may be permitted to withdraw this.
No, liability policy.
Because the Lordship, if the liability is not fixed on the respondent number 2, the insurance company Lordship, ultimately pay and recovery may.
No, pay and recover also. Liability act policy.
We'll see,
That's not.
we will consider, yes.
CL number 10, Babu H. Metagudda.
Seeking announcement and also challenging liability. Both future prospect not awarded. Death case and injury case percentage of
Enhancement, seeking enhancement
and also challenging liability. Pay and recovery.
liability.
Pay and recovery.
Owner of the vehicle.
Owner ಮೇಲೆ ಹಾಕಿದ್ದಾರೆ.
ಎರಡು
ಎರಡು
appeal.
ಒಂದು ಡೆತ್ ಇದೆ, ಒಂದು ಇಂಜುರಿ ಇದೆ ಸರ್.
So ಇಬ್ರು
ಇಬ್ರು ಓನ್ಲಿ ಪೇ ಅಂಡ್ ರಿಕವರಿ ಸಮ್ ಚಾಲೆಂಜ್. ಇದು ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಮಿಲಡ್ ಫಸ್ಟ್ ಕೇಸ್ ಅಲ್ಲಿ ಇಪ್ಕೊಟ್ ಹೋಗಿ ಹೋಗ್ತಾರೆ ಸ್ವಾಮಿ. ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 1ಗೆ ನೋಟಿಸ್ ಹೋಗಿ ಸ್ವಾಮಿ, ಇಂಜೂರ್ ಕೇಸ್ ಮಿಲಡ್ ಫ್ರಾಕ್ಚರ್ ಆಫ್ ಲಿಮರ್ ಇದೆ.
ಬಟ್ ಯು ನಾಟ್ ಆಸ್ಕಿಂಗ್ ಫಾರ್ ಎನ್ ಇಂಟ್ರಿಮ್ ಪ್ರೇಯರ್.
ಇದರಲ್ಲಿ ಈ ಕ್ಲೇಮೆಂಟ್ ಅಪೀಲ್ ಫಾರ್ ಎನ್ಹಾನ್ಸ್ಮೆಂಟ್
ನೋಡಿ, ನೀವು ಯು ಆಲ್ಸೋ ಕ್ಯಾನ್ ಆಸ್ಕ್ ಫಾರ್ ಸ್ಟೇ provided the same conditions will be imposed.
ಅಲ್ಲ,
You are the owner of the vehicle.
ಅಲ್ಲ
isn't it?
ಸ್ವಾಮಿ, ಕ್ಲೇಮೆಂಟ್
Claimant.
ಹಾ.
All right. Learned counsel Shri Subhash Mallapur is requested to take notice for respond number 2. Issue notice to respond number 1.
R1 so
Learned counsel for the appellant is directed to serve copy of the appeal memo along with annexures on learned counsel for respond number 2.
actually
Same alla connected matter.
same.
Serial number 11, preliminary matters, Avinash A. Uplanka.
Agreed by the dismissal of the petition by the petitioner. This particular petition is preferred. The only legal aspect which is raised is after his retirement, after 4 years, the departmental inquiry is being initiated and a charge memo is issued, and it is against 214 subclause 2 of KCS. That is the only question that is. So they have not considered and dismissed my petition.
What is the finding of the tribunal on that aspect?
But tribunal says prior to the filing of this petition, I filed another petition which was disposed on merits. So I filed another petition seeking only a legal ground that under 214(2) the proceedings cannot be initiated.
Case 90, my lord, para 7.
Yes. Odre.
The learned counsel has further stated that notwithstanding the inquiry proceeding against him, the applicant cannot be subject to disciplinary proceeding since he is entitled to the benefit of Rule 214 2B of KCCR. We are afraid the applicant is stopped from contending so in these proceedings, and the decision of this tribunal in appeal number 20279 of 21 dated 2/7/21 binds him. By submitting these certain grounds have not been taken when it was available to him, the applicant cannot seek to overturn or indirectly seek a review the judgment already rendered. The applicant is deemed to have abandoned the ground and
Where is that order? Where is that order? Previous order?
But previous order, I have not annexed, but I have made a mention in my petition.
You mention madadalla. If you are raising a ground and this is the finding of the tribunal,
Yes.
should you not?
I make excuse. I will produce the call.
Learned AGA takes notice for both the respondents. Learned counsel for the petitioner is directed to serve copies of the petition along with annexures in the learned AGA. Full stop. Next para. Learned counsel for the petitioner is requested to furnish a copy of order passed by the Karnataka State Administrative Tribunal in application number 20279-281 of 2021, dated 2/7/2021. Full stop. Release this matter on 16th of December.
Serial number 12, Villappa.
I'm for appellant.
Yes.
Appellant is agreed by the order of learned single judge is before this honorable court. I request my lord to peruse page number 30, annexure A, where this appellant has been selected to the post of a physical teacher on part-time basis. My lord will find my name on the next page, that is 31. item number 13. Sarkari Buddhimandya Balakiyara Balamandira Kalaburagi. My name, my lord, Madevi Tande Vittal Rao, Dahika Yoga Sikshakar. After selecting me by seeing my performance,
For a period of 12 months only now.
1 year.
1 year. It is for a period of 1 year, ad hoc basis. By seeing my performance, authorities have continued my service next year also, without going for the process of notification, appointment. My lord will find annexure B, page number 32. ಈ ಮೇಲಿನ ವಿಷಯದನ್ವಯ ಅಧೀಕ್ಷಕರು ಸರ್ಕಾರಿ ಬುದ್ಧಿಮಾಂದ್ಯ ಬಾಲಕಿಯರ ಬಾಲಮಂದಿರ ಕಲಬುರಗಿರವರು ಬರೆದು ಅರಿಕೆ ಮಾಡಿಕೊಳ್ಳುವುದೇನೆಂದರೆ, ಶ್ರೀಮತಿ ಸೋನ್ಸೋ ದೈಹಿಕ ಯೋಗ ಶಿಕ್ಷಕರು ಸಂಸ್ಥೆಯಲ್ಲಿ ಮಕ್ಕಳಿಗೆ ದೈಹಿಕ ಯೋಗ ಚಟುವಟಿಕೆಗಳನ್ನು ಮಾಡಿಸುವುದು, ವೈಯಕ್ತಿಕ ಆರೋಗ್ಯದ ಬಗ್ಗೆ ತಿಳಿಸುವುದು, ಮಕ್ಕಳಲ್ಲಿ ಕೌಶಲ್ಯ ಬೆಳೆಸುವುದು ಹಾಗೂ ಆರೋಗ್ಯ ಮಟ್ಟ ಸುಧಾರಿಸುವಲ್ಲಿ ಯೋಗಾಸನ, ಏರೋಬಿಕ್ಸ್ ಕ್ಲಾಸ್ಗಳನ್ನು ನೋಡಿ ಅದರಂತೆ ಮಾಡಿಸುತ್ತಾ ಸಹಾಯ ಮಾಡುತ್ತಾರೆ. ಆದ ಕಾರಣ ಇವರ ಸೇವೆಯನ್ನು ಸಂಸ್ಥೆಯು ಪಡೆಯಲು 2021-22 ಸಾಲಿಗೆ ನವೀಕರಣ ಮಾಡಿ ಆದೇಶ ನೀಡಲು ವಿನಂತಿಸುತ್ತಾರೆ. Continued.
A request was made.
My services has been continued. Next year also. Followed by not next year C.
By which order?
Lord.
It was continued by which order? This was a requisition made. Annexure B, which you read out now,
Yes, yes.
is a requisition made.
Yes, requisition.
Which is the order passed.
Continued. My services have been continued.
By which order?
No order. And salary is also paid. Now, honorary was paid for these 2 years was 4,000 per month. As per annexure C, my lord will find page number 33, the honorarium is increased from 4,000 to 10,000. Notification is issued. As per this, my lord, I have applied to the post, annexure D, page number 34. Followed by that, I have been invited for the interview also, annexure E. In the selection list annexure F, my name does not find place. Lord, on inquiry, no response was received. I approached learned single edge. My lord will find annexure G, that is the experience certificate issued to me by the authorities. ಶ್ರೀಮತಿ ಸೋನ್ಸೋ ರವರು ಸರ್ಕಾರಿ ಬುದ್ಧಿಮಾಂದ್ಯ ಬಾಲಕಿಯರ ಬಾಲಮಂದಿರದಲ್ಲಿ ಅರೆಕಾಲಿಕ ಸಿಬ್ಬಂದಿಯಾಗಿ ಈ ಹಿಂದೆ ಕೆಲಸ ನಿರ್ವಹಿಸಿದ್ದಾರೆ ಎಂದು ಈ ಮೂಲಕ ಅನುಭವ ಪ್ರಮಾಣ ಪತ್ರವನ್ನು
Services you rendered where?
This is 4823 and its experience certificate.
No, where did you render this service?
My lord, in the children who are handicapped, Lord,
Where?
mentally, Gulbarga, mentally retarded.
ಎಲ್ಲಿ ಅಂತ? ಕಲಬುರಗಿ.
ಗುಲ್ಬರ್ಗ ಮೇಲೆ
ಕಲಬುರಗಿ ಎಲ್ಲಿ? Is it
ಆಳನ್
a-
ಕಾಲೋನಿ
Huh?
government mentally
Yes.
retarded children home for girls
Mentally retarded children.
in Cartwright respondent number 4 address. State home for women, Alan colony, Kalburgi.
ಎಲ್ಲಿ?
Cartwright of
Gulbarga.
page number 11, my lord. Respondent number 4 address, it is office address. Government mentally retarded children home for girls.
Who is this?
State- She is selected candidate. ma'am.
Mentally retarded children home.
Yes,
For girls.
Government home.
Yes,
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 my lord.
government owned. Government
Then
institution.
you did not approach the KAT?
No, this is not coming under that.
How?
It is, my lord,
Government department.
because our services were not covered by KCSR.
Huh?
Because of that,
The government
KT,
department.
government department,
Then
on ad hoc basis.
what is the law laid down in that regard? Even a person who makes an application for recruitment in respect of a government post or a post in the government department is required to approach the KAT.
So learned single did not get.
Allah.
I okay. If my lord, if that is the case, my lord may dispose of my writ appeal. With that observation, I will go to.
Why are you
Yes.
not raising this objection? Why did you not raise the objection before the learned single judge?
Yes,
Huh?
our colleague is
Who
not,
appeared?
Aarti Patil is appeared.
ಇವೆಲ್ಲ ಬೇಸಿಕ್ಸ್ ರೀ,
Yes,
ಇವೆಲ್ಲ
ma'am.
ಗೊತ್ತಿರಬೇಕು. The first thing that you'll have to see is whether a writ is maintainable. Alva,
On honorarium basis, we were appointed.
do you agree that this kind of a judgment is there? That even for a recruitment process, for a post in the government department, anything arises even out of the recruitment process, you are required to approach the KIT?
Because it
Is
was.
it correct or not? ಇಲ್ಲ ಅಂತಂದ್ರೆ we will adjourn the matter to get the judgment. If you agree, then you will have to go to the KIT.
I'll examine and make my submission.
When? Tomorrow?
Next week. Tomorrow, my
Tuesday.
lords, bench is not there tomorrow. Next week. Next week, any date.
We are sitting.
Friday. Tomorrow.
Tomorrow. At the request of learned counsel for the petitioner, release this matter tomorrow. ನೀವು ತಗೊಂಬನ್ರಿ.
Seal number 13, Nitesh Padiyal.
I appear for the complainant, my lords. The petitioner approached learned single judge for regularization of her service. She was working as watchman, my lords. In page 17 is the operative portion.
Contempt petition.
Please, my lords. Operative portion is that in page 17.
And in this matter, my lord, we received the GO, my lord, to prepare the appeal. In this matter, my lord, appeal is ready, my lord, that is not yet filed. In the meanwhile, you also may issue notice to them.
Learned government advocate takes notice for respondent number 4. Learned counsel for the petitioner is directed to serve copy of the petition along with annexures on the learned government advocate. Issue notice to response number 1 to 3, returnable by 8th of January 2025.
Oblige.
Yes.
Number 14, Nitesh Padiyal.
Appears for the complainant, my lords.
Yes.
The complainant approached was working as a peon under the respondents, my lords. He approached the honorable learned single for regularization of his service. In page 19 is operative portion. The respondent number 2 is directed to consider the letters of respondent number 2 and respondent number 2 on dated 12/6/2020 annexure C and pass appropriate orders in accordance to law within a period of 8 weeks.
Respondent number 3, government advocate. Issue notice to response number 1 and 2.
Please.
Seal number 15, Nitesh Padiyal.
Appear for the complainant minutes.
Yes.
In this matter, your lordship, last date, your lordship directed me to produce orders of learned single judge, division bench and Supreme Court minutes. I filed it on 9th December 2024. 19th November 2024 minutes.
19th November?
9th December 2024 minutes. In terms of
we wanted to see the
yes, my lords.
Order of the Supreme Court.
Yes, my lords. Order of Supreme Court and division bench order. All the 4 orders have produced minutes. Learned single judge order, division bench order, and Supreme Court order. Even I have filed the order of labor court minutes.
Which is the judgment of the division bench?
Division bench, my lords. Page 16, my lords, Annexure D. In page 16.
It commences from the order of the labor court, is it?
Yes, my lords.
Huh?
Labor court order is at in page 33.
Although you had earlier annexed
Yes, my lords.
33.
Yes, my lords.
ಇವಾಗ ಹೊಸದಾಗಿ ಹಾಕಿದೀರಾ?
Yes, my lords. Page number 33. Considering all these four judgments, honorable single judge has allowed my petition.
Then
Now, your lordship may kindly come to petition, my lords.
the KPTCL challenge that order passed by the labor court.
Yes, my lords.
Which is that order?
My lord, in page 18.
18 of the writ petition of the
contempt petition.
18.
Yes, my lords. Operative portion is at 18. It commences from page number 11, my lords.
Oh, that is what I just read now.
Yes, my lords. Impugned order shall be implemented within a period of 2 months from date of receipt of this order, copy of this order. Para 9, lordship have referred to single judge order, my lord, 101460 that have filed, my lords. May I read para 9, my lords?
Issue notice to the respondents. Returnable by 8th of January 2025.
Oblige.
Yes.
Seal number 16, Annaraya M. Patil.
My lord, I am the complainant here. My lord, I was appointed as a deputy project director in an agriculture scheme from 1st of April to 23 to 31st of March 24. My appointment was terminated 2 months prior to the.
Have you sought for leave to appear as party in person? Then? Why, see, you take things for granted like this. You did not argue the matter before the learned single judge. There was an advocate who argued the matter.
Our advocate asked me to present the case.
Huh?
Nare Patil.
Huh?
He asked me to make submission.
Allah, but
I am the
your name is
complainant.
shown.
I am the complainant. I am the complainant. Our advocate asked me to make submission.
Annarai Patil and Jad.
Yes, sir.
ನೀವೇ ತಾನೆ Annara Patil.
No, I am not. I am the complainant.
Who is this Annarayam Patil?
Annarai Patil yaar?
Our advocate. He is good.
Yenri, who is this Annarayam Patil?
Okay.
Advocate?
Yes, sir, advocate.
Advocate? Then why are you appearing?
No, he asked me to make submissions.
Yenanta?
He was quite busy in other cases.
Huh? Heng madak barutte? If you are requesting for some adjournment or something, we can understand. We can't hear you on this matter when the advocate is there on record. You want an adjournment?
Sorry, sir. No, I am doing, but he asked me to make
Madak
submission.
baradilla.
Okay, sir. Please kindly.
Yes.
Make-
At the request of the complainant, since it is submitted, the learned counsel on record is unable to attend to the proceedings today, release this matter on 18th of December.
Oh, please.
Yes.
Seal number 17, Mahesh Patil.
Lordship, my lord, had heard this matter, my lord, for some while, my lord, the last occasion. My lord, it's a case, my lord, where I had challenged, my lord, the order of the KT, my lord, wherein, my lord, I was, my lord, the punishment of compulsory retirement from service has been imposed on.
Yes.
Now, my lord, it's been only, my lord, 2 years of service, my lord, have been left.
Huh?
When, my lord, 2 years of service were left, my lord, then this punishment was issued.
My
lord, the charges, my lord, in the inquiry.
So
Where
now
that-
is attained the age of superannuation,
No, my lord. No, my lord.
still in service.
No, my lord. There was an interim order, my lord, before the tribunal. My lord, before, my lord, that could take effect, my lord, I was relieved. And, my lord, thereafter, my lord, now I am, my lord, out of service. And thereafter, my petition application was dismissed.
Already, you have attained the age of superannuation.
No, not yet.
Huh?
Not yet. Not yet.
You just now said this order was passed when only 2 years were left.
2.5, my lord, now 17 months.
You know? Huh?
ಇನ್ನು 17 ತಿಂಗಳಿದೆ.
Adengri. Anyway,
Yes.
he is still in service. He's not attained the age
Not attain the age of superannuation. Yes.
Really?
Now, my lord, the allegation against the, my lord, the petitioner was that, my lord, that, my lord, his, my lord, father, my lord, had died, my lord, while in service, my lord, as a bullock man. And, my lord,
Compassionate grounds, he was
on
appointed.
compensate ground, he was appointed.
Aye.
And thereafter, my lord,
Appointed as?
appointed as, my lord, the second divisional assistant.
Huh?
Second divisional assistant. And, my lord, now, my lord, an allegation was made, my lord, by, my lord, a person, my lord, who had vested interest against me, my lord, for some other reason, my lord, he had filed some criminal case that ended in B report. And therefore, my lord, he came to, my lord, he filed this, my lord, complaint before the Honorable Lokayukta. And, my lord, on 2 counts of charges that, my lord, that I have asked, my lord, the disproportionate, my lord, assets. And, my lord, that, my lord, I had, my lord, obtained false information, my lord, with regard to, my lord, my father. And thereafter that, my lord, falsely, my lord, that I have obtained this employment. These were the 2 charges. In the departmental inquiry, my lord, the inquiry officer proceeded to hold, my lord, that the other charge of, my lord, of amassing wealth of, my lord, disproportionate, it was, my lord, not proved. Insofar as, my lord, this charge, my lord, it was proved. And, my lord, now,
What exactly was the allegation in that regard?
Please.
What exactly was the allegation in that regard?
Exactly, the allegation, my lord, was that, my lord, my father's name, my lord, is Ramchandra. My lord, he was also called, my lord, as Ramchandra alias Enkappa. My lord, he was called, my lord, Enkappa, my lord, for the reason, my lord, that has come on, my lord, because, my lord.
This matter had come up.
Yes, yes,
here, huh?
yes, yes.
Why it was adjourned?
My lord, ಒಂದು date ಅಂತ ಕೇಳಿದ್ರಿ.
Huh? Why it was adjourned?
One date fixed.
the ಇನ್ನೊಂದ್ಸತಿ ಕೇಳಿ for he the next time ಮಾಡೋಣ.
ಹೇಳಿ.
My lord, my father, my lord, name is Ramachandra. And he was also called as Enkappa for the reason, my lord, that he was, and my lord, he was a believer of my lord Venkatramana. So my lord, ಊರಲ್ಲಿ Enkappa ಅಂತ ಕರೀತಾರೆ. That was the reason. And my lord, what had happened, my lord, he filed a complaint, my lord, saying as to my lord, I was appointed, my lord, as early as my lord 1984. And my lord, ನಾನು.
You were appointed in 1984.
Yes, my lord. And my lord, my father, my lord, had lordship may kindly see these documents for page 257. Page 257. 257, my lord, is the death certificate. On 1971, my lord, this death certificate was issued. That is Ramchandra alias Enkappa.
ಅಲ್ಲಿ ಏನೋ ಇಂಟರ್ಪೋಲೇಷನ್ ಇದೆ ಎಲ್ಲ ಕಡೆ.
ಇಲ್ಲ, ಅದು ಇದರಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ. Next, lordship may kindly see, my lord, the next 259. This is the surveyor certificate. ಅದರಲ್ಲಿ ಅಲಿಯಾಸ್ ಅಂತ ಇದೆ. It is page 259. ಪ್ರಕಾರ ಶ್ರೀ ದಿವಂಗತ ರಾಮಚಂದ್ರ ಅಲಿಯಾಸ್ ಎಂಕಪ್ಪ ಸಾಕಿನ್ ಅಂತ ಸೋ ಇದೆ. Both certificates, my lord, were issued, my lord, at the same time. Now, my lord, here, my lord, the lordship may kindly see page 261. Page 261, my lord, surviving family members. Wherein, my lord, my mother's name, my lord, it's at serial number 1. Buddhamma. My name, my lord, out of 5 children, my lord, my name, my lord, at 5th serial number, I'm the 4th son. Paguntappa. This is my lord, the surviving certificate. My lord, and my lord, when this employment was given to me, my lord, under compensate grounds, even at that point of time, my lord, I was asked to give an undertaking that, my lord, Ramchandra and Enkappa are the same persons. And my lord, I had, my lord, given the undertaking, my lord, even my family members also. My lord, only thereafter, my lord, this, my lord, employment was given to me. Now, my lord, lordship may kindly see this, my lord, the undertaking as well.
Now they have placed on record certain other documents.
No, there is, my lord, there is not even a single document. There is not even a single witness. Only based on suspicion, my lord. Now, though this order has been, my lord, passed. Only based on suspicion.
Is it correct?
No.
What are the other documents that have been placed on record?
My lord, they have inquired in villages, my lord. Kindly see page 189, my lord. They have gone village and they have taken statements of villagers, my lord. Kindly see page 192, relevant, my lord. This is statement of Bhimappa. Bhimappa ತಂದೆ ಅಮ್ಮಪ್ಪ ವಯಸ್ಸು 60 ವರ್ಷ. ಈತನ ಹೇಳಿಕೆ ಅಂತೆ ವೆಂಕಪ್ಪನಿಗೆ ರಾಮಚಂದ್ರವೆಂದು ಕರೆಯೋದು ನನಗೆ ಗೊತ್ತಿಲ್ಲವೆಂದು ಪಾಗುಂಟಪ್ಪ ವೆಂಕಪ್ಪ ಮಗನೆಂದು ಅರ್ಜಿ 192 ಮೇಲು ಫಸ್ಟ್ ಪ್ಯಾರ ಮೇಲು
ಈ ಎಲ್ಲಾ ಹೇಳಿಕೆಗಳನ್ನು
190 ಅಂದ್ರೆ 192 ನಮ್ಮ ಹತ್ರ 192 ಇದೆ
ಶ್ರೀ ಭೀಮಪ್ಪ ಅಂತ
ಎಸ್ ಮೇಲು
ಅದಾ?
ಶ್ರೀ ಭೀಮಪ್ಪ ತಂದೆ ಹನುಮಂತಪ್ಪ ವಯಸ್ಸು 60 ವರ್ಷ. ಈತನ ಹೇಳಿಕೆ ಅಂತೆ ವೆಂಕಪ್ಪನಿಗೆ ರಾಮಚಂದ್ರವೆಂದು ಕರೆಯೋದು ನನಗೆ ಗೊತ್ತಿಲ್ಲವೆಂದು ಪಾಗುಂಟಪ್ಪ ವೆಂಕಪ್ಪ ಮಗನೆಂದು ಅರ್ಜಿ ಕೊಟ್ಟಿದ್ದು ತನಗೆ ಸಂಬಂಧಿಸಿಲ್ಲದೊಂದು ಹೇಳಿಕೊಟ್ಟಿದ್ದಾನೆ. ಇದಲ್ಲದೆ ಗ್ರಾಮದಲ್ಲಿರೋ ಹಿರಿಯ ಕೆಲವರನ್ನು ವಿಚಾರಿಸಲಿಕ್ಕೆ ಕರೆಸಿದಾಗ ಬಹಳ ಜನ ಬರಲು ನಿರಾಕರಿಸಿದ ಕಾರಣ ಸದ್ಯ ಮಂಡಳ ಸದಸ್ಯರೆಂದು ಕರೆಸಿ
ಅದಲ್ರಿ
ಸ್ಟೇಟ್ಮೆಂಟ್ಸ್ ಇದೆ ಮೇಲೆ.
His name was shown as Ramchandrappa.
Yes, ma'am.
In the service records.
Yes,
In service records, only Ramchandrappa.
Ramchandra is mentioned.
What was the name of the wife?
Buddhamma. Buddhamma.
ಮತ್ತೆ ಇನ್ನೇನ್, what is the difficulty?
My lord.
I'm trying to say now.
My lord, Enkappa is father name, petitioner father name is Enkappa, my lord. There is no alias, Ramchandra alias Enkappa. Kindly see death certificate.
Bodamma anbuttu that Ramchandrappa's wife's
What,
name is
my lord?
Bodamma.
Community also different, my lord.
Huh?
He is a petitioner.
He claim from some other person saying.
No, my lord. They have no children. Antidama.
Huh?
They have no.
They have no children.
Original Ramchandrappa had no issues.
But what happened to that wife? Who is taking the pension now?
Buddhamma.
But
Who is that Buddhamma?
is the wife of
What is this? Unnecessary problems you are trying to create just because some person comes and makes a statement.
my lord. Death certificate, all kindly see, it has altered, my lord.
What is this? Which is the impugned order?
My lord, impugned order, my lord.
ನೀವು ಆ ಅಮ್ಮನಿಗೆ ಪೆನ್ಷನ್ ಕೊಡ್ತಾ ಇದ್ದೀರಾ, ಬಟ್ ಯು ವಾಂಟ್ ಟು ಡಿನೈ ದಟ್ ದೀಸ್ ಆರ್ ನಾಟ್ ದಿ ಚಿಲ್ಡ್ರನ್ ಆಫ್ ರಾಮಚಂದ್ರ. ವಾಟ್ ಇಸ್ ದ ಮೀನಿಂಗ್? ಹ್ಯಾಸ್ ಶಿ ಗಿವನ್ ಎ ಸ್ಟೇಟ್ಮೆಂಟ್ ದಟ್ ದೀಸ್ ಆರ್ ನಾಟ್ ಮೈ ಚಿಲ್ಡ್ರನ್? Then
ನಿಮ್ ಪ್ರಕಾರ ಅವ್ರ ತಾಯಿ ಯಾರು?
ಬೋಡಮ್ಮನೆ.
Ramchandra Mrs. Bodamma.
ತಾಯಿ ಹೆಸರು ಹೇಳ್ರಿ ಯಾರು? Who is the mother of this
ಬೋಡಮ್ಮನೆ.
employee?
Then you are giving her pension,
Yes, my lord.
but you want to deny that these are the children of Bodamma.
Page 248, page 248.
248. ಅಲ್ಲ ಇದು KAT ಆರ್ಡರ್ ಅಲ್ಲಿ ಇದೆ ರೀ.
KAT order, my lord, at
300.
300.
297. 296 start.
Tolling discuss, madam.
Compulsory. ಈಗ illegal ಆಗಿ
ಖಂಡಿತ.
Page number 19 is.
Not case for ಹೌದು.
Page number 19 ಲಿಂದ discuss ಮಾಡಿದ್ದಾರೆ.
Page number
19 of the
paragraph ಹೇಳಿ.
paragraph 12
Paragraph
12 my lords.
12.
Yes, my lord. From again the next page ಅಲ್ಲಿ ಕೊಡಿ. Second ground ಅಂತ ಹೇಳಿ ಅದನ್ನ discuss ಮಾಡ್ಕೊತೀವಿ.
Application was filed in the year 2023.
Yes, ma'am.
Huh?
Yes, ma'am.
Disposed of on
Disposed of, my lord, on 20th April
24.
24.
You had benefit of interim stay.
Yes, my lord, interim
before
order
the
was there,
tribunal.
but my lord, that was not, my lord, page 249. Since it was only an order of, my lord, the status quo, by that time, my lord, I was, my lord, relieved. It was, my lord, I didn't have the benefit of this interim order.
Huh?
Page 250.
250.
Since it was an order of status quo,
So as on today, on the impugned order dated 28/6/2020 till appearance of the respondents.
my lord, since, my lord, by that time I was relieved, my lord, I didn't have the benefit of this interim order.
And you did not seek for further clarification.
My lord, the court, my lord, expressed, my lord, that the matter would be taken once for all, my lord, for, my lord, the hearing.
ಅದಿಲ್ಲ ಪ್ರೂವ್ ಆಗಿಲ್ಲ.
ಅದು prove ಆಗಿಲ್ಲ. Not prove. And my lord, here, my lord, the Lokaयुಕ್ತ, my lord, is not empowered to, my lord, conduct inquiries, my lord, in respect of an event, my lord, which took, my lord, half a century ago. Because, my lord,
No. That you cannot call for this one. An employment that is secured on false documents, he goes to the root of the matter. He will not be permitted to sit in that seat even for 1 second. That is the judgment of the Supreme Court. You cannot call this under that rule. ಹಂಗ್ ಮಾಡಕ್ ಬರೋದಿಲ್ಲ.
my lord, my lord, if it,
Employment has been secured by playing fraud.
yes, ma'am.
It cannot be contended that I have been working for so many years and therefore don't remove. That on that ground, it cannot be
My
considered.
lord, in my case, my lord, all the revenue certificates are intact. My lord,
I
since from
We are
1970.
accepting your other submission. Why do you want to make
Please,
this,
please.
this submission now?
Please, please,
You please do not make that submission. That will be incorrect.
please.
Fraud will vitiate everything. So if you are gained employment on the basis of fraudulent records, at any time you can be removed. That is the judgment of the Supreme Court. And even on the judgment of that Managing Director, Food Corporation of India,
Please.
where employments were secured on the basis of false caste certificate. This is the statement that is made by the Supreme Court. We cannot tolerate such person sitting in the post even for 1 second. Anytime they can be removed. Yes. Berkeley. Notice, ಆಗಿದೆಯಲ್ಲ notice
ಆಗಿದೆ.
order.
ಆಗಿದೆ
ಆಗಿದೆ.
It's coming up for admission.
No, no, notice is ordered.
Huh?
ಆಗಿದೆ. Preliminary.
Preliminary hearing, it's coming up for preliminary hearing.
Yes, ma'am.
You have an interim prayer.
Yes, my lord. No, I didn't, my lord, here. I didn't seek for,
ಮತ್ತೆ ಏನ್ ಮಾಡೋದು? We'll have to dispose it off finally.
please. It may be disposed,
There's no interim prayer.
no interim prayer.
ಮತ್ತೆ
Kindly, my lord, maybe.
issue rule. The respondents are permitted to file statement of objections within a period of 2 weeks from today. Not.
Order C number 18, Chidege Kailasi.
My lord. JDK Kailash is, he has admitted to hospital, he is suffering from liver. He has operated, my lord. Doctor advised him.
At the request of learned counsel for the appellant, release this matter after winter vacation.
C number 19. Mahesh Patil. C number 19, Mahesh Patil.
Sir, in this case, the respondent number 1 is retired.
My lord, there is, my lord, the
Respondent 1 is retired.
page.
This accused number 1 is retired from service. Commissioner,
Commissioner.
yes, Dayanand Patil is retired from the service, your lordship. Now, some time may be granted, your lordship. There was appeal was filed against the
2023 is the order passed.
yes,
ಏನಂತ?
My lord, page, that, my lord, in terms of the, my lord, earlier orders of.
You involved in these petitions is squarely covered by order dated so and so, 2013.
Yes, ma'am.
Passed in petition number so and so on the said order of the learned single judge is confirmed by the division bench. Learned counsels for the respondents have no objection.
in this case, your lordship,
What is this?
allotment of site.
My lord, allotment of, my lord, sites, my lord. My lord, this honorable court, my lord, relying, my lord, on the earlier editions, my lord, in writ appeal. My lord, disposed of, my lord, by, my lord, asking the, my lord, the complaint herein, my lord, to, my lord.
Allotment was cancelled, huh?
Yes, my lord. Now, my
Allotment
lord,
was cancelled.
thereafter, my lord, in terms of the order of this honorable court, we have even cost, my lord, has been deposited, my lord, page 19. Now, my lord, they need
One
to,
nimsha. Please come to page number 16. The order of the learned single judge at that point of time, that 2013. Annexure B,
please,
page number 16.
please.
Writ petition is allowed. Impugned order at annexure so and so dated 12/10/2011 issued by the respondent cancelling the allotment of site stands quashed. This order would be subject to petitioner depositing costs of rupees 1 lakh with the respondent authority within 8 weeks.
Yes,
It is made clear that if the cost is not deposited, when was your allotment cancelled?
my lord, my allotment, 21/9/2021.
How can you take advantage of this 21?
21/9/2021.
It was cancelled only in 2021.
21. And my lord, in terms of my lord, the earlier order, my lord, I have deposited the cost, which is at page, my lord, 20. 19 and 20. Now only they need to, my lord, execute the, my lord, the sale deed.
Did you appear before the learned single judge?
Myself,
Yes,
Kalaburagi Urban Development Authority, na?
yes, yours. What
You
happened?
appeared before the learned single judge?
It is appeared, your lordship. What happened? Appeal was filed. 4 matters were there. Appeal was filed. In one appeal is remanded. Another 4 matters are pending. So we requested to withdraw that appeal. After withdrawing that, they will not execute their sale deed, your lordship. It is the clarity.
my lord, what had happened, my lord? There were several matters, my lord, of allotment and auction. My lord, in all other, my lord, allotment matters, my lord, they have complied. And some of them, my lord, they had taken, my lord, for this, my lord, division bench, my lord. And my lord, there were several orders, my lord, that, my lord, the sale deed, my lord, they need to execute. And my lord, even the cost has to be paid. Accordingly, my lord, in all those matters, my lord, cost has been paid, my lord, they have executed the sale deed also. In one order,
What was the ground for cancellation?
my lord, the ground for cancellation, my lord,
That
was
you did not pay the amount within time.
in some of those, my lord, yes, my lord, the amount, my lord, within time it was not paid. My lord, relying on various, my lord, earlier decisions, my lord, it was, my lord, held. My lord, that, my lord, even there is, my lord, the lacuna on the part of the, my lord, the urban my lord, authority themselves also, that in order to make, my lord, good, my lord, that it was directed, my lord, in terms of the earlier order to pay costs. In all such matters, my lord, costs were paid, my lord, and they were complied also. In one of this matter, my lord, still, my lord, they have not, my lord, complied.
That appeal,
And the one such matter, my lord, even it had come before the Honorable Chief Justice, my lord, and even division bench, my lord, even that was also, my lord, complied.
issue is not that, your lordship. We are filed appeal.
You
Authority have filed appeal
ಯಾವ್ದ್ರಲ್ಲಿ?
in this matter
ಈ
also.
matter ಅಲ್ಲಿ?
Yes.
Writ appeal file
Yes, writ
ಮಾಡಿದ್ರಾ?
appeal file ಮಾಡಿದ್ದಾರೆ. The connected matters were there. I will give that number also. So now authority is withdrawing all those appeals. And after that, we'll execute that sale deed in favor of the complainant.
ಆಯ್ತ್ರಿ, please let us tell
I
us
will-
which is the writ appeal
I
number.
will
So that
forward.
at least we can note that.
I will forward.
Learned counsel,
I will forward.
it's coming up for admission, is it?
No, your lordship.
Notice
ಆಗಿದೆಯಾ?
ಅದರಲ್ಲಿ that are accused number 1 is retired from the service, your lordship.
Learned counsel Shri
Anant Jagirdar.
Anand Jagirdar
Yes, yes.
undertakes to appear for
Once-
respondent number 1.
Yes, he's retired from the service. Now the present commissioner I am appearing.
Full stop. However, learned counsel submits that Shri Dayanand Patil, who is shown as respondent number 1, commissioner of Kalaburagi Urban Development Authority, has retired from service. Full stop. Therefore, learned counsel would submit that the petitioner may be directed to show the name of the incumbent commissioner. Yaru?
I will give it.
So and so
God.
as respondent number 1. Full stop. Next para. Accordingly, learned counsel for petitioner is permitted to amend the cost title showing the name of so and so as the commissioner, Kalaburagi Urban Development Authority. Full stop. Next para. Learned counsel for respondent number 1 would further submit that a writ appeal has been preferred in this matter in WA number so and so so and so. Full stop. Next para. Release this matter along with writ appeal number so and so on 18th of December. In the meanwhile, whatever instructions you want to take, you please take and make submission.
We are withdrawing that appeal now.
Madi,
But-
in the meanwhile, if you want to withdraw, you please withdraw.
Yes, yes.
And then place that information before the court.
Much.
And what you propose to do also you should say.
Much.
After withdrawing the writ appeal, what do you want to say? What
We'll
do you'll have to
Execute the sale.
either by filing an affidavit, you'll have to say so,
Yes,
or orally on instructions, you can say so.
much.
Yes.
Seal number 20, Deepak.
ಇದು notice order ಆಗಿತ್ತಾ ಮುಂಚೆನೆ? Yes.
Seal number 20, Deepak Vibara.
Lord, in this matter, my lord, we comply the order of your lordship, my lord. We filed the, my lord, SAP before the Apex Court, my lord, that is dismissed and confirm the order of your lordship, my lord. Thereafter, immediately, my lord, we comply the direction of your lordship and also, my lord, pass the order. I filed the appeal also, my update of the officer also, my lord, additional commissioners affidavit. Last occasion, my learned friend has taken the time, my lord, to verify this.
2/10/2024.
Yes, my lord.
SLP has been filed.
Yes, but that was dismissed, my lord.
Dismissed, huh?
Yes, my lord. I also produced the annexure R2, my lord. That is. We also complied the direction of the lordships also, my lord. We paid the, my lord, all the benefits, my lord, to him, and only pension, my lord, that has we have to send the all records, my lord, we'll get the benefit to him also.
Pass over. Pass over.
Seal number 21, Arun Kumar Amar Gundappa.
Shivakumar Tengle will undertake to file.
Huh?
Shivakumar Tengle will undertake to file wakalat for respond number, accused number.
1.
Yes.
Commissioner.
Yes.
ಇವ್ರೇನ್ರಿ ಇವಾಗ ಇನ್ಕಂಬೆಂಟ್ ಕಮಿಷನರ್ GS ಮಾಳ್ಗಿ.
Yes.
ಹಾ?
Yes.
ಇದೇ ತೋರಿಸ್ಬೇಕಾಗಿರೋದನ್ನ ಇದ್ರಲ್ಲಿ ಪ್ರೀವಿಯಸ್ ಮ್ಯಾಟ್ರಿ. ಹಾ? GS ಮಾಳ್ಗಿ.
Yes, Maligi sir.
ಪ್ರೀವಿಯಸ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ
Yes, Maligi. So, R1 ಗೆ notice ಕೊಟ್ಟಿದ್ರು sir.
ಅದೇ ತಾನೆ ಇವ್ರೇ GS ಮಾಳ್ಗಿ. Learned Counsel Sri Subhash Mallapur undertakes to appear for respondent number 1.
Shivakumar Tengle. Shivakumar Tengle.
Shivkumar Tengli.
Yes.
Learned Counsel Sri Shivkumar Tengli undertakes to appear for respondent number 1.
Yes.
A week's time is granted to file wakalat.
Wakalat as well as the reply statement.
Huh?
We will file reply statement within a week.
Full stop. 2 weeks are granted at the request of learned counsel for respondent number 1 to file
Reply statement.
reply statement. Yes.
Seal number 22. Sharana S. Saradagi.
Appear for the rest number 2, my lord. They filed the memo for withdrawal.
Memo for withdrawal, your order has been complied, your lordships. I filed a memo for withdrawal, your lordship. Order has been complied.
Complaints ಆಗಿದೆ.
Yes.
The complainant and learned counsel for the complainant have filed a memo dated 9/12/2024 stating that pursuant to the order passed by the learned single judge, the respondent has considered the application for mutation and the entry of the name of the petitioner in the land records, huh?
Yes, your
Land records.
land records.
and therefore the petitioner does not press the contempt petition. We'll stop. Next paragraph. Accordingly, the contempt petition stands disposed of.
Lord,
Yes.
for R1, my lord, I will take notice, my lord. It's served, my lord, R1.
Huh?
R1, my lord, served, my lord, I will take notice for R1.
For R1 now.
Please, my lord, we pass the order, my lord, affecting the entry, my lord, that is.
Learned government advocate takes notice for respond number 1.
Please.
Starting. Yes.
Seal number 23, Harshvardhan or Mandit Patel.
Lord, in this matter, my lord, I'll take notice for respondent 1 and 2, my lord. Now, my lord, I received all the documents from the BEO, my lord. Lots of payment on Monday or Tuesday, my lord, we'll file the, my lord, order of the DDPI.
At the request of learned government advocate, release this matter on 17th of December.
Grateful.
Seal number 24, Mahesh Patel.
My lord. My lord, I had challenged, my lord, the order of the learned single judge, my lord. Is that
No interim prayer.
yes, my lord. I have sought for interim prayer,
Really there.
my lord.
ಅಲ್ಲ ಅಲ್ಲಿ ಕೇಳಿದ್ದಾರೆ ಇಲ್ಲಿ
Yes, my lord.
ಯಾಕೆ ಹಿಂಗ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
Inadvertently, my lord.
ಎಲ್ಲ ಸ್ವಲ್ಪ ಹುಷಾರಾಗಿರ್ಬೇಕಪ್ಪ. Learned government advocate ಇದೆಯಾ?
It is, my lord, writ appeal, my lord.
ಹಾಕಿದಿರಂತಲ್ಲ IA for stay.
Writ appeal. I'm sorry, my lord. Page 86.
Yes.
My lord, here, my lord, the appellant, my lord, he was appointed, my lord, by an, my lord, outsourcing agency. My lord is working as master assistant.
Which is the order impugned annexure C na?
Yes, my lord.
Huh?
Yes, my lord.
Is the order of the learned single judge?
Yes, my lord. Page 9. Page 9.
Annexure C.
No, my lord. Not C, my lord. Page annexure A.
Annexure A.
Page 9.
Already, which is the order of the learned single?
Page 9, my lord. Page 9.
Page 9.
24, 11, 24.
Yes.
Yes, my lord.
Yes.
My lord, here, my lord, the appellant, my lord, is admittedly working, my lord, on a temporary basis, my lord, and he was hired, my lord, for on outsourcing agency. My lord, he is working, my lord, since more than, my lord, since from the last.
Outsourced through agency.
Yes, my lord. And my lord, now, my lord, his, my lord, services, my lord, have been terminated, my lord, on misconduct, my lord, on a stigmatic order. No, my lord, I had challenged, my lord, before the learned single judge, my lord, on the ground, my lord, that, my lord, even, my lord, though I am a temporary employee, even, my lord,
outsourced basis ಅಂದ್ರೆ ಅರ್ಥ ಏನು?
ಅಂದ್ರೆ ಒಬ್ರು
he is sent by some agency.
Yes, my lord.
He cannot become an employee of
admittedly,
this
yes.
panchayat.
Yes, my lord. I'm not seeking that at all, my lord. Here, my lord, I'm not seeking, my lord, any continuation, regularization of, my lord, employment. My lord, but when an order is issued, my lord, when a simple order is issued, my lord, by, my lord, casting a stigma on me, saying as to, my lord, I'm not.
There was no need at all.
My lord,
there was no need at all.
My lord, because.
Why should they can simply tell you, please don't come for employment from tomorrow.
My lord,
you are not an employee of the panchayat.
I admit.
You are there working as a through an outsourced agency.
Yes, my lord. I do agree, my lord. But when it is on misconduct, my lord.
Where is the question of misconduct, sir?
Because, my lord, they cast, my lord, they allege something against me, my lord. By, my lord, lordship may kindly see the, my lord, the termination order.
Is that the ground on which the petition has been dismissed?
My lord, it
that
was.
So then we will not interfere.
My lord,
the argument advanced by the learned counsel for the petitioners that their long tenure of service exceeding 10 years should protect them from the impugned recommendations is found to be untenable. The contention that the recommendation to remove the petitioners as conveyed through the impugned communication at annexure B is stigmatic and invalid for want of prior inquiry is misplaced. It is evident from the records that the petitioners were neither appointed by the respondent authorities nor by the local body in any official capacity, whether temporary or permanent. On the contrary, their engagement is purely through an outsourced. Correct. Perfectly in order.
My lord, my lord, submission, my lord, would be, my lord.
Yes.
My lord, my lord, here I'm not seeking of any, my lord, continuation, my lord, by virtue of those contract and all. And my lord, here, my lord, since it is based on misconduct, my lord, even my lord, though I am, my lord, hired by, my lord, the outsourcing agency, my lord, when they, my lord, allege something against me, my lord, and now, my lord, I am terminated, my lord, it, my lord, affects my future employment. My lord, when it affects my lord, I am entitled, though, my lord, I am not their employee, I am entitled actually at least for a notice.
Any judgment? Any decided case?
I have, my lord, my lord, produced, my lord, along, even before the learned single judge, my lord, which are at page 32, annexure C, and, my lord, another page, annexure D also.
This is of a learned single judge.
The learned single judge, which was produced before the learned single judge.
ಇರ್ಬೋದು. ಈಗ ನಮ್ಮ ಮುಂದೆ ಸೈಟ್ ಮಾಡುವಾಗ
Yes.
what is it that you have to cite? Anyway, we'll see.
Page,
If that judgment is supported by some judgment of the Supreme Court,
yes,
we
my
will
lord.
see.
Yes. My lord, page 63.
63.
63. My lord, my lord, page 61, may kindly, para 13.
Hmm?
My lord, page
Yes.
61, para 13.
Yes.
The petitioner was appointed as accountant in the year 2008.
Adhe, see, these are all temporary basis, sir.
Yes, my lord.
You cannot, you will not fit into this category at all.
My lord, they may be, my lord, working as temporary employee, my lord, before.
No, not a temporary employee. You cannot use the word. You are not a temporary employee. You are not an employee of the panchayat at all. You are working there on outsourced basis.
Yes, my lord.
You are sent by some agency.
Yes, my lord.
You have no direct connection with the panchayat.
My lord, I do admit that, my lord, but once, my lord, they, my lord, terminate me.
No doubt, even if you are a temporary employee, you are required to, the employee is required to follow this. If by order of a stigma, you are sought to be removed.
Yes, my lord, stigma, my lord, they.
Will not apply to a person who is not an employee of the employer at all.
But my lord, it will affect my future employment, my lord, where that cast a stigma on
Asking
me.
you, is there any judgment? You please show.
My lord, now, as of before the learner single,
Not
I have
apply to
produced,
you.
my lord, these two
This
judgments.
will not apply to you.
I will, my lord,
You are not a temporary employee.
yes, a short accommodation, my lord, even I will.
No, that is only for the purpose of, that cannot be applied here in service jurisdiction. That cannot be applied.
A short accommodation, my lord, I will.
Learned government advocate takes notice for respondent number 1. One and 2. Learned counsel Shri Amar Kumar Amargundappa is requested to take notice for response number 3 and 4. Learned counsel for the appellant is directed to serve copies of the appeal memo along with annexures on the learned counsels for the respondents.
Lord, there is,
Release this matter on 18th of December.
Lord, there is an office objection, my lord.
In the meanwhile,
Counsel.
office objection should be compared with.
My lord, here, serial number 10, my lord.
42. Yenadu?
My lord, serial number 10, my lord, there were two, my lord, parties, my lord, before the learner single judge, my lord. In the petition.
Office objections at serial number 10, 23, 42. More ಇದೆ.
More ಇದೆ.
Yes.
ಅದರಲ್ಲಿ 10 ಅಲ್ಲಿ ಮಲೋಡ್ he did not choose to ಮಲೋಡ್
ಕೋರ್ಟ್ ಫೀ ಕೊಟ್ಟಿಲ್ವಾ?
100 ಇಬ್ರು ಅದರಲ್ಲಿ ಇಬ್ರು ಇದ್ದಾರೆ, ಇದರ ಒಬ್ಬರೇ ಇದ್ದಾರೆ, ಅದಕ್ಕೆ 100 ಪೇ ಮಾಡಿದ್ವಿ.
ಹ್ಮ್?
ಮಲೋಡ್ earlier ಮಲೋಡ್ there were 2 ಮಲೋಡ್ petitioners before the ಮಲೋಡ್ now ಮಲೋಡ್ only one
ಇದ್ದಾರೆ.
ಒಬ್ಬರೇ ಇದ್ದಾರೆ.
ಹಾ.
And hence ಮಲೋಡ್ 100 ಕಟ್ಟಿ. And serial number 42 ಮಲೋಡ್ no statement of objections were filed before the ಮಲೋಡ್ in writ petition.
That is regarding court fee ಆಯ್ತು. ಆಮೇಲೆ
ಮಲೋಡ್ 40 ಮಲೋಡ್ the
ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 1 to 4 statement of objections were not filed
were
before.
not filed, were not filed before. Hence not
ಆಮೇಲೆ?
produced. Hence not produced.
Serial number 42 ಏನು?
ಅದೇ 42 is ಮಲೋಡ್ statement of objections.
42 court fee. ಹಾ. One not made party. Statement of yes, so. There are 3 office objections. Full stop. Learned counsel for the appellant submits that since petitioner number 1 in the writ petition has not joined the appellant in this appeal, court fee is paid only insofar as the appellant is concerned. Full stop. This would meet both the objections at serial number 23 and 42. Full stop. Similarly, it is submitted that statement of objections were not filed before the learned single judge, and therefore question of furnishing copy of the statement of objections would not arise. Full stop. Next para. The submission of the learned counsel for the appellant is accepted. Full stop. Office objections are overruled. Yes. ಅದಾದ್ಮೇಲೆ ಹಿಂಗ್ ಮಾಡಿ list is matter on 13. Yes. 18th.
Seal number 25, Sachin M. Mahajan.
As per instruction from the ADG, it is not possible. Why it is not possible? I file the memo.
Pass over.
Kindly pass over. 230 months.
Your Lordship, may I have it tomorrow, my lords?
You want
Let
it
them-
tomorrow?
Yeah, let them file whatever they want to file, my lord. Let them serve a copy kindly.
Learned Deputy Solicitor General of India submits that he has instructions from the respondents
Please.
stating as to why the request made by the petitioner cannot be considered. Full stop. Next para. The request of the learned senior counsel appearing for the petitioner release this matter tomorrow.
No, let them serve a copy on us so that we can reply tomorrow, my lords.
ಅಲ್ಲ,
No,
ಆಯ್ತು.
I-
ಇವಾಗ ಏನಾದ್ರು ಸಿಕ್ಕಿದ್ರೆ ನಿಮ್ಗೆ you please
Please.
state, sir.
please.
Seal number 26, Ulyappa Arun.
Right, I'm for the petition mod. The second round litigation. My lord, annexure C, despite of my lord's direction, rather request to KAT to consider stay of the applicant in accordance with law. My lord will peruse annexure C, page number 130. This honorable court has requested my lord to KAT to consider grant of stay. Despite of that, my lord, day has been declined by KAT, my lord. I have been suspended.
ಅಲ್ಲ. We have requested them to consider a
Yes,
interim
yes,
prayer.
yes.
That interim prayer has been considered
Yes.
and rejected.
Again, my lord,
Considered and rejected. ಅವಾಗ ಕನ್ಸಿಡರ್ ಮಾಡಿರ್ಲಿಲ್ಲ.
ಹಾ.
ಇವಾಗ ಕನ್ಸಿಡರ್ ಮಾಡಿ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ.
despite of my lord, this honorable court's request rather.
ಅದೇ ರೀ, we had requested them to consider your interim
Yes,
prayer.
yes,
Now they have considered and rejected.
but the,
Is it correct?
yes,
ಸರಿ.
the material
Ah.
that they have shown in the annexure A14,
Interim order,
yes, it is against interim order.
113.
Yes.
Annexure D is the, my lord, order of interim, order rejecting my
ಅದೇ
request.
ಪೇಜ್ ನಂಬರ್ 139.
Yes,
ಹಾ, ಓದಿ.
139. We heard the, Mayor, we heard the learned counsel for the applicant and learned AGA for respondent number 1, 2, 3. Peruse records. It revealed that the matter is pertaining to suspension of the applicant, and while shifting the lien of the applicant, the authorities had directed the applicant to hand over the charge to one Srimati Umadevi Sonnad, who is facing similar charge. This was the allegation earlier also. Accordingly, this tribunal by its order dated directed the respondent's authority to make necessary arrangements to give additional charge of the applicant to somebody else other than so-and-so, who is also facing the similar charge as that of the applicant. In pursuant to that, the learned AG submit that the said so-and-so has not taken the additional charge of the applicant. The respondents have complied the order of this tribunal. The learned counsel for the applicant further submit that the said so-and-so has not been suspended so far, and the order issued by this tribunal cannot be considered unless he is before this tribunal. Further, as per direction of the Honorable High Court of Karnataka, dated 13/11/24, in writ petition number so-and-so, wherein it was directed to pass orders on the interim prayer. Accordingly, we heard the learned counsel for the applicant on interim prayer. We have gone through the proceedings, submissions, and arguments made on behalf of both the parties. As such, we have gone through the annexure A14, wherein they have assigned the reason based on the material secured during the preliminary inquiry, and based on the impugned order has been passed. Accordingly, prima facie, the impugned order passed is in compliance of 10(3) and KCS rules 1957, wherein the authority competent to place the government servant under suspension shall examine the relevant material relating to the case and consider whether there is a prima facie evidence to support the charge made against the government servant. And if it is satisfied on such examination that prima facie evidence exists, it may place the government servant concerned under suspension. And as per that, all the requirements have been complied while surpassing the impugned order. Under such circumstances, we hold that the applicant has not made out a prima facie case to say the operation of the impugned order. The learned AGA respond number 2 shown directed to file reply statement. Accordingly, time is great. This is the Malad. Yes. Another madam who is also facing the same charge. She has not been either issued notice nor
Can that be a ground for
no,
saying no?
My grievances.
I also should not have been placed under.
My grievances are, my lord, we are similarly situated. Neither she has been issued notice nor she has been suspended. She has been working in her place without any disturbance.
Illa, she has been removed now.
My lord.
She was given additional charge.
No, she is holding independent charge of her post.
Yelli?
In the same district.
Huh?
In the equal post.
Yes.
My
Find
lord.
out why such a order of suspension is not passed against her.
I will find out.
Learned AGA takes notice for respond for 1,
2, 3.
Issue notice to respond number 4. Learned counsel for the petitioner is directed to serve copies of the petition along with annexures on the learned AGA. Full stop. Next para. Learned AGA is directed to secure instructions as to why the co-delinquent employee, Srimati Umadevi Sonnad, has not been placed in suspension. When similar allegations and charges are leveled against her and she is permitted to work. Full stop. Next para. Release this matter on 18th of December.
I am on parity. And my lord, on parity, my lord, till then, my lord may interfere till then.
No. Yes.
Hearing seal number 27. Ashwardhan or Mali Patil.
Tengli was supposed to answer. Your lordships heard this, my lord, regarding that lake rejuvenation. Your lordships had directed whether Lord our.
May I request your lordship, my lord, your lordship have it on Monday, my lord. If we not, the any department or principal secretary.
Tengli is Monday, Tuesday, it can be not taken.
We'll have it on Wednesday, 18th.
Your lordship have Tuesday, my lord, your lordship better. Tuesday, my lord, your lordship. Tuesday, my lord.
Wednesday, Akalan, Ray. Yen problem. ಅದು ನಿಮ್ದಲ್ಲ, he'll have to answer, Mr. Tengli.
Yes, please, my lord. Your lordship is directed us only, my lord, whether they have, my instruction, my lord, they only given the bank guarantee,
You're
my
not
lord,
coming
not given the cash, my lord. That is the instruction, my lord. That is,
You're not
your
coming on
lordship is that.
Wednesday?
Maybe, my lord, some.
Huh?
Tuesday, my lord, I will try to get, my lord. that one.
ಸರಿಯಾಗಿ ಕೇಳಿಸ್ತಾನೂ ಇಲ್ಲ ನೀವು ಮಾತಾಡೋದು.
But
Sir,
your
you are
lordship,
not
have
available on
Tuesday,
Wednesday,
my
sir.
lord, Tuesday. Tuesday, my lord, your lordship, have Tuesday, my lord. Better.
Wednesday illa anta
Asking you whether you are not available on Wednesday.
That is some, my lord, one parted matter is Bangalore, my lord. If I requested, my lord, then I had to come here. That is a problem, my lord. That is the reason. Let it be, my lord. Let it be on Wednesday, my lord.
Request of the learned government advocate release this matter on 17th of December.
Great.
Seal number 29, Manvendra Reddy. Seal number 29.
Lordship, I'm appearing for respondent lordship in this matter on behalf of Ravi B. Patil lordship.
ನೀವು ಆಮೇಲೆ NOC ಕೊಟ್ಟಿದ್ದೀರಾ?
Sanjeev Kumar C. Patil is appearing
So
lordship.
your name can be removed. Huh?
Yes, sir.
Since learned counsel Shri Sanjeev Kumar C. Patil has entered appearance for the respondent, the name of learned counsel Shri Ravi B. Patil may be removed from the cause list. List this matter after winter vacation.
Seal number 30, 30, Kadlur Satyanarayana Acharya.
My lord, I am appearing for respondent.
Yes.
My lord, there is 132 days of delay in filing the appeal.
ಏನ್ರಿ ವಕೀಲ್ರೆ, ಏನು ಹೈಕೋರ್ಟ್ಗೆ ಬರಬಾರ್ದು ಅಂತ ಏನ್ ತೀರ್ಮಾನ ಮಾಡ್ಬಿಟ್ಟಿದ್ರೆ ಹೆಂಗೆ?
ಬರ್ತೀನಿ ಸ್ವಾಮಿ. ನಮ್ದು ಒಬ್ರು ಕಲಿಗೆ ನಮ್ ಕಲಿಗೆ ಎಕ್ಸ್ಪೈರ್ಡ್ ಆಗಿದ್ದಾರೆ. ಇಲ್ಲ ಸ್ವಾಮಿ, ಬರ್ತೀನಿ. ನಮ್ ಕಲಿಗೆ ಎಕ್ಸ್ಪೈರ್ಡ್ ಆಗಿದ್ದಾರೆ ಮೈ ಲಾರ್ಡ್ ಇಲ್ಲಿ ಇವತ್ತು.
ಸರಿ, ಹೆಸರು ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ಬೇಕು ನಿಮ್ಮನ್ನ.
My lord, our colleague is expired today. Because of that reason, I am not able to.
Yes.
My lord, there is 132 days delay in filing the appeal, my lord. Appellant has challenged the impugned judgment of the family court, allowing the counterclaim of the wife for restitution of conjugal rights. And appellant has also challenged by way of separate appeal the rejection of petition for divorce. Lord, the appellant has made out good grounds.
Of 132 days in filing the appeal is condoned, having regard to the nature of the case brought before this court. IA number 1 of 2023 is accordingly disposed of. Errorly the entry delay?
Yes, my lord.
In both the cases? Yes.
Obliged.
Seal number 31, Ravi B. Patil.
Okay.
Application seeking leave to prefer appeal. Since I was not arraigned as a party before not the single judge.
Not the present appellant, my lord, the wife of deceased. Service matter. ಹೌದು, ಇದರಲ್ಲಿ ಏನಾಗಿದೆ, after the dissolution of marriage of deceased with my lord, the respondent number 8, my lord, he had married my lord, the present appellant. My lord, he had left behind my lord, the three sons out of my lord, Suryakanth Panchal. How? After dissolution of the marriage. Yes. With the respondent number 8. 8. Where is that order? My lord, they themselves had produced before the court, my lord, the page number, annexure G, page number 21. I'm sorry, my lord. 40, annexure, page number 40. So this is attained finality. Yes. After this, my lord, suppressing the fact that my lord, the deceased had married this appellant, they had approached my lord, the learned single judge, my lord, with this writ petition, claiming the relief, my lord, may take your lordship to page number 29 and 30. For mandamus, first prayer is with regard to mandamus, second prayer also. Allah, if they have themselves furnished a copy of that decree, then there should be something. What have they said in the memorandum of petition? Memorandum of writ petition, my lord, they have suppressed the fact regarding my lord, my marriage with after my lord, dissolution of first marriage. I was married with my lord, the deceased. But they have but they have produced a copy of the decree of the dissolution of marriage. What is the meaning then? My lord, the prayer C, my lord, at page number 30. Yes, sir. Written in the nature, but however, my lord, the learned single judge has restricted, my lord, the release of my lord, the service benefits in favor of my lord, the respondent number 9 to 9, 10 and my lord, another son. Please come to paragraph 9, page number 26. Please. Stated about the dissolution of the marriage. Yes. Then dissolve the marriage between the petitioner, late Suryakanth, son. Yes. Now, my lord, the dispute is with regard. Dissolved marriage between petitioner and late Suryakanth and sons. I mean the petitioner. Now dispute is with regard to family pension and not the benefits. Dispute is with regard to family pension and benefits, service benefits. The prayer C, they seek for a relief that that benefit should be paid to the respondent 8 to 10, along with one more son who is not a party before the learned single judge. And that is being considered without my in my absence. Now, the authorities are making attempt to release the benefits in favor of the respondent 9 to 11. Operating portion of the order may, though the relief in favor of respondent number 8 is not been granted. Page 15, my lord. Para 5. Para number 3 is of the impugned order. It is, however, paragraph number 2. Yes, they have noticed that dissolution of the marriage. Yes. Now, my lord, para 5. In para number 3. Yes. It is, however, the contention of the petition number 2 to 3. 2 and 3. That is the children of Suryakanth Panchal, that they would be entitled to succeed to the benefit that accrued as a result of Suryakanth's death, since they are the legal heirs of Suryakanth Panchal. Yes. In view of the fact that. So the prayer is made on behalf of the children. Yes. Yes. My lord, the para 5 may I request, my lord? The fifth respondent is directed to consider the claim of all the 3 sons of Suryakanth Panchal and make over the benefits to them in accordance with law. Yes. This exercise shall be taken. Yes. They have suppressed, my lord. I am also entitled for this benefit. Admittedly, my lord, the first wife who has secured decree of divorce, my lord, she is not entitled. Rightly, my lord, considered by learned single judge. But this affects my rights. Now, entire benefits is sought to not be released in favor of respondents number 9 and 10. When did you get married? I have produced the marriage certificate along with the production additional documents. Memorandum of appeal ಅಲ್ಲಿ ಏನು ಹೇಳಿದಿರಿ ಹೇಳ್ರಿ ಸಾಕು. I had married after dissolution of the marriage of respondent number 8 with said Suryakant Panchal. You have not said when you got married.
And I have produced the documents, my lord,
There.
not along with the IA for production of additional documents.
Why IA for production?
But because these documents were not placed before my lord learned single judge.
ಯಾವುದು?
And married on my lord 31/12/2007.
Page number.
My lord, page number 6, my lord. These are the pensionary pension applications, my lord, for release of family pension.
Sir, when did you get married?
31/12/2017.
Where have you stated?
Page 6 nal ಬರುತ್ತೆ. Para 2 last.
(31/12/2017).
Yes.
What document have you produced along for the confirmation of that marriage?
But I have produced one of the documents, death certificate, one of the family family pedigree issued in respect of one of the family of one of the deceased.
That anyone can issue.
The mother no idare. Along with mother, my name is shown. Page number 20. In fact, mother is also entitled for the benefit. Page number 20. Imla Bai mother is also still alive. Death certificate also reflects my name as the wife.
Learned government advocate takes notice for
R1 to R5.
response number 1 to 5.
Yes.
Raj Bukka had.
No, what about this? ಅವ್ರಿಗೆ notice issue ಮಾಡ್ಲಿಲ್ವಾ? School authorities ಗೆ?
Served and toast.
ಇಲ್ಲ.
Notice to R2. 6 and 7 ಏನು ತೋರ್ಸ?
Notice issue ಮಾಡಿಲ್ಲ. Issue notice to response number 5 and 7. Learned counsel.
6 and 7.
Shri Jairaj K. Bukka.
Yes.
Is requested to take notice for response number 8.
8, 9. 8,
8
9,
to 10.
10.
8 to 10.
Yes.
Learned counsel for the appellant is directed to serve copies of the appeal memo along with annexures on the learned government advocate as well as the other respondents. Full stop. Next para. Learned counsel for the appellant submits that this intra-court writ appeal has been filed at the hands of the appellant who was not a party to the proceedings before the learned single judge, along with an application seeking leave to prosecute this appeal in IA number?
I number the
3
of 20.
I number
3
3.
of 2024. And along with the application for condonation of delay. Full stop. It is submitted that though respondents number 8 to 10 who filed the writ petition were aware of the fact that the appellant herein got married to Shri Suryakant Panchal after the dissolution of the marriage between Shri Suryakant Panchal and the 8th respondent herein by a decree passed on
15 September 2017.
15 September 2017, they have deliberately not appellant herein as a party responding to the proceedings before the learned single judge. Full stop. In fact, The writ petitioners were aware of the fact that claim was made by the appellant herein by filing an application before the sixth respondent, headmistress of Karnataka High School, Bidar, seeking family pension nevertheless, she has not been made a party in the writ petition. Full stop. Next para. Consequently, there shall be an ad interim order of stay of the impugned order passed in WP number 200747 of 2023 till the next date appearing. Yes.
Seal number 32.
You to prosecute the concept.
Appearing for appellant, my lord, this insurance appeal challenging liability, my lords. Respondents have filed for withdrawal of the, my lord. TCRs are required, my lord, because we have challenged the exhibit salary certificates, my lord. 3 salary certificates have been produced before the tribunal, my lord. But after the exhibit P20 and 16 are different, my lords. Amount varies from.
Agli 50% only will be has been directed to be deposited.
Yes, even 1/3 has to be done, my lord, because 3 persons are the claimants, my lords. Earlier there were 4 persons.
Only 50% of the award amount has been directed to be deposited.
Yes, my lord.
What will happen if they get it released?
Quantum is also challenged, my lord. That is also 50 out of 50. 50
quantum in ಎಷ್ಟು reduce ಆಗುತ್ತೆ? It be reduced to less than 50%.
Yes, my lord. As per exhibit P16, my lords, the salary certificate issued by the P16, my lords. P16 is the salary, my lords, shows only sum of rupees 21,561, my lords. Exhibit P20, my lords, 36,585 it is showing, my lords. Half of the it will come higher double amount. 36,585, my lords. That has been considered, my lords. And it has been issued in the month of.
It will not reduce to less than 50%.
And even quantum in that, my lord, 1/4
ಎಷ್ಟು award ಆಗಿದೆ?
Award amount, my lords, total
40 lakh, 17,000.
40 lakh 17,500, my lords.
So we'll permit them to get release of 50% of what you have deposited. That will be about 10 lakhs. If you have deposited 20 lakhs,
we have deposited.
They will,
deposited entire award amount. Entire award amount has been deposited, my lords.
Entire award.
Howda? Why?
Yes, the honorable court direction.
Interim order was.
Entire amount.
Yes.
Entire amount.
Yes, what do you say?
My lord,
Since they have raised a challenge regarding liability also, and they have deposited the entire amount, we cannot permit you to take release of the entire amount or even 50%.
50%, my lord,
ಆಗೋದಿಲ್ಲ.
the PW3, my lord, is accountant, my lord, of the employee.
Will permit you to get a release of 25% only.
25%, my lord. Yes, but meanwhile, my lord, records are necessary, my lord. In my case, my lord.
Order on IA number 3 of 2024. This is an application filed at the hands of response number 1 to 3, who are the claimants before the tribunal, seeking leave to withdraw the amount deposited by the appellant insurance company. Full stop. However, learned counsel for the appellant insurance company submits that this appeal has been filed on 2 grounds. namely that the insurance company is not liable.
It is liable, my lord.
Madilla,
Only
liability challenge
quantum,
Only quantum.
Only quantum.
Only con.
That this appeal has been filed challenging the quantum of compensation granted by the tribunal, awarded by the tribunal. And in terms of the directions issued by this court, 50% of the entire award amount has been deposited before the tribunal. Full stop. It is therefore contended that without consideration of the appeal, the entire amount cannot be released to the claimants. Full stop. Next para. Angadre we will permit release of 50%. If it is only quantum, we are therefore of the considered opinion that the claimants may be permitted to withdraw 50% of the award amount from the tribunal, subject to the final outcome of this appeal.
Yes. In my case, my lord, respondent number 2, my lord, Ex-parte direct to take notes, my lord. Connect appeal, my lord. Claimant also.
Appeal is filed.
You are also seeking enhancement.
Enhancement.
Further enhancement.
Yes, madam. Respondent number 1, my lord,
I will
A
take
number so and so is accordingly disposed of. Next para. Idರಲ್ಲಿ connected appeal ಅಲ್ಲಿ learned counsel Shri
Sharan Basappa M. Patil.
In response.
ಶರಣ ಬಸವ ಬಿ ಪಾಟೀಲ್
M. Patil.
M. Patil.
M. Patil.
Sharan Basappa M. Patil, my lord.
ಏನ್ರಿ ಇಬ್ಬರದು ಒಂದೇ
ಇಬ್ರು ಹಂಗೆ
ಸಂಗನ ಬಸವ
ಸಂಗನ್
learned counsel Shri ಶರಣ ಬಸಪ್ಪ ಎಂ ಪಾಟೀಲ್ is requested to take notice for
Respondent number 2, my lord.
respondent number 2. ಆಮೇಲೆ
Respondent number 1, my lord,
will-
Ex-parte Patil. ಇದು
Liaquat
Liaquat.
will take.
learned counsel Shri Liaquat Farid Ustad,
Yes, yes, ma'am.
who is present in the court, takes notice for
For R.
R1, my lord.
respondent number 1.
Yes, ma'am.
ಅಷ್ಟೇನಾ?
Respondent number 3, my lord, claimant, my lord, is also claimant, my lord. I will take notes, my lord.
Respondent number 1 is who? Owner of the
Owner of the
vehicle.
I'm
Who is respondent number 3?
He is one of the claimant, my lord.
Claimant.
Yes, my lord. ಅವರು father-in-law of the petition number 1, my lord.
Notice to respondent number 3.
Please. In the back. Yes.
DCR requirement for
ಅಲ್ಲ ರಿಲೀಸ್ ಆಗಲಿದೆ ಅಮೌಂಟ್
Please, second.
ಮತ್ತೆ ಪ್ರಾಬ್ಲಮ್ ಆಗುತ್ತೆ.
yes, ma'am.
Respondent number ಅವ್ರು ತಗೊಳಲ್ಲ ಅವರು because he is not sailing with them. ತಗೊಳ್ಳೋದಿಲ್ಲ.
But 50% ಅವ್ರಿಗೂ ಹಾಕಿದ್ರಿ ರಿಲೀಸ್ಗೆ.
Madam,
ಓ ಅದೊಂದು ಪ್ರಾಬ್ಲಮ್ ಆಗುತ್ತಲ್ರಿ.
ಕ್ಲೈಮೆಂಟ್ ಡಿಸ್ಪ್ಯೂಟ್ ಇದೆಯಲ್ಲ,
yes, ma'am.
50%
ಅದೊಂದು
ಅವ್ರು ರಿಲೀಸ್
problem
ಮಾಡಿದ್ರೆ
ಆಗುತ್ತಲ್ಲ.
as per apportionment made by the
Yes, ma'am.
tribunal.
Apportionment may tribunal, madam.
Get a release of 50% of the award amount in terms of the apportionment made by the tribunal.
Tribunal, please, please.
Seal number 33, Preeti Patil Melkundi.
This is also insurance company appeal, madam. 61 days delayed the above matter. 69 days award of
In terms of the apportionment made by the tribunal, having regard to the fact that the respondent or respondent number 4 herein is also one of the claimants before the tribunal. Yes.
yes, madam. This company appeal, insurance company appeal challenging liability matter, madam. Challenging liability matter, madam. 69 lakhs.
346 days
This
delay.
is park vehicle, madam. Not for
ಹೌದ್ರಿ, almost 1 year delay.
61 days, madam. 61 days. 33, madam.
61 days.
Award amount 69 lakhs one for. Without
61
income,
lakhs.
yes, 69 lakhs for it is 16,400, madam. Without deduct the tax and others, madam. Park vehicle is there. Without indicator and
So issue notice to all the respondents.
yes, madam.
Next para. Although there is a delay of 61 days in filing the appeal, learned counsel for the appellant insurance company submits that the respondents have filed a case for execution of the award, and if no stay is granted, the appellant insurance company will be put to great difficulty. Full stop. Consequently, next para. There shall be an ad interim order of stay of the impugned judgment and award in MVC 340 of 2022 on the file of the MACT and third additional senior civil judge Kalaburagi till the next date of hearing, subject to the appellant insurance company depositing 50% of the award amount before the tribunal, within a period of 6 weeks from today.
Much on.
Case number 34, Avinash Uplanka.
My lord, in this case, the petitioner was working as a revenue inspector, food inspector. DGO number 1 was working as a manager. Two persons named as Siddhappa and Saibana lodged a complaint before the Lokayukta stating that these two persons have let go a lorry which was carrying a public distribution system rice meant for it, for which they lodge a complaint. An inquiry is being conducted. Simultaneously, a case is being registered against them in the police station, stating that you have not acted in accordance with the law and you have done an act of cheating. 420 case was registered. Surprisingly, the inquiry officer holds that in spite this PW 1 and 2, Siddhappa and Saibana turning hostile to the case of the complaint which they have given, only on the basis of an investigating officer who has not conducted the investigation, but a part of the investigation holds that the charge against these petitioners, this petitioner and another DGO 1 is proved. Agreed by the same thing, I approached the Honorable Karnataka Administrative Tribunal, pointing out the fact that the criminal case which was registered against me ended in an acquittal, which is at page number 92 to 124. The contention of the charge therein in the criminal case and the articles of charge against this petitioner are one and the same. I seek for an interim prayer before the Karnataka Administrative Tribunal for staying the operation and execution, as 23 years of service is yet to be completed by this petitioner. And surprisingly, the inquiry report, which my lordship may kindly take at page number 45, para 17 is the relevant portion of the inquiry report. My submission would be, it was a perverse report. In the cross-examination of PW3, who is the investigating officer, admits that names of the DGO 1 and 2 are not mentioned in the exhibit P2 and 3, that is the FIR and the Panchanama. He admits that the complaint is lodged against one Suresh Bandagomble, Gausuddin and the Tahsildar. He admits that even in exhibit P4, the names of DGO 1 and 2 are not mentioned. He admits that the Abzarpur police station crime number 6046 of 2004 was not registered against DGO number 1 and 2. He admits that case is registered
at the relevant point of time, he was working as
food inspector.
Food inspector.
Food inspector. DGO 1 was a manager. One Allah Bakshi is an accused in the criminal case.
Manager of
this food and civil supplies. Manager alone post ಇದೆ sir. Manager and food and civil supply department public distribution systems again allotment ಕೊಡ್ತಾರೆ ಸರ್ಕಾರದಿಂದ ಬಂದಿದ್ದಕ್ಕೆ ಅಲ್ಲೊಂದು post manager on food inspector na. All said and done, it will be the manager who will be responsible. Criminal case against register ಆಗ್ಲಿಲ್ಲ. Subsequently, someone named it and I have been charge sheeted. That has been acquitted. And the inquiry officer holds that even in the investigating officer's cross-examination, he admits that no case was registered. Subsequently, I have been named. ಅಂತ ಒಂದಿದ್ರ ಮೇಲೆ ಒಂದು perverse report only saying that the investigating officer says that he has collected the document from the concerned Tahsil office, so I have charge sheeted them, deleting the name of the persons who are named in the FIR. And I have been ordered for DGO1 retirement ಆಗಿ ಹೋಗಿದ್ದಾರೆ. DGO2 is the petitioner. 23 ವರ್ಷ ಸರ್ವಿಸ್ ಇದೆ. So I sought for an interim prayer on 2 grounds by relying the judgment of my lordship, saying that in the criminal case when I have been acquitted on the same charge,
Prayer.
interim prayer ಅನ್ನ stay ಮಾಡೋದಕ್ಕೆ
Pending
reject.
before the KAT.
KAT. Interim prayer is rejected, for which I am before my lordship. Page number 125 and 126. ಇನ್ನೂ ಒಂದೇನಾಯ್ತು, ಈ KAT ಸಿಟ್ಟಿಂಗ್ ಇರ್ತಾ ಇರೋದೇ ಫ್ರೈಡೆ ಒಮ್ಮೆ. So the matters will be called at Bangalore. We will be even unable to make our submissions completely.
Where is that report?
Inquiry report starts from 34 to 48. Relevant portion would be page number 45, para 17. ಆ para 45, page number 45 ಅಲ್ಲಿ para number 17 ಅಲ್ಲಿ enquiry officer makes a note.
Yes.
In the cross examination of PW3, that is the PW1 and 2 turns hostile. ಅದು ಬರ್ದಿದ್ದಾರೆ. PW1 ಮತ್ತೆ 2 hostile ಆಗಿದ್ದಾರೆ. ಯಾರು ಜಾಯಿಂಟ್ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅವ್ರು hostile. PW3 is the investigating officer. PW3 admits that names of DGO1 and 2.
Investigating officer.
ಅಂದ್ರೆ criminal case in the investigating officer. He is being examined as PW3. ಹಾ, ಲೋಕಾಯುಕ್ತ. ಲೋಕಾಯುಕ್ತ ಸರ್, ಲೋಕಲ್ ಪೊಲೀಸ್, ಅಫ್ಜಲ್ಪುರ್ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್.
Local police.
ಲೋಕಲ್ ಪೊಲೀಸ್.
420.
ಹಾ, 420 ಲೋಕಾಯುಕ್ತ. ಪ್ರಿವೆನ್ಷನ್ ಆಫ್ ಕರಪ್ಷನ್ ಆಕ್ಟ್ ಚಾರ್ಜ್ ಇಲ್ಲ ಸರ್. ಯಾಕೆ ಟ್ರ್ಯಾಪ್, ರಿಸಿಟ್, ಡಿಮಾಂಡ್ ಎಕ್ಸೆಪ್ಟೆನ್ಸ್ ಅದೇನಲ್ಲ. ಇಟ್ಸ್ ಓನ್ಲಿ.
ಏನ್ರಿ ಇದು IPC 420 ಹೆಂಗ್ರಿ ಬರುತ್ತೆ?
It is a 420 case registered against someone.
420 ಬರುತ್ತೆ.
FIR registered against some other persons, subsequently charge sheet filed against.
ನಮ್ ಅಗೇನ್ಸ್ಟ್ ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್ ಮಾಡ್ತಾರೆ. ಕೇಸ್ ಮಾಡಿರೋದೇ ಬೇರೆಯವ್ರ ಮೇಲೆ.
ಆಯ್ತು, ಓದಿ.
PW3 in the cross examination admits that names of DGO1 and the petitioner is DGO2 are not mentioned in exhibit P2 and 3. He admits that the complaint is lodged against one Suresh Bendegomble, Gausuddin and Tahsildar. He admits that even in exhibit P4, the names of DGO1 and 2 are not mentioned. He admits that the Afzalpur police station crime number 46 of 2014 was not registered against DGO1 and 2. He admits that the case is registered against one Allah Baksh. He is the person who took the lorry, stating that he obstructed to do official duty against the DGO1 and 2. He has not recorded the statements of Tahsildar and PSI. He has not drawn the spot measure. He has not visited the police station and the office of Tahsildar, but he secured the documents.
ಏನ್ ಡಾಕ್ಯುಮೆಂಟ್?
ಈ ಪೀರಿಯಡ್ ಅಲ್ಲಿ ಇವ್ರು ವರ್ಕ್ ಮಾಡ್ತಾ ಇದ್ರು. ಇಷ್ಟು ಲಾರಿಯನ್ನ ಯಾರೋ ತಗೊಂಡು ಹೋಗಿದ್ದಾರೆ ವಿದೌಟ್ ಬಿಲ್ಲಿಂಗ್ ಅಂಡ್ ದೇ ಹ್ಯಾವ್ ಗಾಟ್ ಪಾಸ್ಟ್ ದಿ ಲೇಡನ್ ಲಾರಿ ಅಂತ ಹೇಳಿ. ಅವು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕಲೆಕ್ಟ್ ಮಾಡಿದಕ್ಕೆ ದಿ ಎನ್ಕ್ವೈರಿ ಆಫೀಸರ್ ಕಮ್ಸ್ ಟು ದ ಕನ್ಕ್ಲೂಷನ್ ದಟ್ one SS Hullur it's at para 22. The charge sheet is filed after investigation alleging an offense under 409, 420, 511. That is an attempt read with 34 of IPC, dropped against 353 and final. The charge sheet is filed against DGO1 and 2 and Allah Baksh. According to the charge sheet near Bhima River Bridge, when SS Hullur police inspector of DCBI handed over the lorry laden of 280 bags against rice to DGO1 and 2, they facilitated Allah Baksh Bhagwan illegally released the lorry laden with 280 rice of bags and thereby committed offense under 409 and 420. Enquiry officer come to the conclusion this SS Hullur is not examined either in the criminal case nor before the enquiry officer. ಎರಡು ಕಡೆ ಮಾಡಿಲ್ಲ.
No. Action was taken by the police inspector. Their vehicle was seized.
Yes. They say that SS Hullur
Then it was handed over to DGO1 and 2 to take further action. Now the allegation is
they have made
without taking action, they have simply
left the vehicle anta avaru helidare. Then to establish this thing, neither SS Hullur was examined either in the criminal case nor before the enquiry officer. Our examine agilla. ಈ ಆಕ್ಟ್ ಅನ್ನ ಇಬ್ರು ಅನ್ನೋನ್ ಪರ್ಸನ್ಸ್ ಸಿದ್ದಪ್ಪ ಅಂಡ್ ಸಿದ್ದಮಲ್ಲಪ್ಪ they say that ಯಾರೋ ಒಂದು ಇಟ್ಟಿದ್ದನ್ನ ಲಾರಿ ಬಿಟ್ಟಿದಾರ ಅಂತ ಹೇಳಿ ಅವರು ಲೋಕಾಯುಕ್ತ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟ ಮೇಲೆ ಈ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಅಲ್ಲಿ ಕೇಸ್ ರಿಜಿಸ್ಟರ್ ಆಗುತ್ತೆ. ಇಟ್ ಈಸ್ ಅಲ್ಟಿಮೇಟ್ಲಿ ದ ಡ್ಯೂಟಿ ಆಫ್ ದಿ ಮ್ಯಾನೇಜರ್ without there being any material. Investigating officer, ಇಲ್ಲಿ ನಾವು against case or register ಆಗಿಲ್ಲ. This is the plight for which I sought for an.
Third, three.
Avinash.
This writ petition is filed.
First one, notice of.
State one.
Respond for one.
Notice.
Notice to respond.
Is directed to change.
ಆಮೇಲೆ ಇವರು ಸುಭಾಷ್ ಮಲ್ಲಾಪುರ್.
To Subhash Malapur.
ಲೋಕಾಯುಕ್ತ. Copy to be served on the learned government advocate and learned counsel for respondent.
Sir, has filed this writ petition against the interim order passed by the tribunal KAT in application number
ಮೇಲಿದೆ ಸರ್, ಪೂರ್ತಿ ಮೇಲೆ 215065.
21585.
595.
595 for 2024 dated 25/11/2024. As the tribunal has refused to stay the order, stay the operation of the impugned order. The learned counsel for the petitioner would submit that on the basis of the complaint filed by PW 1 and 2,
They are Siddappa and Saibana.
Siddappa and Saibana, Afzalpura police.
ಇಲ್ಲ ಸರ್, ಮೊದಲು ಅವ್ರು ಲೋಕಾಯುಕ್ತ ಕೊಡ್ತಾರೆ ಸರ್. ಸಿದ್ದಪ್ಪ ಮತ್ತು ಸಾಯಿಬಣ್ಣ ದೇ ಲಾಸ್ಟ್ ದಿ ಕಂಪ್ಲೇಂಟ್ ಬಿಫೋರ್ ದ ಲೋಕಾಯುಕ್ತ. ಇವರು ಬಿಟ್ಟಿರೋ ಲಾರಿ ಬಿಟ್ಟಿದ್ದಾರೆ ನೋಡ್ರಿ ಅಂತ ಹೇಳಿ. ಅಗೇನ್ಸ್ಟ್ DGO 1 and 2 or petitioner and his manager. ಇಲ್ಲಿ ಒಬ್ರು ಇನ್ನೊಬ್ರು ರಿಟೈರ್ ಆಗಿ ಹೋಗಿದ್ದಾರೆ ಸರ್ ಅವ್ರು. ಇದು ಕಂಪಲ್ಸರಿ ರಿಟೈರ್ಮೆಂಟ್ ಆರ್ಡರ್ ಮಾಡಿದಾರಲ್ಲ.
ಈ DGO 1 ಇವರು,
ಇವು DGO 2 ಸರ್.
DGO
petitioner.
petitioner and another
Manager at the relevant point of time.
and another DGO 1, the manager of
Food Corporation of FCI.
but CC ಯಾವ ರೀತಿ ಆಯ್ತು ಇದು?
CC ಇವ್ರ ಅಗೇನ್ಸ್ಟ್ ಮತ್ತ ಆ DGO 1 ಅಗೇನ್ಸ್ಟ್ ಕ್ರಿಮಿನಲ್ ಕೇಸ್.
ಲೋಕಾಯುಕ್ತ ಕೊಟ್ರಿ.
ಇಲ್ಲ, ಲೋಕಾಯುಕ್ತ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಾರ ಅಂದ ಮೇಲೆ ಇವ್ರು ಇಲ್ಲಿ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ದವರು ಕೇಸ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ್ರು ಸರ್.
ಅಲ್ಲ, ಎಲ್ಲಿ FIR ಯಾರು ಕೊಟ್ಟಿದ್ದು?
FIR ತಗೊಂಡಿದ್ದು ಅಫ್ಜಲ್ಪುರ್ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ದವ್ರು. ಈ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟ ಮೇಲೆ ಪೊಲೀಸ್ ಸರ್,
ಪೊಲೀಸ್ಗೆ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದು ಯಾರು?
ಇವ್ರು ತಹಸೀಲ್ದಾರ್ ಇನ್ಫಾರ್ಮೇಶನ್ ಬಂತು, ಲೋಕಾಯುಕ್ತದಿಂದ ನೋಟಿಸ್ ಬಂತು, ಇಂಥದೊಂದು ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದಾರೆ ನಮ್ಮ ಹತ್ರ, ಇದ್ರ ಅಗೇನ್ಸ್ಟ್ ಏನ್ ಆಕ್ಷನ್ ತಗೊಂಡಿದಿರಿ ಅಂತ ಕೇಳಿ ತಹಸೀಲ್ದಾರ್ ಒಂದು ಆರ್ಡರ್ ಬರೆದ್ಮೇಲೆ ತಹಸೀಲ್ದಾರ್ ಏನ್ ಮಾಡ್ತಾರೆ, ಹೋಗಿ ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಅನ್ನ ರಿಜಿಸ್ಟರ್ ಮಾಡ್ತಾರೆ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಅಲ್ಲಿ, ಅಫ್ಜಲ್ಪುರ್ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಅಲ್ಲಿ.
ಅದು ಲೋಕಾಯುಕ್ತದ್ದು ಏನಾಯ್ತು?
ಲೋಕಾಯುಕ್ತ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದಕ್ಕಾಗಿ ಬರೀ ನಾವು ಲೋಕಾಯುಕ್ತಕ್ಕೆ ಅವರು ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿಲ್ಲ ಸರ್.
ಲೋಕಾಯುಕ್ತ ಕೊಟ್ರು ಅಂತ ಹೇಳಿದ್ರು.
ಅಂದ್ರೆ ಲೋಕಾಯುಕ್ತ ಎನ್ಕ್ವೈರಿ ಸಲಕ್ ಸರ್. ಲೋಕಾಯುಕ್ತ ಅಂತ ಹೇಳಿ ಒಂದು ವಿಂಗ್ ಇದೆ, ಉಪಲೋಕಾಯುಕ್ತ, ಲೋಕಾಯುಕ್ತ, ಅಲ್ಲಿ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ರು ಇವ್ರು. ಯಾರು? ಸಿದ್ದಪ್ಪ ಮತ್ತು ಸಾಯಿಬಣ್ಣ.
ಅಲ್ಲಿ ಎನ್ಕ್ವೈರಿ ಸ್ಟಾರ್ಟ್ ಆಯ್ತು.
ಎನ್ಕ್ವೈರಿ ಸ್ಟಾರ್ಟ್.
ಅದು ಸಿವಿಲ್, ಇಲ್ಲಿ ಕ್ರಿಮಿನಲ್.
ಇಲ್ಲಿ ಕ್ರಿಮಿನಲ್ ಎರಡು ಮಾಡಿದ್ರು.
ಅದೇ who was the complaint?
ಎಲ್ಲಿ ಸರ?
ಅವರೇ ಸೇಮ್
ಪೊಲೀಸ್
ಪೊಲೀಸಿಗೆ ತಹಸೀಲ್ದಾರ್ ಸರ್, ತಹಸೀಲ್ದಾರ್. ಈ ಲೋಕಾಯುಕ್ತವ್ರು ಯಾವಾಗ ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡ್ತಾರೆ ಕನ್ಸರ್ನ್ ಆಫೀಸರ್ಸ್ಗೆ, ಇಂಥದ್ದೊಂದು ಕಂಪ್ಲೇಂಟ್ ಬಂದಿದೆ ನಿಮ್ದು ಟಿಪ್ಪಣಿ ಕೊಡ್ರಿ ಅಂತ ಹೇಳಿ, ಅವಾಗ ತಹಸೀಲ್ದಾರ್ ಹೋಗಿ ಕೇರಿ ಕೇಸ್ ರಿಜಿಸ್ಟರ್ ಮಾಡ್ತಾರೆ.
The Tahsildar Afzalpur has lodged a complaint against this petitioner and others.
ಇಲ್ಲ ಸರ್, ಡಿಫರೆಂಟ್ ಪರ್ಸನ್ಸ್, ಬಟ್ ಚಾರ್ಜ್ ಶೀಟ್ ಈಸ್ ಬೀಂಗ್ ಫೈಲ್ಡ್ ಅಗೇನ್ಸ್ಟ್ ದಿಸ್ ಪರ್ಟಿಕ್ಯುಲರ್ ಪಿಟಿಷನರ್ ಅಂಡ್ DGO. ಕಂಪ್ಲೇಂಟ್ ಕೂಡ ನಮ್ಮ ಅಗೇನ್ಸ್ಟ್ ಇಲ್ಲ. Sir, judgment starts at page number 92. Criminal case in page number 92, sir. 92, sir. 92 to 124 ಇದೆ. 92. Criminal case.
ಲೋಕೇಶಪ್ಪ, ಅನಿಲ್ ಕುಮಾರ್, ಅಲ್ಲಾ ಬಕ್ಷ.
ಹಾ, ಅಲ್ಲಾ ಬಕ್ಷ. These are the 353 ಸಲುವಾಗಿ sir.
FIR ಇರೋದು ಯಾರ ಮೇಲೆ?
Pardon sir.
FIR ಇವ್ರ ಮೇಲೆ ಇಲ್ಲ ಅಂದ್ರಲ್ಲ.
ಈ ಇದ್ರ ಸಲುವಾಗಿ ಸರ್, ದಿಸ್ ಕೇಸ್ ವಾಸ್ ಫಾರ್ 353. ಇವ್ರ ಅಗೇನ್ಸ್ಟ್ ಕೇಸ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಿರೋದು. ಮೈ ಲಾರ್ಡ್ಶಿಪ್ 353 ಅಲ್ಲಿ ಕೇಸ್ ರಿಜಿಸ್ಟರ್ ಫಸ್ಟ್ ಇವ್ರು ಮಾಡಿದಿತ್ತು.
ಅದಲ್ರಿ.
ಈಗ ತಹಸೀಲ್ದಾರ್ ಇದ್ರ ಮೇಲೆ ಕಂಪ್ಲೇಂಟ್ ವಾಸ್ ಲಾಸ್ ಅಗೇನ್ಸ್ಟ್ ದಿಸ್ ಪಿಟಿಷನರ್ ಲೋಕೇಶಪ್ಪ ಅಂಡ್ ಅಲ್ಲಾ ಬಕ್ಷ. ಮೈ ಲಾರ್ಡ್ಶಿಪ್ ಕ್ಯಾನ್ ಟೇಕ್ ಇಟ್.
Petitioner also.
Petitioner also. My lordship may take it at this juncture.
On the basis of the complaint filed by the Tahsildar Afzalpur, the Afzalpura police have registered the case against the accused number 123. That is Lokeshappa, Anil Kumar Wagyekar, bracket na petitioner in this case, and number 3, Allah Bakash. And after completion of charge sheet, investigation, charge sheet was filed against the accused number 123 for the commission of offence under section 409, 420 and 511 read with 34 IPC. After trial, the trial court has acquitted the accused number 123 in CC number 217/2016 on the file of civil judge and JMFC Afzalpur for the commission of offence under section 420, 409, 511 IPC. ಇದರ ಬರ 511 ಇಲ್ಲ.
ಇಲ್ಲ ತೆಗೆದಿದ್ದಾರೆ, ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಮಾಡಲಿಲ್ಲ, ಅದಕ್ಕೆ ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಮಾಡಲಿಲ್ಲ.
420, 409 read with 34 IPC. Same is not challenged by the state.
State ಇಲ್ಲ ಸರ್.
Same is not challenged by the state. With regard to the enquiry conducted by the Lokayukta is concerned, the material witness PW 1 and 2
Turned
are
hostile.
not supported to the. They are not supported. ಮತ್ತೆ ಇನ್ಯಾರ?
Investigating officer.
Only on the basis of
Investigating officer.
investigation officer who has conducted the investigation in CC number
217.
217/2016. The enquiry officer of Lokayukta has come to the conclusion that
Charge against the
charge
petitioner.
against this petitioner has been proved by the
From the evidence of investigating officer.
concerned authority.
Pardon sir.
ಇದಾದ್ಮೇಲೆ ಮತ್ತೆ ಏನಾಯ್ತು?
ಆದ್ಮೇಲೆ ಕಂಪಲ್ಸರಿ ರಿಟೈರ್ಮೆಂಟ್ ಗೆ ರೆಕಮೆಂಡೇಶನ್ ಮಾಡಿದ್ರಿ ಎನ್ಕ್ವೈರಿ ಆಫೀಸರ್.
ಅಲ್ಲ, ಆಮೇಲೆ ಯಾರು ಉಪಲೋಕಾಯುಕ್ತ
ಉಪಲೋಕಾಯುಕ್ತ
ಪೇಜ್ ನಂಬರ್ ಯಾವ್ದು?
ಬರೋಡ್ ಇದು ಉಪಲೋಕಾಯುಕ್ತ ರಿಪೋರ್ಟ್ ಆಯ್ತು. Recommendation 49 to 53, my lord. Page number 49 to 53. Recommendation of compulsory retirement. Sir, page number
Enquiry
annexer
after
A3.
Is the report to the learned to the Upalokayukta.
Honorable.
Number 1. On examination of the report,
Upalokayukta.
the Upalokayukta. The learned
Honorable.
Upalokayukta number 1 has recommended
Compulsory retirement.
recommended for compulsory retirement
Yes.
of this petitioner.
Compulsory.
ಇದು ಆರ್ಡರ್ ಪಾಸ್ ಆಯ್ತಾ ಗೌರ್ಮೆಂಟ್?
58, page number 58 also.
58. On the basis of this recommendation made by the Upalokayukta, the impugned order is passed against this petitioner for compulsory retirement from service. Being aggrieved by this order, you have
Approach the KT.
the petitioner has challenged the same before the court.
Page number 40.
Further, the learned counsel but submit that the charge sheet filed against DGO 1 and 2 and Allah Bakash Bhagwan according to Constitution. Yeah, you know.
ಇವ್ರನ್ನೇ examine ಮಾಡಿ. ಇದು background check. Yes.
According to the charge sheet, on 11/9/2013 near Bhima River Bridge, when SS Ullur Police Inspector DCIB handed over the lorry laden with 280 bags of rice to DGO 1 and 2. They facilitated the Allah Bakash Bhagavan illegally released the lorry landed with 280 rice bags and their rice bags. But they said Ullur inspector is not exempt.
Not exempt, either in the inquiry or in the criminal.
Witness, Sri SS Ullur, Police Inspector DCIB has not been examined before the Lokaikta.
Local or criminal,
Or before the
criminal case.
criminal court.
Criminal court has been excluded.
I guess, under you important witness, sir.
Also before the criminal court. Only on the basis of the investigation report, who has investigated in part
And file the charge sheet,
and submitted the
final report.
charge sheet against the petitioner and others. The inquiry officer has come to the conclusion that the charge is proved against the petitioner and others.
Ill petitioner open.
Petitioner, which is the not sustainable under law, on all these grounds sought for stay. Stay the operation of the impugned order. On an examination of the entire materials placed before this court, you find that you find some prima facie, we find the
Petitioner has made out a case for
hence proceed to pass the following order. There shall be a stay. As to the impugned order passed by the concerned authority.
ಯಾವ್ದದು?
Stay of
Respond number 1, page number 21 ಅಲ್ಲಿ KME 62 BDP 2017 dated 28.
yes, sir.
Annexure A6, madam.
Annexure A6, page 62.
Page number 62.
Then keep it. They have come here only for stay. The petition itself can be disposed of.
With a direction to K2.
That this stay will continue. Yes, that was the interim prayer, and we have granted stay. The matter may proceed before the tribunal. Stay ಅಷ್ಟೇ stay ಆಯ್ತು. ಆದ್ಮೇಲೆ only on the ground that interim stay of made by the president.
Since this writ petition is filed against the interim order passed by the KAT, same is stayed by this court and stay is granted. As sought for
Shall continue to operate and shall continue to
That's it.
operate till the disposal of the application
That's
or
Disposal.
by any other application filed by the respondents to seeking vacation of the interim order. The writ petition is accordingly disposed of.
Much of.
Seal number 34, P group matters, Sanjay M. Joshi.
Next week, my lord. Sanjay Joshi mother expired, sir, last week.
Huh?
Next week, my lord.
At the request of learned counsel for the petitioner, ಏನ್ರ ಬರೋದಿಲ್ರಿ ಇವ್ರು ಸಂಜಯ್ ಜೋಶಿ ಅವರು.
ಇಲ್ಲ ಬರ್ತಾರ ಸರ್, ಮೊನ್ನೆ ಅವ್ರು ಫಾದರ್ ಎಕ್ಸ್ಪೈರ್ ಸರ್ 1 month ಅಲ್ಲಿ ಮತ್ತೆ ಮದರ್ ಆಯ್ತು ಸರ್ ಮೊನ್ನೆ, ಹಿಂಗಾಗಿ ಸ್ವಲ್ಪ ಅವ್ರು ಟ್ರಬಲ್ ಆಯ್ತು ಸರ್.
We will have it after vacation.
Yes, ma'am.
List is matter after winter vacation.
Much.
Appeal number 36, Mahesh Patil.
My lord, it may be taken 230, my lord.
2:30.
I will request the AG to appear because it is
Pass over.
Appeal number 37, Mahesh Patil. Mahesh Patil.
Jaykumar sir was not present in VC. Pass over.
ಜಯಕುಮಾರ್ ಪಾಟೀಲ್ ಅವರು.
Yes, my lord.
ಹಾ?
Yes.
ಯಾವ್ದ ಇದ್ರದ್ ಮ್ಯಾಟ್ರ ಇದು? ಆ ಟೀಚರ್ಸ್ ಅದಲ್ಲ ಬೇರೆ. ಪಾಸ್ ಓವರ್.
ಪಾಸ್ ಓವರ್ ಆಗ್ತೀನಿ ಅಂತ ಹೇಳಿದಾರೆ, ಏನೇ ಕಾಲ್ ಮಾಡಿದ್ರು ಅವ್ರು.
ಪಾಸ್ ಓವರ್.
Appeal number 39, Sanjay M. Joshi.
This case, stay maybe extension, madam. Next date of hearing is sir, stay last year. Stay may be extended, madam.
At the request of learned counsel for the petitioner, list this matter after winter vacation. Full stop. Interim order granted earlier stands extended in the next date of hearing.
Much.
Appeal number 40, Shankar R. Kattimani, party in
That's
person.
for number 3, that's for number 2. Last hour, date of hearing.
Yes.
already percentage.
Yes. Yes.
My lord, it
What
is,
are your instructions?
my lord, instruction is that, my lord, it is, my lord, the amendment, my lord, in the year 2006. Where, my lord, it's clearly stated that, my lord, the fourth semester has to be taken into consideration for calculating the, my lord, the commercial practice. My
ಎಲ್ಲಿ
lord.
ಅದು which page is that you are
Page number
pointing out?
152.
Huh?
152. This, my lord, page number 151, my lord, that is the Anubandha 3, which is dated 1988, my lord, has
ನೀವು
been
ಪಾಯಿಂಟ್ ಔಟ್ ಮಾಡಿದ್ ಯಾವ್ದ್ರ ಯಾವ ಪೇಜ್ ರೀ? We had marked it last time.
151.
ಅದೇ ಪೇಜಾ?
ಇಲ್ಲ sir.
ಹಾ, ಯಾವ್ದು ನೀವು ತೋರಿಸಿದ್ದು?
142.
142.
42 ಸೂಚನೆ 2.
ಒನ್ 3 ವರ್ಷದ ಡಿಪ್ಲೊಮಾ ಇನ್ ಕಮರ್ಷಿಯಲ್ ಪ್ರಾಕ್ಟೀಸ್ ಅಥವಾ ತತ್ಸಮಾನ ವಿದ್ಯಾರ್ಹತೆ ಹೊಂದಿರುವ ಅಭ್ಯರ್ಥಿಗಳಿಗೆ 3 ವರ್ಷದ ಡಿಪ್ಲೊಮಾ ಇನ್ ಕಮರ್ಷಿಯಲ್ ಪ್ರಾಕ್ಟೀಸ್ ಅಥವಾ ತತ್ಸಮಾನ ವಿದ್ಯಾರ್ಹತೆಯಲ್ಲಿ ಕನ್ನಡ ಬೆರಳಚ್ಚು ಮಾಡಿಲ್ಲದ ವಿದ್ಯಾರ್ಥಿಗಳಿಗೆ ಅವರು ಎಲ್ಲಾ ವರ್ಷದ ಅಥವಾ ಎಲ್ಲಾ ಸೆಮಿಸ್ಟರ್ನಲ್ಲಿ ಗಳಿಸಿದ ಅಂಕಗಳು ಹಾಗೂ ಕನ್ನಡ ಬೆರಳಚ್ಚು ಪ್ರೌಢ ದರ್ಜೆಯ ಸೀನಿಯರ್ ಗ್ರೇಡ್ ವಿದ್ಯಾರ್ಹತೆಯಲ್ಲಿ ಗಳಿಸಿರುವ ಅಂಕಗಳ ಒಟ್ಟು ಶೇಕಡಾವಾರು ಕನ್ನಡ ಬೆರಳಚ್ಚು ಪ್ರೌಢ ದರ್ಜೆ. ಯು ಆರ್ ಪಾಯಿಂಟಿಂಗ್ ಔಟ್ ದಟ್ ಸೀನಿಯರ್ ಗ್ರೇಡ್, ಬಟ್ ಇವ್ರು ಸೀನಿಯರ್ ಗ್ರೇಡ್ ಮಾಡಿಲ್ಲ, ಜೂನಿಯರ್ ಗ್ರೇಡ್ ಮಾಡಿರೋದು ಅಂತ ಇವ್ ಪಾಯಿಂಟಿಂಗ್ ಔಟ್.
Yes.
ಹಾ,
ಅದು ಅವ್ರು ತೋರಿಸಿರ್ತಕ್ಕಂಥದ್ದು ಏನಿದೆಲ್ಲ ಸೆಕೆಂಡ್ ಫೋರ್ತ್ ಸಮ್ ಅದು
ಲೋವರ್ ಗ್ರೇಡ್ ಆಗುತ್ತೆ. ಜೂನಿಯರ್
ಜೂನಿಯರ್
ಗ್ರೇಡ್. ಎಸ್.
Yes, my lord. That's why, my lord, this is 1988, page number 151, my lord. Page number 151. He has read, my lord, the second column.
It is also part of the same document.
Yes, my lord.
It's part
This
of the
is-
same
yes,
document.
yes, part
Yes.
of the notification, my lord.
Yes.
He has read, my lord, the second column,
Yes.
which says, my lord, ತಾಂತ್ರಿಕ ಶಿಕ್ಷಣ ಪರೀಕ್ಷಾ ಮಂಡಳಿಯ ಕಮರ್ಷಿಯಲ್ ಪ್ರಾಕ್ಟೀಸ್ ಏನ 2ನೇ ವರ್ಷದ ಡಿಪ್ಲೊಮಾದಲ್ಲಿ ಕನ್ನಡ ಶೀಘ್ರ ಲಿಪಿ
Page 151.
my lord.
ಹಾ,
Column 2.
yes.
ತಾಂತ್ರಿಕ ಶಿಕ್ಷಣ ಪರೀಕ್ಷಾ ಮಂಡಳಿಯ ಕಮರ್ಷಿಯಲ್ ಪ್ರಾಕ್ಟೀಸ್ ನ 2ನೇ ವರ್ಷದ ಡಿಪ್ಲೊಮಾದಲ್ಲಿ ಕನ್ನಡ ಶೀಘ್ರ ಲಿಪಿ ವಿಷಯದಲ್ಲಿ ಉತ್ತೀರ್ಣತೆ
ಇದು ಈಕ್ವಲೆಂಟ್ ಟು ಕರ್ನಾಟಕ ಪ್ರೌಢ ಶಿಕ್ಷಣ ಪರೀಕ್ಷಾ ಮಂಡಳಿ ಕಿರಿಯ ದರ್ಜೆಯ ಕನ್ನಡ ಶೀಘ್ರ ಲಿಪಿ ಪರೀಕ್ಷೆಯಲ್ಲಿ ಉತ್ತೀರ್ಣತೆಗೆ ಸಮ ಅಂತ it is his contention that because the fourth semester comes my lord in the second year only.
Yes.
My lord, thereafter this has been amended and it is in the next page, my lord. Continuation of this, my lord. 9th November 2006, where my lord third serial number 3 CP andre commercial
commercial practice.
Yes, my lord. 4ನೇ ಸೆಮಿಸ್ಟರ್ ಬೆರಳಚ್ಚು ತೇರ್ಗಡೆ ವಾಣಿಜ್ಯ ಪರೀಕ್ಷೆಗಳ ಬೆರಳಚ್ಚು ಪ್ರೌಢ ದರ್ಜೆ ಕನ್ನಡ ಸೀನಿಯರ್ ಗ್ರೇಡ್ಗೆ ಈಕ್ವಲ್ ಅಂತ ಮಾಡಿದೆ. ಐ ವಿಲ್ ರೀಡ್ ಮೈ ಲಾರ್ಡ್ ದಿ ಪ್ರಿಯಂಬಲ್ ಆಲ್ಸೋ. ತಾಂತ್ರಿಕ ಶಿಕ್ಷಣ ನಿರ್ದೇಶಕರ ಪ್ರಸ್ತಾವನೆಯನ್ನು ಕೂಲಂಕುಷವಾಗಿ ಪರಿಶೀಲಿಸಿದ ಸರ್ಕಾರವು 2/3/1988 ಆದೇಶವನ್ನು ಮುಂದುವರಿಸುತ್ತಾ ತಾಂತ್ರಿಕ ಶಿಕ್ಷಣ ಪರೀಕ್ಷಾ ಮಂಡಳಿ ನಡೆಸುತ್ತಿರುವ ಕಮರ್ಷಿಯಲ್ ಪ್ರಾಕ್ಟೀಸ್ ಡಿಪ್ಲೊಮಾ ಪರೀಕ್ಷೆಗಳ ಕನ್ನಡ ಬೆರಳಚ್ಚು ಮತ್ತು ಶೀಘ್ರ ಲಿಪಿ ವಿಷಯಗಳ ಪರೀಕ್ಷೆಗಳ ಮಾರ್ಪಾಡನ್ನು ಈ ಕೆಳಕಂಡಂತೆ ಮಾಡಲಾಗಿದ್ದು, ಇದನ್ನು ನೇಮಕಾತಿಗಳಿಗಾಗಿ ಕರ್ನಾಟಕ ಪ್ರೌಢ ಶಿಕ್ಷಣ ಪರೀಕ್ಷಾ ಮಂಡಳಿ ನಡೆಸುವ ಕನ್ನಡ ಬೆರಳಚ್ಚು ಮತ್ತು ಶೀಘ್ರ ಲಿಪಿ ಪರೀಕ್ಷೆಗಳ ತತ್ಸಮಾನತೆಗೆ ಪರಿಗಣಿಸಬೇಕಾಗುತ್ತದೆ ಎಂದು ಈ ಕೆಳಕಂಡಂತೆ ಆದೇಶಿಸಲಾಗಿದೆ.
Yes.
Considering this, my lord, the fourth semester has been calculated and my lord aggregate has been made and
No, we can't understand why they have to put all these things instead of saying which is the one that is to be operated. ಇದನ್ನೆಲ್ಲ
ಅಲ್ಲ ಏನಾಗುತ್ತೆ ಮೇಲಾಡ್ ಬೇರೆ ಬೇರೆ ಪೋಸ್ಟಿಗೆ ಇವನ್ ಜೂನಿಯರ್ ಗ್ರೇಡ್ ಆಲ್ಸೋ ರಿಕ್ವೈರ್ಡ್ ಮೇಲಾಡ್. In respect of this post is concerned, my lord, senior grade is required. In respect of other post is concerned, junior grade also required. Therefore, this entire notification has been extracted and this is in continuation of, my lord, the notification also.
Yes.
ರವನರ್ ಅವ್ರು ಹೇಳ್ತಾ ಇರೋದು 2ನೇ ವರ್ಷ ಅದನ್ನೇ ಕಂಟಿನ್ಯೂ ಆಗಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ.
ಅಮೆಂಡ್ಮೆಂಟ್ ಆಗಿದೆ 2006 ಅಲ್ಲಿ ನೀವು ಪಾಯಿಂಟ್ ಔಟ್ ಮಾಡಿದ್ದು
2 ವರ್ಷ
1988. ಅದಾದ್ಮೇಲೆ 2006 ಅಲ್ಲಿ ಅಮೆಂಡ್ಮೆಂಟ್ ಆಗಿದೆ.
ಓಕೆ ಸರ್,
ದಟ್ ವಿಲ್ ಬಿ ಅಪ್ಲಿಕಬಲ್ ಅಂತ ಅವರು ಈ ಪಾಯಿಂಟ್.
2ನೇ ವರ್ಷ ಸೆಮೆಸ್ಟ್ರಿ ನಲ್ಲಿ ಕನ್ವರ್ಟ್ ಮಾಡಿದಾಗೆ 3 ಮತ್ತು 4 ಆಗುತ್ತೆ. 2ನೇ ವರ್ಷದ ಡಿಪ್ಲೊಮಾ
4ನೇ ಸೆಮಿಸ್ಟರ್ ಬೆರಳಚ್ಚು ತೇರ್ಗಡೆ
ಅದು 2ನೇ ವರ್ಷದಾಗುತ್ತೆ.
ಕರೆಕ್ಟ್.
2ನೇ ವರ್ಷದಂದ್ರೆ ಮತ್ತೆ 3 ಮತ್ತು 4 ಆಗುತ್ತೆ.
ಕರೆಕ್ಟ್.
3 ಮತ್ತು 4 ಏನಿದೆ ಅಲ್ಲ ಅದು ಜೂನಿಯರ್ ಗ್ರೇಡ್ ಅಂತ ಇನ್ನು ಕೆಲವೊಂದಿಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ ಸರ್. ಇದರಲ್ಲಿ ನೋಡಿ 3 ಮತ್ತು 4 ಸೆಮೆಸ್ಟ್ರಿ ಕೆಳಗಡೆ ಏನಿದೆ ಅಲ್ಲ ವಾಣಿಜ್ಯ ಪರೀಕ್ಷೆ ಬೆರಳಚ್ಚು ಪ್ರಥಮ ದರ್ಜೆಗೆ ಜೂನಿಯರ್ಗೆ ತತ್ಸಮಾನ ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ. ಕೆಳಗಿನಲ್ಲಿ ಕೂಡ ಇದು ಕೊಟ್ಟಿದ್ದಾರೆ. ಕೆಳಗಡೆ ಇದೆ ಸರ್ ಸರ್ಕಾರಿ ಮಹಿಳಾ ಪಾಲಿಟೆಕ್ನಿಕ್ ಬೆಂಗಳೂರು ಅಂತ
ಸಪರೇಟ್ ಅದರ
ಅಲ್ಲಿ 3, 4 ಜೂನಿಯರ್ ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ. ಮತ್ತೆ ಈ ಕಡೆ ಮೈಸೂರದವ್ರಿಗೆ ಬಿ CPC ಸರ್ಕಾರಿ ಪಾಲಿಟೆಕ್ನಿಕ್ ಮೈಸೂರು ಅಂತಿದೆ, ಅಲ್ಲಿಯೂ ಕೂಡ 3 ಮತ್ತು 4 ಅದು ಜೂನಿಯರ್ ಅಂತ ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ದಾರೆ. ಜೂನಿಯರ್ ಇದೆ ಇವರು
ಎಲ್ರಿ
ಸರ್. ಇದು ಕೆಳಗಡೆ
2006
ಅದ್ರ ಕೆಳಗಡೆ ಅದು ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅಂದ್ರೆ 1999 2000
99 2000 ಇದೆ ಅಲ್ಲ ಅದರೊಳಗೆ ಫಸ್ಟ್ ಕಾಲಮ್ ನಲ್ಲಿ ಬೆರಳಚ್ಚು 3 ಮತ್ತು 4ನೇ ಸೆಮೆಸ್ಟ್ರಿ.
ವಿ ಆರ್ ನಾಟ್ ಕನ್ಸರ್ನ್ಡ್ ವಿತ್ ದಟ್.
ಬೆರಳಚ್ಚು
ಪ್ರಥಮ ದರ್ಜೆಗೆ ಸಮಾನ.
ಅದನ್ನ ಈ ಕಡೆ ಹಾಕಿದ್ದಾರೆ, ಇದನ್ನ ಆ ಕಡೆ
ಸರ್ಕಾರಿ ಮಹಿಳಾ ಪಾಲಿಟೆಕ್ನಿಕ್ ಬೆಂಗಳೂರು 99/2000 ಸ್ವಾಯತ್ತತೆ ಪಡೆದಿದೆ. ಇದು ಅವರಿಗಷ್ಟೇ ಅಪ್ಲಿಕೇಬಲ್. ಇದು
ಇದರಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದಾರೆ, ಅವರು ಕೂಡ ಇದರಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದಾರೆ. ಇಲ್ಲಿ 3rd ಮತ್ತು 4th ಪ್ರಥಮ ದರ್ಜೆಗೆ ಜೂನಿಯರ್ ಕಾರಣಕ್ಕೆ ಸಮಾನ ಅಂತ ಹೇಳ್ತಾರೆ. ಇಲ್ಲಿ 4th ಸೆಮಿಸ್ಟರ್ ಏನಂತಾರೆ ಪ್ರೌಢ ದರ್ಜೆಗೆ ಸಮಾನ ಅಂತ ಹೇಳ್ತಾರೆ. ಇಲ್ಲಿ 4th ಇದ್ದುದು, ಇಲ್ಲಿ 4th ಇರೋದು ಜೂನಿಯರ್. ಇಲ್ಲಿ ಇವ್ರು ಸೀನಿಯರ್ ತೋರಿಸ್ತಾರೆ, ಇಲ್ಲಿ ಜೂನಿಯರ್ ತೋರಿಸ್ತಾರೆ. ಇಲ್ಲಿ ಇರ್ತಕ್ಕಂಥದ್ದು ಕನ್ಫ್ಯೂಷನ್. ಇದರಿಂದ ಇದು ಆಗ್ತಾ ಇರಿ, ಇದು ಮಿಸ್ಲೀಡ್ ಆಗ್ತಾ ಇರ್ತದೆ.
ಯಾವಾಗ ಈ ನೋಟಿಫಿಕೇಶನ್ ಇಶ್ಯೂ ಆಗಿರೋದು?
2016 ನವೆಂಬರ್ 16
ನೀವು ಇದಕ್ಕೆ ಗುದ್ದಾಡ್ತಾ ಇದ್ದೀರಾ? Yes. While considering such grievance.
Yes, sir.
While considering such grievance, where a recruitment process is challenged, courts are required to consider only whether the authority has followed the requisite procedure. We are not concerned with the outcome of the result. Courts are only concerned to find out whether the procedure is followed. Now they are able to point out that this is the information available. Accordingly, we have done. ಅಷ್ಟೇ, ಅದ್ರ ಮೇಲೆ ನಾವೇನು ಮಾಡಕ್ ಬರೋದಿಲ್ಲ.
ಓಕೆ.
Yes.
DPR ದವರು KPSC ದವರಿಗೆ 30/4/2019 ಒಂದು ಪತ್ರ ಬರ್ತದೆ, ಅದು ಹಚ್ಚಿದ್ದಾರೆ ಅವರು. 30/4/2019 R1 ಅಂತಿದೆ. ಅದರಲ್ಲಿ ಪೇಜ್ 3 R1 ಪೇಜ್ 3
ಔಟ್ಪುಟ್ ಇಸ್
KPSC ದವ್ರು ಹಚ್ಚಿದ್ದಾರೆ.
ಹಾ,
ಅದರಲ್ಲಿ ಅವರು ಹೇಗೆ ಕೌಂಟ್ ಮಾಡ್ಬೇಕು ಅಂತ ಹೇಳಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಅಲ್ಲಿ ಏನಾಗಿದೆ ಅಂತಂದ್ರೆ, ಪ್ರಥಮದ PUC ಅಥವಾ ಇತರೆ ತತ್ಸಮ
ಯಾವ ಪೇಜ್ ರೀ?
ಪೇಜ್ ನಂಬರ್ ಸರ್, ಇದು ಅಡಿಷನಲ್ ಆಗಿ ಹಚ್ಚಿದ್ ಸರ್. R1 ಅನಕ್ಷರ್ಸ್
ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಬ್ಜೆಕ್ಷನ್ ಜೊತೆಗೆ ಅಲ್ಲಲ್ಲ.
ಸರ್, ಅದು ಇನ್ನೊಂದು ಕೇಸ್ ಇದೆಯಲ್ಲ, ಆ ಕೇಸ್
petition ಅಲ್ಲಿ annexure R1.
Yes. ಹಾ,
ಪೇಜ್ 3 ಸೀರಿಯಲ್ ನಂಬರ್ 1. PUC ಅಥವಾ ಇತರೆ ತತ್ಸಮಾನ ವಿದ್ಯಾರ್ಹತೆಯನ್ನು ಹೊಂದಿರುವ ಅಭ್ಯರ್ಥಿಗಳು ಸದರಿ ವಿದ್ಯಾರ್ಹತೆಯಲ್ಲಿ ಗಳಿಸಿದ ಅಂಕಗಳು ಶೇಕಡಾವಾರು ಹಾಗೂ ಕರ್ನಾಟಕ ರಾಜ್ಯ ಪ್ರೌಢ ಶಿಕ್ಷಣ ಪರೀಕ್ಷಾ ಮಂಡಳಿ ವತಿಯಿಂದ ನಡೆಸುವ ಕನ್ನಡ ಬೆಳಚು ಸೀನಿಯರ್ ಪರೀಕ್ಷೆಗಳಲ್ಲಿ ಗಳಿಸಿದ ಅಂಕಗಳು ಶೇಕಡಾವಾರು. ಈ ಶೇಕಡಾವಾರುಗಳನ್ನು ಪ್ರತ್ಯೇಕವಾಗಿ ಲೆಕ್ಕ ಹಾಕಿ ನಂತರ ಅವುಗಳನ್ನು ಒಟ್ಟುಗೂಡಿಸಿ ದೊರಕುವ ಸರಾಸರಿ ಶೇಕಡಾವಾರನ್ನು ಅಂಕಗಳನ್ನು ಪರಿಗಣಿಸುವುದು ಅಂತ ಹೇಳಿದೆ. ಯುವರ್ ಆನರ್, ಪೇಜ್ ನಂಬರ್ 137. ಸರ್, ಇದರಲ್ಲಿ ಸೀರಿಯಲ್ ನಂಬರ್ 11 ಇದೆ. PUC ಮತ್ತು ಟೈಪ್ ರೈಟಿಂಗ್ ಅಂತ ಎರಡು ತೋರಿಸಿದೆ.
ಪೇಜ್ ನಂಬರ್
137.
32. ಏನ್ 32 ಇಲ್ವೇ ಇಲ್ಲ ಪೇಜ್
ಸರ್, ಫಸ್ಟ್ ಕೇಸ್
ಏನಪ್ಪ ಹಂಗೆ
ಸರ್, ಡಾಕ್ಯುಮೆಂಟ್ ಅದ್ರೊಳಗೆ ಹಚ್ಚಿದ್ದಾರೆ.
132.
ಸೀರಿಯಲ್ ನಂಬರ್ 11 ಚೆನ್ನಪ್ಪ ಅಂತಿದೆಯಲ್ಲ, ಅದು PUC ಮತ್ತು ಟೈಪ್ ರೈಟಿಂಗ್ ಸೀನಿಯರ್ ಅಂತ ಎರಡು ತೋರಿಸಿದೆ. ಇದನ್ನ PUC, ITI, GOC ಎಲ್ಲರಿಗೆ ಈಕ್ವಲ್ ಆಗಿ ಸೇಮ್ ಆಗಿ ಕೌಂಟ್ ಮಾಡಿದ್ದಾರೆ. ಇದೇ ರೀತಿ ತೋರಿಸಿದ್ದಾರೆ ಎಲ್ಲರಿಗೂ. ಇನ್ ಸೀರಿಯಲ್ ನಂಬರ್ 2 ಇವರನ್ನು ಪೇಜ್ ನಂಬರ್ 3 ಅಲ್ಲಿ ಡಿಪ್ಲೊಮಾ ಇನ್ ಕಮರ್ಷಿಯಲ್ ಪ್ರಾಕ್ಟೀಸ್ ಇಂಗ್ಲಿಷ್ ವಿದ್ಯಾರ್ಹತೆಯನ್ನು ಹೊಂದಿರುವ ಅಭ್ಯರ್ಥಿಗಳು
ಎಲ್ಲಿ
ಸರ್ R1 ಒಳಗೆ.
ಮತ್ತೆ ಈ ರೆಫರಿಂಗ್ annexure R1
R1
R1 ಇದೇ ತಾನೆ R1.
123 page 123 connected.
123.
Yes.
ಸೆಕೆಂಡ್ ಪಾಯಿಂಟ್, ಡಿಪ್ಲೊಮಾ ಇನ್ ಕಮರ್ಷಿಯಲ್ ಪ್ರಾಕ್ಟೀಸ್ ಇಂಗ್ಲಿಷ್ ವಿದ್ಯಾರ್ಹತೆಯನ್ನು ಹೊಂದಿರುವ ಅಭ್ಯರ್ಥಿಗಳು ಸದರಿ ವಿದ್ಯಾರ್ಹತೆಯ ಎಲ್ಲಾ ಪರೀಕ್ಷೆಗಳಲ್ಲಿ ಗಳಿಸಿದ ಒಟ್ಟು ಅಂಕಗಳ ಶೇಕಡಾವಾರು ಹಾಗೂ ಕರ್ನಾಟಕ ರಾಜ್ಯ ಪ್ರೌಢ ಶಿಕ್ಷಣ ಪರೀಕ್ಷಾ ಮಂಡಳಿ ವತಿಯಿಂದ ನಡೆಸುವ ಕನ್ನಡ ಬೆಳಚು ಸೀನಿಯರ್ ಪರೀಕ್ಷೆಗಳಲ್ಲಿ ಗಳಿಸಿದ ಅಂಕಗಳ ಶೇಕಡಾವಾರು. ಈ ಶೇಕಡಾವಾರುಗಳನ್ನು ಪ್ರತ್ಯೇಕವಾಗಿ ಲೆಕ್ಕ ಹಾಕಿ ನಂತರ ಅವುಗಳನ್ನು ಒಟ್ಟುಗೂಡಿಸಿ ದೊರಕುವ ಸರಾಸರಿ ಶೇಕಡಾವಾರು ಅಂಕಗಳನ್ನು ಪರಿಗಣಿಸುವುದು. ಪೇಜ್ ನಂಬರ್ 67. ಫಸ್ಟ್ ಪೇಜ್
60.
2
62.
ಹಾ.
ಹಾ.
ಸೀರಿಯಲ್ ನಂಬರ್ 60 ಇದೆ, 60.
ಹ್ಮ್.
ಅದರಲ್ಲಿ ಡಿಪ್ಲೊಮಾ ಇನ್ ಕಮರ್ಷಿಯಲ್ ಪ್ರಾಕ್ಟೀಸ್ ಬ್ರಾಕೆಟ್ ನಲ್ಲಿ ಇಂಗ್ಲಿಷ್ ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಹ್ಮ್.
ಇದು ಡಿಪ್ಲೊಮಾ ಕಮರ್ಷಿಯಲ್ದು ಪರ್ಸೆಂಟೇಜ್ ಮತ್ತು ಸೆಕೆಂಡರಿ ಬೋರ್ಡ್ ನಿಂದ ಮಾಡಿರ್ತಕ್ಕಂಥ ಕನ್ನಡ ಟೈಪ್ ರೈಟಿಂಗ್ ಎರಡು ಕೂಡಿಸಿ ತೆಗೆದಿರ್ತಕ್ಕಂಥ ಪರ್ಸೆಂಟೇಜ್ ಅಂತ ತೋರಿಸಿದ್ದಾರೆ.
ಹ್ಮ್.
ಯುವರ್ ಆನರ್, ಅದೇ R1 ಅಲ್ಲಿ ಸೀರಿಯಲ್ ನಂಬರ್ 3.
ಹ್ಮ್.
ನೇಮಕಾತಿ ಉದ್ದೇಶಕ್ಕಾಗಿ ಡಿಪ್ಲೊಮಾ ಇನ್ ಕಮರ್ಷಿಯಲ್ ಪ್ರಾಕ್ಟೀಸ್ ಕೋರ್ಸಿನ ಪರೀಕ್ಷೆಗಳಲ್ಲಿನ ಕನ್ನಡ ಬೆಳಚು ಮತ್ತು ಸಿರಿಲಿಪಿ ಪರೀಕ್ಷೆಗಳನ್ನು ಕರ್ನಾಟಕ ರಾಜ್ಯ ಪ್ರೌಢ ಶಿಕ್ಷಣ ಪರೀಕ್ಷಾ ಮಂಡಳಿಯ ನಡೆಸುವ ಕನ್ನಡ ಬೆಳಚು ಮತ್ತು ಸಿರಿಲಿಪಿ ಪರೀಕ್ಷೆಗಳಿಗೆ ತತ್ಸಮಾನವೆಂದು ಪರಿಗಣಿಸತಕ್ಕದ್ದು ಎಂದು ದಿನಾಂಕ 9/11/2006 ಸರ್ಕಾರದ ಆದೇಶ.
ಅದೇನೆ, they are referring to the same
ಅದೇ
modified
ಅದರದೇ ಇದೆ.
yes.
ಆದೇಶಿಸಲಾಗಿದೆ ಹಾಗೂ ಅದರಲ್ಲಿ ತತ್ಸಮಾನತೆ ಈಕ್ವಲೆನ್ಸ್ ವಿವರಗಳನ್ನು ನೀಡಲಾಗಿದೆ. ಆದುದರಿಂದ ಡಿಪ್ಲೊಮಾ ಇನ್ ಕಮರ್ಷಿಯಲ್ ಪ್ರಾಕ್ಟೀಸ್ ಕನ್ನಡ ವಿದ್ಯಾರ್ಹತೆಯನ್ನು ಹೊಂದಿರುವ ಅಭ್ಯರ್ಥಿಗಳು ಆ ವಿದ್ಯಾರ್ಹತೆಯ ಎಲ್ಲಾ ಪರೀಕ್ಷೆಗಳಲ್ಲಿ ಗಳಿಸಿದ ಒಟ್ಟು ಅಂಕಗಳನ್ನು ಶೇಕಡಾವಾರು 1983 ಸದರಿ ನಿಯಮಗಳ ನಿಯಮ 321 ರಂತೆ ಇದನ್ನ ಡಿಪ್ಲೊಮಾದ ಅಂಕಗಳಂತೆ ಮತ್ತು ದಿನಾಂಕ 9/11/2006 ಸರ್ಕಾರದ ಆದೇಶದಲ್ಲಿ ಕರ್ನಾಟಕ ರಾಜ್ಯ ಪ್ರೌಢ ಶಿಕ್ಷಣ ಪರೀಕ್ಷಾ ಮಂಡಳಿ ನಡೆಸುವ ಪ್ರೌಢ ದರ್ಜೆಯ ಸೀನಿಯರ್ ಕನ್ನಡ ಬೆರಳಚ್ಚು ಪರೀಕ್ಷೆಗೆ ತತ್ಸಮಾನವೆಂದು ನಿಗದಿಪಡಿಸಲಾದ ಪರೀಕ್ಷೆಗಳಲ್ಲಿ ಪಡೆದ ಅಂಕಗಳ ಶೇಕಡಾವಾರು 1983 ಸದರಿ ನಿಯಮಗಳ ನಿಯಮ 32B ರಂತೆ ಪ್ರತ್ಯೇಕವಾಗಿ ಲೆಕ್ಕ ಹಾಕಿ ನಂತರ ಅವುಗಳನ್ನು ಒಟ್ಟುಗೂಡಿಸಿ ದೊರಕುವ ಸರಾಸರಿ ಶೇಕಡಾವಾರು ಅಂಕಗಳನ್ನು ಪರಿಗಣಿಸುವುದು. ಯುವರ್ ಆನರ್, ಪೇಜ್ ನಂಬರ್ 61.
61. ಹಾ.
ಸೀರಿಯಲ್ ನಂಬರ್ 55.
55.
ಹಾ. ದುರ್ಗಾಶ್ರೀ ಅಂತಿದೆ. ಇಲ್ಲಿ ಡಿಪ್ಲೊಮಾ ಕಮರ್ಷಿಯಲ್ ಪ್ರಾಕ್ಟೀಸ್ ಮತ್ತೆ ಸೆಕೆಂಡರಿ ಬೋರ್ಡ್ ನಿಂದ ಮಾಡಿರ್ತಕ್ಕಂಥ ಟೈಪ್ ರೈಟಿಂಗ್ ತೋರಿಸಿದ್ದಾರೆ. ಎರಡು ತೋರಿಸಿದ್ದಾರೆ. ಆದ್ರೆ ಧನರಾಜ್ ಗುಬ್ಬಿ ಅವ್ರದ್ದು ಪೇಜ್ ನಂಬರ್ 134.
134.
ಹಾ. ಸೀರಿಯಲ್ ನಂಬರ್ 6 ಧನರಾಜ್ ಗುಬ್ಬಿ ಅಂತ. ಇವ್ರದ್ದು ಕೇವಲ ಡಿಪ್ಲೊಮಾ ಇನ್ ಕಮರ್ಷಿಯಲ್ ಪ್ರಾಕ್ಟೀಸ್ ಅಂತ ತೋರಿಸಿದ್ದಾರೆ. ಇಲ್ಲಿ ಇವ್ರದ್ದು ಟೈಪ್ ರೈಟಿಂಗ್ ಏನು ತೋರಿಸಿಲ್ಲ. ಆದ್ರೆ ಇಲ್ಲಿ 61ನೇ ಪೇಜ್ ನಲ್ಲಿ ಟೈಪ್ ರೈಟಿಂಗ್ ಸೀನಿಯರ್ ಸೆಕೆಂಡ್ ಇಯರ್ ಇದರಿಂದ ಮಾಡಿರ್ತಕ್ಕಂಥದ್ದು ಟೈಪ್ ರೈಟಿಂಗ್ ತೋರಿಸಿದ್ದಾರೆ. ಇವರೇನ DPR ದವ್ರು ಏನ್ ಹೇಳಿದ್ದಾರೆ, ಪ್ರತ್ಯೇಕವಾಗಿ ಲೆಕ್ಕ ಹಾಕಿ ಅಂತ PUC ಯಲ್ಲೂ ಕೂಡ ಹೇಳಿದ್ದಾರೆ, PUC ಮಾಡಿದವ್ರಿಗೆ ಭೀ ಹೇಳಿದ್ದಾರೆ. ಮತ್ತೆ ಡಿಪ್ಲೊಮಾ ಕಮರ್ಷಿಯಲ್ ಇಂಗ್ಲಿಷ್ ಅವರಿಗೂ ಕೂಡ ಪ್ರತ್ಯೇಕವಾಗಿ ಲೆಕ್ಕ ಹಾಕಿ ಟೈಪ್ ರೈಟಿಂಗ್ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಇದರಲ್ಲೂ ಕೂಡ ಪ್ರತ್ಯೇಕವಾಗಿ ಲೆಕ್ಕ ಹಾಕಿ ಟೈಪ್ ರೈಟಿಂಗ್ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಇದರ ಅರ್ಥ ಡಿಪ್ಲೊಮಾ ಕಮರ್ಷಿಯಲ್ದು ಅದ್ರ ಪರ್ಸೆಂಟೇಜ್ ತೋರಿಸ್ಬೇಕು ಮತ್ತು ಟೈಪ್ ರೈಟಿಂಗ್ ಪರ್ಸೆಂಟೇಜ್ ತೋರಿಸ್ಬೇಕು ಅಂತ ಅನ್ನೋದಿದೆ. ಅದ್ರೊಳಗಿಂದ ಅಂಕಗಳನ್ನು ಹೊರಗೆ ತೆಗೆದು ಕೂಡಿಸಿ ಅಂತ ಎಲ್ಲಿ ಹೇಳಿಲ್ಲ. ಇದು DPR ದವರೇ ಹೇಳಿರ್ತದೆ. ಈ DPR ದವ್ರಿಗೆ ಇವರು KATಯಲ್ಲಿ ಇದನ್ನು ಹಾಕಿದ್ರು. ಹಾಕದ ನಂತರ ನಾ DPR ದವರಿಗೆ ಮಾಹಿತಿ ಹಕ್ಕಿನ ಪ್ರಕಾರ ನಾನು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದೆ. ಅವ್ರು ಏನ್ ಮಾಡಿದ್ರು, ನಾವು ಆ ರೀತಿ ಹೇಳಿಲ್ಲ ಅಂತಂದಾಗ ನಾನು ಮತ್ತೆ ಅದಕ್ಕೆ ಫಸ್ಟ್ ಅಪೀಲ್ ಹಾಕ್ತೆ. ಫಸ್ಟ್ ಅಪೀಲ್ ಹಾಕಿದಾಗ DPR ದವ್ರು ಏನ್ ಮಾಡಿದ್ರು, ಕರೆದ್ರು. ನಿಮ್ಗೆ ಏನ್ ಡೌಟ್ ಇದ್ರು ಕೂಡ ನೀವು ಇಲ್ಲೇ ಬನ್ನಿ ಅಂತ. ಅಲ್ಲಿ ಹೋದಾಗ ನಾನು ಅಲ್ಲಿ ವಿಧಾನಸೌಧ ಹೋದಾಗ ನಿಮ್ ಪ್ರಾಬ್ಲಮ್ ಏನು ಅನ್ನೋದು ಸ್ಪಷ್ಟವಾಗಿ ಹೇಳಿ ಅದಕ್ಕೆ ಆನ್ಸರ್ ಮಾಡ್ತೀವಿ ಅಂತಂದಾಗ
ಇವರಲ್ಲಿ ಸೆಕೆಂಡ್ ಕೇಸ್ ಇದೆಯಲ್ಲ ಇನ್ನೊಂದು ಅಟ್ಯಾಚ್ಡ್, ಅದರಲ್ಲಿ ಅವ್ರು ಮಾರ್ಕ್ಸ್ ಕಾರ್ಡ್ ಎಲ್ಲ ಕೊಟ್ಟಿದ್ರು. ಆ ಮಾರ್ಕ್ಸ್ ಕಾರ್ಡು ಮತ್ತೆ KPSC ದವರು ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಮಾಡಿರ್ತಕ್ಕಂಥ ಸೀಟ್ ನಾ ಎರಡೂ ತೋರಿಸಿ ಹೇಳಿದೆ. ಒಂದು ನಿಮಿಷ. KPSC ದವ್ರು ಹೇಳ್ತಾ ಇರೋದು, ನೀವು ಕೂಡಿಸಿ ಅಂಕಗಳನ್ನೇ ಕೂಡಿಸಿ ಅಂತ ಹೇಳಿದ್ದೀರಾ ಅಂತ ಅವ್ರು ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಕೋರ್ಟ್ನಲ್ಲೂ ಕೂಡ ಅದೇ ರೀತಿ ವಾದ ಮಾಡಿದ್ದಾರೆ. ನೀವು ಆ ರೀತಿ ಹೇಳಿದ್ದೀರಾ ಅಂತಂದಾಗ ಅವ್ರಂದ್ರು, ನಾವು ಆ ರೀತಿ ಏನೂ ಹೇಳಿಲ್ಲ, ಕೇವಲ ವಿದ್ಯಾರ್ಥಿ ಕುರಿತು ಅಷ್ಟೇ ಹೇಳಿದ್ವಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಅದೊತ್ತಿಗೆ ಫಸ್ಟ್ ಅಪೀಲ್ದು ಅವರು ಆದೇಶ ಕೂಡ ಮಾಡಿದ್ದಾರೆ, ಅದ್ರ ಪ್ರತಿ ಕೂಡ ಇದೆ. ಪೇಜ್ ನಂಬರ್ 2 ಇವರ ಹಿಂದೆಗಡೆ ಮೇಲ್ಮನವಿದಾರರು ಕರ್ನಾಟಕ ನಾಗರಿಕ ಸೇವಾ ಶೀಘ್ರಲಿಪಿಗಾರರು ಮತ್ತು ಬೆಳ್ಳಚ್ಚುಗಾರರ ನೇಮಕಾತಿ ನಿಯಮ 1983 ನಿಯಮ 3ರನ್ವಯ ವಿದ್ಯಾರ್ಥಿ ಅಂಕಗಳನ್ನು ಪರಿಗಣಿಸುವಾಗ ಡಿಪ್ಲೊಮಾ ಇನ್ ಕಮರ್ಷಿಯಲ್ ಪ್ರಾಕ್ಟೀಸ್ ಕನ್ನಡ ವಿದ್ಯಾರ್ಥಿಯ 4ನೇ ಸೆಮಿಸ್ಟ್ರಿನಲ್ಲಿ ಬೆರಳಚ್ಚು ಪ್ರೌಢ ದರ್ಜೆಯ ಅಂಕಗಳನ್ನು ಒಳಗೊಂಡಿರುವುದರಿಂದ ಸದರಿ ವಿದ್ಯಾರ್ಥಿಯನ್ನು PUCಗೆ ವಿದ್ಯಾರ್ಥಿಗೆ ತತ್ಸಮಾನವೆಂದು ಪರಿಗಣಿಸುವಾಗ ಪ್ರೌಢ ದರ್ಜೆಯ ಬೆಳ್ಳಚ್ಚಿನ ಅಂಕಗಳನ್ನು ಪ್ರತ್ಯೇಕವಾದ ವಿದ್ಯಾರ್ಥಿ ಎಂದು ಪರಿಗಣಿಸಿ ಲೆಕ್ಕ ಹಾಕಿದಲ್ಲಿ ಪ್ರೌಢ ದರ್ಜೆಯ ಬೆಳ್ಳಚ್ಚಿನ ಅಂಕಗಳು 2 ಬಾರಿ ಲೆಕ್ಕ ಹಾಕಿದಂತಾಗುತ್ತದೆ. ಈ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಡಿಪ್ಲೊಮಾ ಇನ್ ಕಮರ್ಷಿಯಲ್ ಪ್ರಾಕ್ಟೀಸ್ ಕನ್ನಡ ವಿದ್ಯಾರ್ಥಿಯ 4ನೇ ಸೆಮಿಸ್ಟ್ರಿನಲ್ಲಿ ಪ್ರೌಢ ದರ್ಜೆಯ ಅಂಕಗಳನ್ನು ಒಳಗೊಂಡಿರುವುದರಿಂದ ಸದರಿ ವಿದ್ಯಾರ್ಥಿಯನ್ನು PUCಗೆ ತತ್ಸಮಾನವೆಂದು ಮಾತ್ರ ಪರಿಗಣಿಸಿ ಲೆಕ್ಕ ಹಾಕುವಂತೆ ಕೋರಿರುತ್ತಾರೆ. ಆದರೆ ಕರ್ನಾಟಕ ನಾಗರಿಕ ಸೇವಾ ಶೀಘ್ರಲಿಪಿಗಾರರು ಮತ್ತು ಬೆಳ್ಳಚ್ಚುಗಾರರ ನೇಮಕಾತಿ ನಿಯಮ 1983ರ ನಿಯಮ 3ರಲ್ಲಿ ಶೀಘ್ರಲಿಪಿಗಾರರು ಮತ್ತು ದತ್ತಾಂಶ ನಮೂದು ಸಹಾಯಕರ ಕನಿಷ್ಠ ಸರ್, ಈಗ ಅದು ಟೈಪಿಸ್ಟ್ ಇದ್ದು ದತ್ತಾಂಶ ಅಂತ ಮಾಡಿದ್ದಾರೆ. ಕನಿಷ್ಠ ಮತ್ತು ತತ್ಸಮಾನ ವಿದ್ಯಾರ್ಥಿಯ ಕುರಿತಷ್ಟೇ ಉಪಬಂಧಿಸಲಾಗಿದ್ದು ಸದರಿ ವಿದ್ಯಾರ್ಥಿಗಳ ಅಂಕಗಳನ್ನು ಹೇಗೆ ಪರಿಗಣಿಸಬೇಕೆಂಬ ಬಗ್ಗೆ ವಿಸ್ತೃತವಾಗಿ ವಿವರಣೆ ನೀಡಲಾಗಿರುವುದಿಲ್ಲ. ಆಯ್ಕೆ ಪ್ರಾಧಿಕಾರಿಗಳು ಅವರ ಹಂತದಲ್ಲಿ ನಿಯಮಾನುಸಾರ ಈ ಬಗ್ಗೆ ಕ್ರಮ ವಹಿಸಬೇಕಾಗಿರುತ್ತದೆ. ಅವಶ್ಯಕತೆ ಇದ್ದಲ್ಲಿ ಸರ್ಕಾರದ ಸ್ಪಷ್ಟತೆ ಅಥವಾ ಅಭಿಪ್ರಾಯಗಳನ್ನು ಕೋರಬಹುದಾಗಿರುತ್ತದೆ ಎಂದು ಮೇಲ್ಮನವಿದಾರರಿಗೆ ತಿಳಿಸಿ ಪ್ರಕರಣವನ್ನು ಮುಕ್ತಾಯಗೊಳಿಸಲಾಗಿದೆ. ಕೂಡಿಸಿ ಅಂಕಗಳನ್ನೇ ಕೂಡಿಸಿ ಅಂತ ಅವ್ರು ಹೇಳಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಇವರು ಕೂಡಿಸಿ ಅಂಕಗಳನ್ನೇ ಕೂಡಿಸಿದ್ದಾರೆ. ಅವ್ರು ಹೇಳಿ ಪ್ರಕಾರ ಅಲ್ಲಿ ಡಿಪ್ಲೊಮಾದಲ್ಲಿ ನಾನು 61 ಪೇಜ್ನಲ್ಲಿ ತೋರಿಸಲ್ಲ, ಡಿಪ್ಲೊಮಾ ಮತ್ತೆ ಕನ್ನಡ ಟೈಪ್ ರೈಟಿಂಗ್ ಎರಡೂ ಕೂಡಿಸಿದ್ದಾರೆ, ಎರಡೂ ತೋರಿಸಿದ್ದಾರೆ ಅಲ್ಲಿ ಕ್ವಾಲಿಫಿಕೇಶನ್. ಆದ್ರೆ ಧನರಾಜ್ ಗುಬ್ಬೆ ಅವ್ರದ್ದು 134 ಪೇಜ್ನಲ್ಲಿ ಕೇವಲ ಒಂದೇ ಒಂದು ಕ್ವಾಲಿಫಿಕೇಶನ್ ತೋರಿಸಿದ್ದಾರೆ. ಅದಕ್ಕೆ 72.53 ಅಂತ ತೋರಿಸಿದ್ದಾರೆ ಪರ್ಸೆಂಟೇಜು. ಅಷ್ಟು ಪರ್ಸೆಂಟೇಜ್ ಇಲ್ಲ ಅವ್ರದ್ದು, ಕೇವಲ 59.06 ಆಗುತ್ತೆ. ಅದು ಪಿಟಿಷನರ್ ಪರ್ಸೆಂಟೇಜ್ಗಿಂತ ಕಡಿಮೆ, 64.83% ಪಿಟಿಷನರ್ ದೊಡ್ಡದು. ಎಷ್ಟೇ ಇವರು.
Yes.
My lord, he has pointed at, my lord, page number 61, where, my lord, serial number 55, he, my lord, has studied diploma in commercial practice, also, my lord, in senior typewriting. In the very same page, my lord, serial number 52, in another candidate, my lord, where it is, my lord, it has been shown as diploma in commercial practice. Not only this, the private respondent is shown, my lord, diploma in commercial practice.
Page number 50?
My lord, page number 61. 61. Serial number, he referred serial number 55.
Yes.
ಅದರಲ್ಲಿ ಸೀನಿಯರ್ ಟೈಪ್ ರೇಟಿಂಗು.
Yes.
ಅದರ ಅವರು ಸೀನಿಯರ್ ಟೈಪ್ ರೇಟಿಂಗ್ ಕ್ವಾಲಿಫೈ ಇದ್ರಪ್ಪ, ಓದಿದ್ರ ಅಂತಂದ್ರೆ, ಮೈ ಲಾರ್ಡ್, ಇಟ್ ಹ್ಯಾಸ್ ಬಿನ್ ಶೋನ್.
ಅಲ್ಲಿ ಅದರಲ್ಲಿ ಸೀರಿಯಲ್ ನಂಬರ್ 52 ಅಲ್ಲಿ ಶ್ರುತಿ ಅಂತ ಅವರೊಬ್ರು ಅವರು ಡಿಪ್ಲೊಮಾ ಇನ್ ಕಮರ್ಷಿಯಲ್ ಪ್ರಾಕ್ಟೀಸ್
ಅಷ್ಟೇ.
ಅಷ್ಟೇ ಮೇಡಮ್. ಯಾರು ಕ್ವಾಲಿಫೈ ಅಡಿಷನಲ್ ಕ್ವಾಲಿಫೈ ಇತ್ತು ಅದನ್ನ ರೆಫರ್ ಮಾಡಿದ್ದಾರೆ, ಯಾರ್ದಿಲ್ಲ ಅದನ್ನ ಡಿಪ್ಲೊಮಾ ಇನ್ ಕಮರ್ಷಿಯಲ್ ಪ್ರಾಕ್ಟೀಸ್ ಇಂದಾನೆ 4th ಸೆಮಿಸ್ಟರ್ ತಗೊಂಡ್ಬಿಟ್ಟು ಮಾಡಿದ್ದಾರೆ. ದಟ್ ಇಸ್ ಓನ್ಲಿ.
Your Honor, your
Not that, my lord, only the third respondent has shown this qualification. There are several, my lord, candidates.
ಸರ್ ಅವ್ರ ಕ್ವಾಲಿಫಿಕೇಶನ್ ಕೇಳಿದ್ದನ್ನ ಫುಲ್ಫಿಲ್ ಅಂತ ಮಾಡೇ ಇಲ್ಲ, ಕೇವಲ ಒಂದು ಕ್ವಾಲಿಫಿಕೇಶನ್ ಮಾತ್ರ ಫುಲ್ಫಿಲ್ ಮಾಡ್ತಾ ಇರೋದು. ಅವ್ರು ಕೇಳಿರ್ತಕ್ಕಂಥದ್ದು ಕನ್ನಡ ಟೈಪ್ ರೈಟಿಂಗ್ ಸೀನಿಯರ್ ಗ್ರೇಡ್ ಪಾಸ್ ಆಗ್ಲೇಬೇಕನ್ನೋದು ಕಂಡೀಷನ್ ಇದೆ, ಅದು ಫುಲ್ಫಿಲ್ ಮಾಡಬೇಕು. ಇವರು ಡಿಪ್ಲೊಮಾನೇ ನಾನು PUC ಅದನ್ನೇ ತೋರಿಸ್ತೀನಿ, ಟೈಪ್ ರೈಟಿಂಗು ಅದನ್ನೇ ತೋರಿಸ್ತೀನಿ ಅಂತಂದ್ರೆ ಇದು ಅಸಮಾನತೆ ಆಗುತ್ತೆ. ಆಪರ್ಚುನಿಟಿ ಕೊಡೋದ್ರಲ್ಲಿ ಅಸಮಾನತೆ ಆಗುತ್ತೆ. ಉಡ್ಸಿ ಅಂಕಗಳನ್ನೇ 2 ಸಲ ಕೂಡಿಸ್ದಂಗ.
You have not come with any citation, any judgment to support your contention? ಬರ್ಬೇಕ್ರಿ, ಇವೆಲ್ಲ ಮಾಡ್ಬೇಕ್ರಿ. ನೀವೆಲ್ಲ ಯಂಗ್ಸ್ಟರ್ಸ್ ರೀ, ಸ್ವಲ್ಪ ಎಫರ್ಟ್ ಹಾಕ್ಬೇಕು. You have understood what is the case?
Yes.
Then you should think how it can be attacked. As I said earlier, these are all cases where the courts are required to consider only whether the procedure is followed and they have not done anything special in respect of one person trying to give more marks and or do something to reduce the marks from some other candidate. Atara yen madilla. They whatever they have understood, if this is the procedure prescribed and we have accordingly done it, and we have not done anything beyond what is permissible. Ee taradu any number of judgments you will get.
Yes, yes. But
you should come with the judgment so that our work will become easier.
But my lord, the notification is very clear, my lord, because
Kudare,
that's why
ultimately, how do we write a judgment? How do we write a judgment? Huh? All right.
Your Honor,
Third.
ಇನ್ನೊಂದು ವಿಷಯ, ಒನ್ ಮೋರ್ ಸಬ್ಮಿಷನ್.
ಹೇಳಿ.
ಪೇಜ್ ನಂಬರ್ 144 ಅವರು ಓದಿದ್ದಾರೆ. ಅದರಲ್ಲಿ 2 ವರ್ಷನ್ ಇದೆ. 2 ವರ್ಷನ್ ಸೇರಿಸಿ ಒಂದೇ ವರ್ಷನ್ ಅಂತ ಓದಿದ್ದಾರೆ. ಅದರಲ್ಲಿ 2 ವರ್ಷನ್ ಇದೆ. ಒಂದು ಡಿಪ್ಲೊಮಾ ಕಮರ್ಷಿಯಲ್ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡಿಲ್ಲ, ಡಿಪ್ಲೊಮಾ ಕಮರ್ಷಿಯಲ್ ನಲ್ಲಿ ಟೈಪ್ ರೈಟಿಂಗ್ ಮಾಡಲಾರ್ದು ಅಂತ 1 ವರ್ಷನ್ ಇದೆ. ಇನ್ನೊಂದು ಡಿಪ್ಲೊಮಾ ಕಮರ್ಷಿಯಲ್ ನಲ್ಲಿ ಟೈಪ್ ರೈಟಿಂಗ್ ಮಾಡಿದವರು ಅಂತ ಅನ್ನೋದು ಇನ್ನೊಂದು ವರ್ಷನ್ ಇದೆ. ಅದು ಸೆಕೆಂಡ್ ವರ್ಷನ್ ನಲ್ಲಿ 3 ವರ್ಷದ ಡಿಪ್ಲೊಮಾ ಇನ್ ಕಮರ್ಷಿಯಲ್ ಪ್ರಾಕ್ಟೀಸ್ ಅಥವಾ ತಸಮಾನ ವಿದ್ಯಾರ್ಥಿಯಲ್ಲಿ ಕನ್ನಡ ಬೆಳ್ಳಚ್ಚು ಮಾಡಿದ ಅಭ್ಯರ್ಥಿಗಳು ಅವರ ವಿದ್ಯಾರ್ಥಿಯಲ್ಲಿಯೇ ಕನ್ನಡ ಬೆಳ್ಳಚ್ಚು ವಿದ್ಯಾರ್ಥಿ ಸೇರಿರುವುದರಿಂದ ಆಯ್ಕೆಗೆ ಅವರ ಎಲ್ಲಾ ವರ್ಷದ ಅಥವಾ ಎಲ್ಲಾ ಸೆಮಿಸ್ಟರ್ಗಳಲ್ಲಿ ಗಳಿಸಿದ ಒಟ್ಟು ಶೇಕಡಾವಾರು ಅಂಕಗಳನ್ನು ಪರಿಗಣಿಸಲಾಗುವುದು. ಅಂದ್ರೆ ಅವ್ರದ್ದು ಎಲ್ಲಾ ಟೋಟಲಿ ಓವರ್ ಆಲ್ ಪರ್ಸೆಂಟೇಜ್ ತಗೋತೀನಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಅದ್ರ ಪ್ರಕಾರನೇ ಧನರಾಜ್ ಗುಬ್ಬೆ ಅವರು ಆನ್ಲೈನ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದರೆ ಅದರಲ್ಲಿ 5125 ಮಾರ್ಕ್ಸಿಗೆ 3022 ಮಾರ್ಕ್ಸ್ ತೋರಿಸಿದ್ದಾರೆ. ಪರ್ಸೆಂಟೇಜು 58.97 ಅಂತ ತೋರಿಸಿದ್ದಾರೆ ಆನ್ಲೈನ್. ಇದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕುವ ಸಂಬಂಧ 2016ರಲ್ಲಿ ನವೆಂಬರ್ 16ರಂದು ಅಪ್ಲಿಕೇಶನ್ ಬಿಟ್ಟಾಗ ಆವಾಗ ಫುಲ್ಫಿಲ್ ಮಾಡಿರ್ತಕ್ಕಂಥದ್ದು. ಇದನ್ನ ಪ್ಯಾರಾ ಓದ್ ಕೇಸನ್ನೇ ಅವ್ರು ಈ ರೀತಿ ಫುಲ್ಫಿಲ್ ಮಾಡಿದ್ದಾರೆ. ಇವರು ಮಾಡಿಲ್ಲ ಅಂತ ಕೇಸನ್ನ ಹೇಳ್ತಾ ಇದ್ರಲ್ಲ, ಇದರಲ್ಲಿ ಡಿಪ್ಲೊಮಾ ಕಮರ್ಷಿಯಲ್ ಮಾಡಿದ್ರು, ಅದಕ್ಕೋಸ್ಕರನೇ ಅವ್ರು ಅಷ್ಟು ಪರ್ಸೆಂಟೇಜ್ ತೋರಿಸಿದ್ರು.
All right. Third reserve.
On submission, my lordship. On submission, my lordship. On submission. What officer can say? Recruitment man. Then tell. Wow, not what other. ಮುಂಚಿನ CK proceedings ಅಂತ ಕ್ಲೋಸ್ ಮಾಡ್ತಾರೆ. ನಾವೇ ಕ್ಲೋಸ್ ಮಾಡೋಲ್ಲ. ಅದನ್ನ ಪಾರ್ಟಿಗೆ ಮಂಗಳವಾರ ಬುಧವಾರ ಸ್ಟಾರ್ಟ್
ಇಲ್ಲ ಅಂದ್ರೆ ನೀವು 2:30ಗೆ ಮುಂಚೆನೆ 2 ಕಾಲಂಗೆ ಓಪನ್ ಮಾಡ್ಕೊಳ್ಳಿ ಸರ್ ಮೊಬೈಲ್ ಅಲ್ಲಿ ಮಾಡ್ಕೊಬಿಟ್ಟು ಇವ್ರು ಬರ್ತಾರೆ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಅವ್ರಿಗೆ ಕೇಳಿ ನಾನು ಏನಾದ್ರು ಇವಾಗ ಸಬ್ಮಿಷನ್ ಮಾಡ್ಬೋದಾ ನಮ್ಗೆ ಅರ್ಜೆನ್ಸಿ ಇದೆ ಮ್ಯಾಟ್ರು ಅಂತ ಅವ್ರಿಗೆ ಏನಾದ್ರು ಇನ್ಫಾರ್ಮೇಶನ್ ಇದ್ರೆ ಅವ್ರು ನಿಮ್ಗೆ ಹೇಳ್ತಾರೆ.
ಅವ್ರು ಇಷ್ಟ ಇಂಪಾರ್ಟೆಂಟ್ ಮಾಡಲ್ಲ ಅಂತ ಇವಾಗ ಅವ್ನಿಗೆ ಹೇಳೋಣ ಡೇಟ್ ಕೊಡಿ ಅಂತಾರೆ ಅಂತ.
ಅಲ್ಲ ನಾವು ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಎಂಗೇಜ್ ಮಾಡಿದೀವಿ ಅವರು ಮಂಗಳವಾರ ಅಥವಾ ಬುಧವಾರ ಹಾಕ್ಸ್ಕೊಳ್ಳಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಅದಕ್ಕೋಸ್ಕರ ನಾನು ಒಂದು ಸಬ್ಮಿಷನ್ ಮಾಡ್ಬೋದಾ ಅಂತ ಕೇಳಿ ಅವ್ರ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಏನ್ ಸಜೆಸ್ಟ್ ಮಾಡ್ತಾರೆ ನೋಡಿ. ಅದೇ ಬೆಸ್ಟ್ ಸರ್.
ಅಲ್ಲೇ ಹೇಳ್ಸಿದೆ
ಎಲ್ಲಿ
ಅಲ್ಲೇ ಅದ್ರಲ್ಲೇ ನಮ್ಮ
ಹಂಗೂ ಮಾಡ್ಬೋದು ಕೇಳ್ಬಿಟ್ಟು ಇದ್ ಮಾಡಕ್ ಹೇಳಿ. ಅವ್ರು ಹೆಂಗು ಅಲ್ಲೇ ಊಟ ಮಾಡ್ತಾ ಇರ್ತಾರೆ ಅಲ್ಲೇ ಕೇಳಕ್ ಹೇಳಿ.
ಮುನ್ನ ಇಲ್ಲ ನಮ್ಮ ಫ್ರೆಂಡ್ ಹೇಳಕ್ ಹೇಳ್ತೀನಿ
ಸರ್. ಹಾ ಸರ್ ಅಲ್ಲೋಗಿ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಹತ್ರ ಕೇಳಕ್ ಹೇಳಿ. ಅವ್ರು ಮೇಡಮ್ ಹೋಗಿರ್ತಾರೆ ಪಾಪ ಮನೆಗೆ.
ಹೌದು ಅಂತ ಇಲ್ಲ ಸರ್ ನಾನು. ಹಲೋ ಸರ್ ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಇದ್ದೀರಾ ಸರ್? ಅದೇ ಇವಾಗ ಡೇಟ್ ಇದ್ ಮಾಡಿದಾರೆ, ಅದಕ್ಕೆ ಒಂದು ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ಕೊಂಡು 2:30ಗೆ ಅದೇ ಸೀನಿಯರು. ಹಾ ಅಲ್ಲಲ್ಲ ಇವಾಗ ನಾಳೆ ನೆಕ್ಸ್ಟ್ ವೀಕಲ್ಲಿ ಬರುತ್ತಲ್ಲ, ಅದು ಮಂಗಳವಾರ ಇಲ್ಲ ಬುಧವಾರ ಸೀನಿಯರ್ ಬರ್ತಾರೆ, ಅದಕ್ಕೆ ಅವತ್ತು ಲಿಸ್ಟ್ ಮಾಡಿ ಅಂತ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿ ಅಂತ ಅನ್ನೋದಕ್ಕೆ. ಇಲ್ಲಿವರು ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಬ್ಲಾಕ್ ಮಾಡೋರು ಇಲ್ಲಿ, ಅದಕ್ಕೋಸ್ಕರ ನಾನು ಇಲ್ಲಿ ರೀಸೆಂಟ್ ಇವಾಗ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಎಂಗೇಜ್ ಮಾಡಿದ್ವಿ ಸಮಯ ಸೀರಿಯಲ್ ನಂಬರ್ 28 ಇವತ್ತು ಅಡ್ಜರ್ನ್ ಆಗಿದೆ. ಅದಕ್ಕೆ ನೆಕ್ಸ್ಟ್ ವೀಕಲ್ಲಿ
First door matters. CL number 8, Harshvardhan R. Malipati.
Your Lordship, kindly pass. Senior is held up in VC, Your Lordship. One matter, he is appearing through VC in the before the principal bench. He is appearing for a different matter before the principal bench. Your Lordship, may kindly pass, Your Lordship.
Mission.
This matter, my lord, your lordship, last occasion, your lordship has heard this matter, my lord. Only, my lord, reinstatement, my lord, your lordship is denied. Learned single judge directed the, my lord, appellant to reinstate. So that one, my lord, has to be modified. That's all, my lord. Even other side also, my Patil also agreed for that one also.
Yes.
Mahesh Patil, Mantesh Patil is agreed for that one.
It was adjourned at his instance, my lord. My lord, this was a case where I submitted that, my lord, since the disciplinary inquiry was, my lord, not in, my lord, order, the matter is remitted back. My lord, there are certain serious allegations against, my lord, this my lord, person, my lord, where he had, my lord, changed the municipal records, and, my lord, one road, my lord, belonging to the, my lord, layout is, my lord, renumbered, and, my lord, it is made in his name. My lord, therefore, my lord, I requested that if it can be, his reinstatement can be deferred by, my lord, 6 months. By that time, my lord, we'll conclude the inquiry, and if he is found, my lord, otherwise we'll take him, my lord.
Instead of 6 months, it may be taken, instead of 6 months, my lord, within 3 months, it may be completed.
Because, my lord, that inquiry process will take time. Last occasion also, because of the short time, my lord, they did not do that, my lord, in a proper manner. Certain documents were not furnished, and for that reason, it was again set back. My lord, we'll try to do that within 3 months only, but, my lord, the outer limit could be fixed at 6 months, my lord. That reinstatement could be deferred, my lord, till then. Now the order is for, my lord, reinstatement. Paragraph 10, my lord, page 11. What has happened is, my lord, about 11 charges are leveled. Against, my lord, 6 charges, my lord, whatever documents were sought for were given. As against, my lord, certain other charges, my lord, we could not, my lord, furnish all the documents which he had sought for. Lord, and, my lord, since he was, my lord, held guilty of all the 11 charges, court said that, my lord, it was not proper.
Where are the charges?
And, my lord, is the eighth charge, my lord.
Berkeley. The chief officer of the town municipal council, Sedam, is before this court in this intra-court appeal. Calling in question the order passed by the learned single judge in writ petition number 202701 of 2017, dated 9th of September 2024. Full stop. Next para. Learned counsel for the appellant submits that the learned single judge has held that the writ petitioner was not furnished with documents relating to all the 11 charges, and he was given documents only in respect of certain charges. And it is also noticed in the said order that the probability of securing the documents in relation to the other charges was not feasible in the immediate future. And he was called upon to submit his reply in respect of the documents which have already been furnished to him. Full stop. The learned single judge is convinced that unless the documents are given to the writ petitioner, he will not be in a position to give an effective reply. Full stop. Therefore, the learned single judge has directed a reinstatement of the writ petitioner into service, while granting liberty to the appellant to hold an inquiry into the allegations that are made, by supplying all the necessary documents, and thereafter to proceed in accordance with law. Full stop. Next para. However, learned counsel for the appellant draws the attention of this court to charge number 10 in the memo of charges, and submits that a serious allegation has been made against the petitioner, who was working as
Lord Clerk,
FD.
FDM. He was on temporary basis, my Lord, as computer operator
computer operator
on temporary basis.
in the municipality.
Yes.
And
Computer operator and work inspector, my Lord. His designation, my Lord,
computer operator
and
and
work
inspector.
inspector.
And taking advantage of his position, he has illegally entered his name in respect of an immovable property measuring 45 into 14 feet, by assigning a new number, assigning sub numbers 4-9-79/1 and 4-8-64/1. Which property is actually part of a public road.
Yes, ma'am.
Full stop. The learned counsel would therefore submit that although the appellant is willing to proceed to conduct inquiry against the writ petitioner while supplying all the requisite documents, nevertheless, it is submitted that a reinstatement of the writ petitioner into service would cause serious dent into the inquiry. Full stop. Moreover, with such serious charges, the petitioner should not have access to any of the documents in the municipality. Full stop. Therefore, learned counsel for the appellant would submit that that part of the order passed by the learned single judge may be modified while retaining the other portion of the order where documents are directed to be supplied to the writ petitioner and thereafter conduct the inquiry. Full stop. Next paragraph. He has been out of service from when?
2013.
Huh?
2013.
13.
4/7/2013.
Moreover, the writ petitioner has been out of service from the year 2013. Stop. Next paragraph. Learned counsel for the writ petitioner and private respondent number 1 does not dispute the fact that the writ petitioner has been out of service for more than 9 years now.
11 years.
11 years.
11 years.
For more than 11 years now. Stop. Next paragraph. Having regard to the submissions made by the learned counsel for the appellant, we are of the considered opinion that the request made by the learned counsel for the appellant should be acceded to. Full stop. The Honorable Supreme Court has held that the provision for placing an employee under suspension is mainly for the reason that such employee should not gain access to relevant documents. Full stop. In the present context, it would not be permissible to reinstate the writ petitioner and give a posting outside the municipality. Full stop. Therefore, we accede to the submission made by the learned counsel for the appellant. Full stop. Next paragraph. Consequently, we proceed to allow the appeal partly while modifying the orders passed by the learned single judge. To the extent that the direction issued to reinstate the writ petitioner into service is set aside. Full stop. The appellant shall furnish necessary documents to the writ petitioner, as directed by the learned single judge, and thereafter proceed to conduct the inquiry and conclude the same as expeditiously as possible and at any rate within a period of 4 months from the date of receipt of a copy of this order. Full stop. Ordered accordingly.
What's in the morning, I requested that since he has made an allegations against the fourth respondent,
Huh?
In the, my lords, the fourth respondent is the authority who is holding the, my lords, inquiry.
Deputy Commissioner.
Deputy Commissioner ಅಲ್ಲ, writ petition ಅಲ್ಲಿ the CEO, my lords, Chief Officer of Town Municipal Council. The writ petition fourth respondent.
ಅದಲ್ರಿ ಯಾವಾಗ ಅಲಿಗೇಷನ್ ಮಾಡಿದ್ವಿ, ಏನ್ ಮೇಲೆ ಅಲಿಗೇಷನ್ ಮಾಡಿದ್ರಿ ನೀವು?
ಅವ್ರ ಮೇಲೆ ಇದು relating to the, my lords, reinstatement, he has demanded some bribe ಅಂತ, he has made an allegations to the ಲೋಕಾಯುಕ್ತ.
Reinstatement.
ಇದಾದ್ಮೇಲೆ
ಯಾವಾಗ?
ಆರ್ಡರ್ ಆದ್ಮೇಲೆ there is, my lords, order. After the order, since my lords, anyway he has made some allegations against the ಲೋಕಾಯುಕ್ತ.
Petition order ಆದ್ಮೇಲೆ.
As per the learned single date.
That was, my lords, because of that reason he will be, my lords, having some bias against him. Even if the inquiry held,
I don't think will be conducted by the chief officer.
earlier also he himself was
Conducting the chief the inquiry.
No, that will
ಅವಾಗ
be.
ಅವರೇ ಮಾಡಿದ್ರು. ಮೊದಲು ಕೂಡ ಅವರೇ.
Lord, he is a temporary, my lord, employee. Anyhow, my lord, I will instruct that, my lord, it should be conducted
Last time
by
only
some
they
third
had
party.
the chief officer, only the officer who has not passed the order.
Next para. At this juncture, learned counsel for the writ petitioner, respondent number 1 herein, submits that the writ petitioner has made some allegations against the incumbent chief officer of the town municipal council, SEDM. And therefore, he would request that the inquiry should be held by any other person other than the present incumbent chief officer of the town municipal council, SEDM. Full stop. Next para. In the interest of justice, comma, the inquiry shall not be conducted by the incumbent chief officer of the town municipal council, comma, SEDM. Full stop. The director of municipal administration shall appoint any other person as inquiry officer, and the inquiry will be accordingly conducted.
But he was working on temporary basis, my lord, as a supervisor come work inspector, not.
ಅಲ್ಲಿ ಕಂಪ್ಯೂಟರ್ ಅಂತ ಏನೋ ಬಂತಲ್ಲ, ಅದನ್ನ ಚೇಂಜ್ ಮಾಡ್ಕೊಂಡು ಹೇಳಿ ಏನಂತ?
ಕಂಪ್ಯೂಟರ್ ಆಪರೇಟರ್ ಅಂತ ಬಂದಿತ್ತು ಸ್ವಾಮಿ, ಅದ್ರ ಬದಲಿ ವರ್ಕ್ ಇನ್ಸ್ಪೆಕ್ಟರ್ ಅಂಡ್ my lord ಬಾರ್ supervisor on a temporary basis, temporary employee. And one more request, my lord, lordships have directed to furnish the papers. My lord, papers as against allegations where the papers are not available, we are contemplating to drop that and, my lord, proceed again. That could be observed, my lord, because this will be taken as, my lord, the.
Yes.
Appellant is contemplating to, my lord, provide papers in and proceed against only, my lord, charges against which, my lord, we have the papers.
It is also permissible in law that while conducting the disciplinary inquiry, some of the charges can be dropped, if necessary evidence in that regard is not available with the disciplinary authority. Full stop. Therefore, if no evidence is available in respect to some of the charges as found in the charge memo, the disciplinary authority is permitted to proceed while dropping such charges where the documents are not available. Yes, great.
Number 20, Deepak P. Barad.
Lord, appear for the respondent, my lord. Lord, we filed the affidavit, my lord, complying the order of your lordships, my lord. Page number 4. Para number 14, your lordship's order, my lord, kindly see, my lord.
Because other day, the affidavit was filed by the government, my lord. Along with that, my lord, the calculation has been given, my lord, for promotional. There
Para
is-
14, your lordship's order, my lord. Para 14. Or consequently, while allowing the writ petition and set aside in the impugned order passed by the Karnataka so and so in application number and impugned endorsement dated 13/10/2019 at annexure 821. This court would direct the respondent authority to refix the retiral benefits of the petitioner while notioning granting promotion to the petitioner in accordance with Rule 2002 and pass necessary orders granting the arrears of retirement benefits payable to the petitioner accordingly. Kindly see, my lord, then, my lord, we prepared the everything that least, my lord, annexure, my lord, detailed orders came to be passed by the authority. That is, my lord, I produced along with my affidavit, my lord. That is page number 22, my lord. Order is passed, my lord, page number 22 in my affidavit, my lord. That is annexure R5. ಆದೇಶ, my lord. ಪೀಠಿಕೆಯಲ್ಲಿ ಔಷಧ ಶ್ರೀ ಇಸ್ರಾಮ್ ಎಸ್ ಕೊಡುಗೆ ನಿವೃತ್ತಿ ಮತ್ತು ಗುರುಗಳು ಸರ್ಕಾರಿ ಮಾದರಿ ಪ್ರಾಥಮಿಕ ಶಾಲೆ ಕಟಕ ಚಿಂಚೋಳಿ ಬಾಲ್ಕಿ ಬಿದರ್ ಇವರಿಗೆ ಪ್ರೌಢಶಾಲಾ ಸಹ ಶಿಕ್ಷಕರ ವೃಂದ ಮತ್ತು ನೇಮಕಾತಿ ನಿಯಮಗಳು 2002 ಆದೇಶ ದಿನಾಂಕ 24/6/2021 ರನ್ವಯ ಸದರಿಯವರಿಗೆ ದಿನಾಂಕ ದಿಸ್ ಇಸ್ ಇಂಪಾರ್ಟೆಂಟ್ 1/1/2004 ರಿಂದ ಪೂರ್ವಾನ್ವಯವಾಗುವಂತೆ ಪ್ರೌಢಶಾಲಾ ಸಹ ಶಿಕ್ಷಕ ಗ್ರೇಡ್ 1 ವೃಂದ ಗ್ರೇಡ್ 2 ಹಿಂದಿ ಭಾಷೆ ಹುದ್ದೆಗೆ 4575-8400 ವೇತನ ಶ್ರೇಣಿಯಲ್ಲಿ ಮುಮ್ಮಡಿತಿ ನೀಡಿ ಆದೇಶಿಸಿದೆ. ದೆನ್ ಮಲಾಡ್ ಶಿಕ್ಷಕರ ದಿನಾಂಕ 1/1/2004 ರಿಂದ ಅನ್ವಯವಾಗುವಂತೆ ಸಿಗಬೇಕಾದ ಅಭ್ಯರ್ಥಿ ಆರ್ಥಿಕ ಸೌಲಭ್ಯ ಮತ್ತು ಸೇವಾ ಸೌಲಭ್ಯಗಳು ಒದಗಿಸಲು ಸೂಕ್ತ ಕ್ರಮ ಕೈಗೊಳ್ಳುವಂತ ಆದೇಶಿಸಿದೆ. Thereafter, my lord, calculation sheet is produced by annexure R6, my lord. Entire calculation sheet is done. And we arrived that, my lord, entire amount is, my lord, we determined that amount also. Now, my lord, he filed the memo, my lord, stating that, my lord, our calculation is wrong.
ನೀವು ಫೈಲ್ ಮಾಡಿದ್ದೀರಾ?
The endorsement was challenged of may I, my lord. Endorsement was challenged 13/10/2009, my lord. The promotion was for the date, my lord, from 1/1/2009. Endorsement, I had filed an objection that, my lord, my name was not reflected in the promotion list in 5/9/2009, my lord. Thereafter, my lord, I had been given annexure A21, my lord, on 13/10/2009. Now, my lord, the government has taken, which is notional increment and promotion, which has been high school. I have to be promoted from primary school to high school grade 2, my lord. My lord, when the scale was revised, my lord, in 2004 itself, and that has been considered. In fact, my lord, I have given a calculation from
This one you
Yes.
filed it along with a memo?
No, my lord, just now I'm giving.
Please give it.
Yes.
Please give it along with the memo.
Yes.
On the previous occasion, learned government advocate had filed a memo along with an affidavit along with affidavit of the deputy director bracketally administration close department of school education Bidar along with a calculation sheet showing the arrears that would be payable to the complainant. Full stop. Learned counsel for the complainant had sought for some time to go through the said information and make submissions. Full stop. Next paragraph. Today, learned counsel for the complainant has filed a memo along with a calculation sheet prepared by the complainant and submits that there is a vast difference between the arrears calculated by the respondents and what is sought by the complainant. Full stop. Next para. The learned counsel is directed to serve a copy of the same on the learned government advocate, and the learned government advocate is directed to place the information at the hands of the respondents and obtain their
Please.
Response to the memo of calculation filed at the hands of the complainant. Full stop. List this matter after winter vacation.
Correct.
Yes.
Memo 47. Seal number 36. Mahesh Patil.
Additional Advocate General is held up in further argument is held up in another court, my lord.
Hmm?
Additional.
Same matter, the
My lord, this matter, my lord, wherein, my lord, I'm seeking, my lord, notional, my lord, promotion. We have, my lord, retired way back in 2013-14, my lord. The KT has, my lord, rejected our application, my lord, in 2018. And, my lord, here in identical matter, my lord, the tribunal has considered, my lord, and passed orders. The very same authority, my lord, on similar, my lord, all lines, my lord. And, my lord, by taking into consideration, my lord, the judgment of the Honorable Supreme Court and this court, my lord, the tribunal has allowed application in identical matters. Here, what I'm seeking, my lord, is only one increment, my lord, notionally. My lord, initially, my lord, we were, my lord, promoted, my lord, under Rule 32 of KCSR, both of us. My lord, we were appointed, my lord, in the year, my lord, 1973. Retired, my lord, both of us, my lord, in 2013 and 14, respectively. My lord, we were, my lord, initially given promotion, my lord, under Rule 32 of KCSR, my lord, as a reserve sub-inspector, from ARSI to reserve sub-inspector. Thereafter, my lord, we retired, my lord, in the year, my lord, 2013-14.
which is the impugned order?
My lord, of the KAT,
Annexure G na?
annexure C, my lord.
C.
My lord, annexure C, page 33.
March 2018.
Yes, my lord. This is of 2020, my lord, writ petition of 2020. We had challenged, my lord, their, my lord, endorsement, annexure A6, page 32.
There is a delay of more than 2 years
My lord,
in filing this writ petition.
both these, my lord, the petitioners, my lord, they are in, my lord, Kalaburagi. My lord, and my lord, they are retired, my lord, so thereafter. And my lord,
We have not heard this matter.
no, my lord. The only, my lord, here, my lord, what had happened, my lord, the Article 370 which came into
ಅವ್ರು ಇಲ್ವಲ್ಲ, he says the AG will argue the matter.
some other day.
Huh? At the request of learned additional government advocate, release this matter after winter vacation.
Serial number 37, Mahantesh Patil.
Yes.
Not in this matter, Kumar Ex-parte sir was appearing. Senior counsel.
2020.
Also.
At the request of learned counsel for petitioner, release this matter after winter vacation.
Serial number 41, Mahesh Patil.
No. But it is a case of, my lord, departmental inquiry. Wherein, my lord, been compulsory retired from service. My lord, here, my lord, the charges, my lord, where, my lord, that, my lord, I have, my lord, demanded and accepted bribe. But, my lord, here, my lord, even my lord, the criminal proceedings, my lord, I was acquitted. And, my lord, and even, my lord, in the departmental inquiry, my lord, all of the witnesses, my lord, have not supported. They have clearly said as to, my lord, I have not received, my lord.
Trap case.
Yes, my lord.
Trap case.
Trap case.
Trap case.
Trap case. And, my lord, the criminal proceedings, my lord, have ended in acquittal. And thereafter, my lord, this punishment was imposed. And even, my lord, all the witnesses, my lord, have, my lord, deposed in the same manner in the departmental inquiry as was saying as to, my lord, that, my lord, that have, my lord, the charges they have supported again, they are, my lord, not deposed against the, my lord, charges. And, my lord, and both, my lord, witnesses are same. My lord, the charges are same. And, my lord, may I, my lord, take to the relevant. My lord, may I take to PW1, my lord? Page 44.
Out bide, if they have not supported, there is no use of
PW1 has not
reading that.
Yes, madam.
But, my lord,
At least the shadow witness has stated.
I will take to the complainant, my lord, he has, my lord, not supported. Yeah.
Bide, ಆಯ್ತು.
Same. And coming to PW2, my lord, he is the, my lord, the punch witness. Lordship may kindly see, my lord, the page 51. Para 5 in the cross examination. My lord, ದೂರದಾರರು ಅಪಾಯಿತ ನೌಕರರನ್ನು ಭೇಟಿ ಮಾಡಿ 10 ನಿಮಿಷ ಅವಧಿ ನಂತರ ದೂರದಾರರು ಮತ್ತು ಅಪಾಯಿತ ನೌಕರರು ಕಚೇರಿಯಿಂದ ಹೊರಗೆ ಬಂದು ಶಾಬಾದ್ ರಸ್ತೆಯಲ್ಲಿರುವ ಹೋಟೆಲ್ಗೆ ಹೋಗುವ ಸಲುವಾಗಿ ಬೈಕ್ನಲ್ಲಿ ಹೊರಟರು. ರಾಜು ಮತ್ತು ಸಿಬ್ಬಂದಿ ಬಂದು ಬೈಕ್ನಲ್ಲಿ ನಾನು ಮತ್ತು ತನಿಖಾಧಿಕಾರಿಯು ಇತರೆ ಸಿಬ್ಬಂದಿ ಜೀಪ್ನಲ್ಲಿ ದೂರದಾರನು ಮತ್ತು ಅಪಾಯಿತ ಸರ್ಕಾರಿ ನೌಕರನ್ನು ಹಿಂಬಾಲಿಸಿಕೊಂಡು ಹೋಗಿದ್ದೆವು. ದೂರದಾರರು ಮತ್ತು ಅಪಾಯಿತ ಸರ್ಕಾರಿ ನೌಕರು ಅಶೋಕ್ ಹೋಟೆಲ್ ಒಳಗಡೆ ಹೋದರು. ನಾನು ತನಿಖಾಧಿಕಾರಿ ಮತ್ತು ಸಿಬ್ಬಂದಿ ಜೊತೆ ಹೋಟೆಲ್ನ ಹತ್ತಿರ ನಿಂತು ಸೂಚನೆಗಾಗಿ ಕಾಯುತ್ತಿದ್ದೆವು. ದೂರದಾರರು ಸೂಚನೆ ಕೊಟ್ಟ ಮೇರೆಗೆ ತನಿಖಾಧಿಕಾರಿ ಸಿಬ್ಬಂದಿಗಳು ಹೋಟೆಲ್ನಿಂದ ಹೊರಗೆ ಹೊರಡುತ್ತಿದ್ದು ಅಪಾಯಿತ ಸರ್ಕಾರಿ ನೌಕರು ವಶಕ್ಕೆ ಪಡೆದರು. ದೂರದಾರರು ಅಪಾಯಿತ ನೌಕರನ್ನು ತೋರಿಸಿ ತನ್ನಿಂದ ಹಣ ಪಡೆದ ಬಗ್ಗೆ ಹೇಳಿದರು. ತನಿಖಾಧಿಕಾರಿ ಅಪಾಯಿತ ನೌಕರನ್ನು ಹಿಡಿದುಕೊಂಡು ಹತ್ತಿರ ಇದ್ದ ಗಿಡದ ಒಳಗೆ ಕೂರಿಸಿ ಅಪಾಯಿತ ನೌಕರನ್ನು ಕೈಗಳನ್ನು ದ್ರಾವಣಗಳಿಂದ ತೊಳಿಸಿದಾಗ ದ್ರಾವಣ ಗುಲಾಬಿ ಬಣ್ಣಕ್ಕೆ ತಿರುಗಿತು. ತನಿಖಾಧಿಕಾರಿ ದ್ರಾವಣ ಬಾಟಲಿಗಳನ್ನು ತೋರಿಸಿ ಬಾಟಲಿಗಳಲ್ಲಿ ಶೇಖರಿಸಿ ಸೀಲ್ ಮಾಡಿ ವಶಕ್ಕೆ ಪಡೆದರು. ದಿಸ್ ಇಸ್ ದಿ the one of the witness. My lord, now, my lord, page 54. Page 54, my lord, 53, my lord, page para 10. DDPI ಕಚೇರಿಯಿಂದ ಅಶೋಕ್ ಹೋಟೆಲ್ಗೆ 1.5 ರಿಂದ 2 ಕಿಲೋಮೀಟರ್ ಅಂತರದಲ್ಲಿ ಇದೆ. ಹೋಟೆಲ್ ಹೊರಗಡೆ 10 ರಿಂದ 15 ಅಡಿ ದೂರದಲ್ಲಿ ರಾಜು ನಿಂತಿದ್ದರು ಎಂದರೆ ಸರಿ. ದೂರದಾರರು ಮತ್ತು ಅಪರಾಧ ಸರ್ಕಾರನು ಹೋಟೆಲ್ ಒಳಗಡೆ ಯಾವ ಸ್ಥಳದಲ್ಲಿ ಕುಳಿತಿದ್ದರು ಎಂದು ನಾನು ನೋಡಿಲ್ಲ. ಅಶೋಕ್ ಹೋಟೆಲ್ನಿಂದ ದೂರದಾರರು ಮತ್ತು ಅಪರಾಧ ಸರ್ಕಾರ ಹೊರಗೆ ಬಂದ ನಂತರ 25 ಮೀಟರ್ ದೂರದಲ್ಲಿ ಅಪರಾಧ ಸರ್ಕಾರವನ್ನು ವಶಕ್ಕೆ ಪಡೆಯಲಾಯಿತು ಎಂದರೆ ಸರಿ. ಸಾಯಿ ಶಕ್ತಿ ಜನರಲ್ ಸ್ಟೋರ್ಸ್ ಅಂಗಡಿ ಮುಂದೆ ಅಪರಾಧ ಸರ್ಕಾರಿ ನೌಕರರ ಕೈಗಳನ್ನು ದ್ರಾವಣದಲ್ಲಿ ತೊಳೆದಿದ್ದಾರೆ ಎಂದರೆ ಸರಿ. ಸದರಿ ಸ್ಟೋರ್ನಲ್ಲಿ ಇದ್ದ ವ್ಯಕ್ತಿ ನಾವು ಇದ್ದ ಸ್ಥಳಕ್ಕೆ ಬಂದಿರಲಿಲ್ಲ ಎಂದರೆ ಸರಿ. ಸದರಿ ಸ್ಟೋರ್ನಲ್ಲಿ ಮುಂದೆ 25 ನಿಮಿಷಗಳ ಕಾಲ ಇದ್ದೆವು ಎಂದರೆ ಸರಿ. ಸದರಿ ಸ್ಟೋರ್ನ ಮುಂದೆ ಯಾವುದೇ ಬರವಣಿಗೆ ಮಾಡಿಲ್ಲ ಎಂದರೆ ಮತ್ತು DDPI ಕಚೇರಿಗೆ ಹೋಗಲಾಯಿತು ಎಂದರೆ ಸರಿ. 11 ಅಪರಾಧ ಸರ್ಕಾರಿ ನೌಕರ ಬಳಿ ಇದ್ದ ಹಣವನ್ನು ಸಾಯಿ ಶಕ್ತಿ ಜನರಲ್ ಸ್ಟೋರ್ಸ್ ಮುಂದೆ ವಶಕ್ಕೆ ಪಡೆದಿದ್ದಾರೆ ಮತ್ತು ಅಪರಾಧ ಸರ್ಕಾರಿ ನೌಕರ ಶರ್ಟ್ DDPI ಕಚೇರಿಯಲ್ಲಿ ವಶಕ್ಕೆ ಪಡೆದು ಶರ್ಟ್ನ ಜೇಬಿನ ಭಾಗವನ್ನು ದ್ರಾವಣದಲ್ಲಿ ತೋರಿಸಿದ್ದಾರೆ ಎಂದರೆ ಸರಿ. ದೂರದಾರರು ಸ್ಟೋರ್ನ ಬಳಿ ವಾಯ್ಸ್ ರೆಕಾರ್ಡರ್ಗಳನ್ನು ತನಿಖಾಧಿಕಾರಿ ಕೊಟ್ಟಿಲ್ಲ ಎಂದರೆ ಸರಿ. ವಾಯ್ಸ್ ರೆಕಾರ್ಡರ್ಗಳಲ್ಲಿ ಇದ್ದ ಸಂಭಾಷಣೆಯನ್ನು DDPI ಕಚೇರಿಯಲ್ಲಿ ನಮಗೆ ಕೇಳಿಸಿಲ್ಲ. ವಶಕ್ಕೆ ಪಡೆದ ದಾಖಲಾತಿಗಳ ಬಗ್ಗೆ ನನಗೆ ಮಾಹಿತಿ ಇಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಸದರಿ ದಾಖಲಾತಿಗಳನ್ನು ನಾನು ಓದಿ ನೋಡಿಲ್ಲ. DDPI ಕಚೇರಿಯಲ್ಲಿ ತಯಾರಿಸಿದ ಪಂಚನಾಮೆ ಅಂಶಗಳನ್ನು ನಾನು ಓದಿ ತಿಳಿದಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. ದೂರುದಾರರು ಕೆಲಸಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟ ಕಡತ ಕಚೇರಿಯ ಮ್ಯಾನೇಜರ್ ಟೇಬಲ್ ಮೇಲೆ ಇತ್ತು ಎಂದರೆ ಸರಿ. ತನಿಖಾಧಿಕಾರಿ ಸದರಿ ಕಡತೆಯಿಂದ ದಾಖಲಾತಿಗಳ ಪ್ರತಿಗಳನ್ನು ಪಡೆದಿದ್ದಾರೆ ಎಂದರೆ ಸರಿ. This is the version of one of the the witnesses, who was not an eyewitness.
So he has not seen
Not seen. But here
person receiving the amount.
And subsequently when this his hands were washed, that has come. But here the complainant in this categorically he has stated in his even before the departmental inquiry and even before the criminal proceedings, very same version, saying as to page 46, page 46 for a moment. ಮೇಲಿಂದ ಪ್ಯಾರಾ 3 ನಾನು ಅಶೋಕ್ ಹೋಟೆಲ್ನಲ್ಲಿ ನಾನು ಮತ್ತು ಅಪರಾಧ ಸರ್ಕಾರನವರು ಚಹಾ ಕುಡಿದು ನನ್ನ ಪ್ಯಾಂಟ್ನ ಎಡೆ ಕಿಸೆಯಲ್ಲಿದ್ದ 12,000 ರೂಪಾಯಿಗಳನ್ನು ಅಪರಾಧ ಸರ್ಕಾರಿ ನೌಕರಿಗೆ ಕೊಡಲು ಹೋದಾಗ ಅಪರಾಧ ಸರ್ಕಾರಿ ನೌಕರು ತಡೆ ಎಂದು ಹೇಳಿ ಹಣವನ್ನು ಪಡೆದಿಲ್ಲ ಮತ್ತು ನಾನು ಹಣವನ್ನು ನನ್ನ ಪ್ಯಾಂಟಿನ ಎಡೆ ಕಿಸೆಯಲ್ಲಿ ಇಟ್ಟುಕೊಂಡೆ. ಹೋಟೆಲ್ನಿಂದ ನಾನು ಮೊದಲು ಹೊರಗೆ ಬಂದಾಗ ತನಿಖಾಧಿಕಾರಿ ಹಣದ ಬಗ್ಗೆ ವಿಚಾರಿಸಲಾಗಿ ನಾನು ಹಣ ನನ್ನ ಬಳಿ ಇರುವುದಾಗಿ ಮತ್ತು ಅಪರಾಧ ಸರ್ಕಾರ ನೌಕರು ಪಡೆದಿಲ್ಲವೆಂದು ತಿಳಿಸಿ ತನಿಖಾಧಿಕಾರಿಗೆ ಹಣವನ್ನು ತೆಗೆದುಕೊಟ್ಟಿದ್ದೇನೆ. This is the version of the complainant. And now in the criminal proceedings, all of this the very same witnesses, even he has deposed in the very same fashion even in the criminal proceedings. May I take lords to the relevant which is
No, but if you compare this statement with the statement that you just read out now.
Yes, ma'am. They
Is page number.
Yes, ma'am. PW2. Page 50. He has not stated with regard to. He admits that he was away from that place.
No. Paragraph number 6 ಅಲ್ಲಿ ದೂರುದಾರರು ಆಪಾದಿತ ನೌಕರರನ್ನು ತೋರಿಸಿ ತನ್ನಿಂದ ಹಣ ಪಡೆದ ಬಗ್ಗೆ ಹೇಳಿದರು. ತನಿಖಾಧಿಕಾರಿ ಆಪಾದಿತ ನೌಕರರನ್ನು ಹಿಡಿದುಕೊಂಡು ಹತ್ತಿರ ಇದ್ದ ಗಿಡದ ಕೆಳಗೆ ಕೂರಿಸಿ ಆ ನೌಕರರ ಕೈಗಳನ್ನು ದ್ರಾವಣದಲ್ಲಿ ತೊಳೆಸಿದಾಗ ದ್ರಾವಣ ಗುಲಾಬಿ ಬಣ್ಣಕ್ಕೆ ತಿರುಗಿತು.
Yes, sir. Only when
He has not even touched it.
Yes.
How will it turn pink?
Comprehensively, when his statement is read, PW2.
And from where it was?
And he says, PW2 says, as on that day, even the work was not pending. It was with the manager. Even that also, he has deposed at page 54. And even page 53, para 10 also. Page 53, para 10 and 11. He states in the cross-examination that the work was also not pending. It was the file was with the manager.
If that is the case, then where was the need for him to go and give a complaint to the Lokayukta?
But
in all these cases, we are seeing the same thing. This person will turn hostile. Complainant will turn hostile.
my lord, in, my lord,
All the cases, that is what we are seeing.
my lord, but my lord, in the,
And where was the need for him to go to the Lokayukta? Why did he go to the Lokayukta then?
He admits, my lord.
but going by his, my lord, deposition, and even, my lord, he is consistent, my lord, even in the criminal
Then
proceedings.
why did
also.
he go to the Lokayukta? For what?
My lord, here, my lord, maybe, my lord, that, my lord, his, my lord, work has not been done. But, my lord, here, page 54, my lord, it reveals, my lord, that, my lord, the file was, my lord, with the, my lord, the work of the, my lord, the, insofar as the complaint, my lord, it was over, insofar as the part of the petition is concerned.
That information, you can't depend on PW2. He is only a shadow witness.
Yes, my lord.
Our by ಇದನ್ನ ಹೇಳ್ಸೋದ್ರಲ್ಲಿ ಏನು ಅರ್ಥ ಇಲ್ಲ.
ಇಲ್ಲ, that
There is
was,
meaning in this.
this was fact, my lord. This is,
So
this
how
is,
can he speak about that?
but, my lord, the fact,
He is only a witness to the incident.
incident.
ಅಷ್ಟೇ.
uh,
ಅದನ್ನ ಬಿಟ್ಟು ಅವ್ರ ಬಾಯಲ್ಲಿ ಇದನ್ನೆಲ್ಲ ಹೇಳ್ಸೋದ್ರಲ್ಲಿ ಏನು ಅರ್ಥನೇ ಇಲ್ಲ.
But, my lord, that is not disputed with regard to, my lord, that as on that day, my lord, it was not, my lord, pending. But, my lord, now coming to the, my lord, the, even the criminal proceedings also, my lord, the very same, my lord, all of them, my lord, are,
Same circumstances, the same observation we have made, and we have passed one order.
but here, my lord, in the case on hand, my lord, these witnesses, my lord, are same, my lord. They have, my lord,
Correct, ಎಲ್ಲ same. All same, exactly same. But there the shadow witness said, I saw him receiving the money, keeping in his shirt pocket. He takes a stand. I did not take it. It was thrust into my pocket.
yes, my lord.
And they forced me to remove it from my pocket.
In every other case, my lord,
ಈ ತರ ಏನೋ ಒಂದು ಸ್ಟ್ಯಾಂಡ್ ತಗೋತಾರೆ.
my lord, in every other,
Complainant himself turns hostile. So therefore, the Supreme Court has observed in many such cases. Then why did he go to the Lokayukta then?
my lord, maybe,
He had to turn hostile subsequently. Firstly, where was the need for him to go to the Lokayukta?
my lord, maybe, my lord, that
There
is,
was no work pending,
my lord,
and there was no demand from the employee. Why should he go to the Lokayukta is the question.
my lord, maybe that, my lord, my lord, when, my lord, work, my lord, is not done, my lord, my lord, maybe that, my lord, his work is not done, my lord, he has approached. My lord, maybe that, my lord, there are other persons, my lord, who might be responsible, my lord, for a delay of his work. Maybe, my lord, there is, my lord, because, my lord, in the case on hand, my lord, it shows, my lord, as on that day, my lord, the work was not pending with him, and the file, my lord, already, my lord, his part is done, and it was lying on the, my lord, table of the manager.
Just spoken about that.
This PW2 is there, my lord.
PW2 ಬರೋದಿಲ್ರಿ.
Other.
He cannot speak about those documents.
PW1 except for that. Page 48.
My lord.
My lord,
Page
page,
40.
for a moment, my lord, page 186. My lord,
ಏನಿದು?
my lord, it is the, my lord, the order, my
Order
lord, in
the
the
criminal
criminal
court.
proceedings, order in the criminal proceedings.
ಹಾ.
Page 55. In the cross-examination of PW1, page 186, my
ಹಾ.
lord, in the cross-examination of PW1, as well as in the cross-examination of PW8, investigating officer, it is elicited that on 7/10/2014, the accused had recommended for considering the application of complaint regarding suspension period. There is evidence to show that the file was seized from the table of the superintendent and not from the table of the accused. The relevant file and other documents are at EXP P30. There is a note of accused on 7/10/2014. It is also admitted by the investigating officer and complainant that the accused had made a note for placing the material to consider the suspension period of the accused as leave period. Thus, the file had already reached main officer and there was no work pending before the concerned clerk. This was the, my lord, and my lord, here, page 53, my lord, page 184.
The complainant also is an employee.
Yes, my lord. Complainant is also
Co-employee.
is an employee, my lord. It appears, my lord, he is an employee. And my lord, page 53 also, my lord, the same version, my lord, page 53, page 184. My lord, para 53. There is only evidence of PW1 regarding demand made by the accused. So also the investigating officer PW8 has stated about the case. In the cross-examination, the complainant PW1 has admitted that while he was trying to give the amount to the accused had denied to receive the amount by pushing away the same with his hands. He has further stated that he has given this statement before the police, stating that accused has pushed away the amount. He has further stated that the police kept that amount in the shirt pocket of the accused.
Same set of allegation. Same set of stand taken by the.
But if there is some, my lord, deviation, my lord, in either of these proceedings, but my lord, in the instant case, my lord, my lord, lordship may kindly see, my lord, even 189, page 189, my lord, the witnesses, my lord, these all, my lord, are the same. Page 189, my lord, 1, 2, 3, my lord.
Maybe.
And my lord, the same, my lord, the version has come out, my lord, even before the in the criminal proceedings also. Now, my lord,
We have gone only by the evidence of the shadow witness.
my lord, comprehensively, my lord, only by that, my lord, they, my lord, because by that's the reason, my lord, as to why in the cross examination ಅವರು ಹೇಳ್ತಾರೆ ಇದರಲ್ಲಿ ದೂರ ತೋರಿಸಿ ಇದರಲ್ಲಿ ಒಂದೇ, my lord, as lordship have pointed out, ದೂರದಾರ ಅಪರಾಧವನ್ನು ತೋರಿಸಿ ತನ್ನಿಂದ ಹಣ ಪಡೆದ ಬಗ್ಗೆ ಹೇಳಿದರು ಅಂತ ಅಷ್ಟೇ ಇದೆ ಹೊರತು, my lord, nothing, my lord, comprehensively can be read, my lord, from PW2 statement.
PW2 is only a shadow witness, sir.
Yes, my lord.
Please understand. He can speak only about what he has seen. ಅಷ್ಟೇ, ಅದು ಬಿಟ್ರೆ ಬೇರೆ ಏನು ಇಲ್ಲ. Nothing else he can say. So he has stated very clearly, this is what I saw. He was brought from the hotel. He was asked to sit under a tree. His hands were washed. The amount was removed. His hands were washed. He turned into pink.
My lord, in every other case, my lord, when, my lord, even otherwise also, my lord, that procedure is done. My lord,
and this is the stand. Invariably, everyone are taking now. That is what we see. No, I didn't keep it in my pocket. They only kept it and asked me to remove it. Why should I remove? If you know that this is what is going to happen if I remove it, then why did he remove the money from the pocket? If he has not kept it in the pocket.
My lord, there is every possibility, my lord, but
The version of the complainant is that he did not receive it at all.
Yes, my lord.
I kept it back in my pocket. That is the version of the complainant.
Yes, my lord. That he has pushed away.
He pushed it away, so he didn't take it. I kept it back in my pocket. If that is so, how can his hand the color turn pink?
My lord, in every other case, my lord, even, my lord, they are made to, my lord, they are made to touch even later. My lord, that's what happens, my lord. In every other case, my lord, even otherwise also, I'm not saying, my lord, as to only in this matter.
Sir, what does the Lokayukta have to do? Why should they do it?
My lord, only to off the record, my lord, only lordship have pointed out.
Yes.
My lord, in every other matter, my lord, where, my lord,
See, the very
we haven't come across, my lord, where, my lord.
A fact that the person goes to the Lokayukta with a complaint against particular.
I do agree, my lord.
Employee.
There must be.
What does it say?
My lord, there must be some genuine complaint also, my lord. I do agree, my lord.
Yes.
But, my lord, the outcome of the proceedings in every other, my lord.
In this background, if you say, no, the complaint himself had turned hostile.
Not in all cases, my lord. Not in all cases.
In almost all the cases, that is what we are seeing. So therefore, the Supreme Court has held, if the shadow witness has spoken about the incident and that he has seen that he received the amount and he removed the amount and the test has turned positive, that is more than enough in a disciplinary proceedings.
But, my lord, the other circumstances, my lord, wherein with regard to, my lord, as on that day, my lord, the work was also not pending with him.
You'll note paragraph number 54. You read paragraph number 53 of the order of the magistrate. Please see paragraph number 54. That is why you have held that the standard of proof required
Is different. Yes,
in a
my lord.
criminal case is totally different. You please read paragraph 54.
Yes, my lord.
Odi.
My lord, there is also the evidence of shadow witness as well as the another punch witness, PW 2 and 3, to the effect that the currency notes were taken out from the shirt pocket of the accused. The question would be that whether there would be presumption under section 20 of the Prevention of Crime Act regarding possession of currency notes.
This
Yes,
is
my lord,
how-
that is there.
This is how the criminal
Yes, my lord.
court proceeds,
Yes, my lord.
not necessary in a disciplinary proceeding.
Not necessary, my lord, but there should be, my lord, some, my lord, evidence only, my lord, based on, my lord, recovery will, my lord, always be there. My lord, even otherwise, my lord, recovery will be always be there in every other matter, my lord. Apart from this, my lord, if, my lord, they would be able to, my lord, show, my lord, that the, my lord, the petitioner, my lord, has, my lord, indeed, my lord, demanded and accepted bribe.
I think it's high time we also make a provision wherever a complaint turns hostile like this, some serious consequences should
My lords,
ensue.
in some cases, they have perjurial ಹಾಕಿದ್ದಾರೆ
ಮಾಡಿದ್ದಾರೆ.
ಮಾಡಿದ್ರು. ಒಂದೆರಡು ಕೇಸ್ ಇದಾವೆ.
No. Provision itself should be made. In every case, this is what we are seeing. The complainant turns hostile. So therefore, the Supreme Court has observed, then why did he primarily go to the Lokayukta then? What does it show? ಆಗ್ತಾರೆ, ಎಲ್ಲ ಆಗ್ತಾರೆ. ಅದೇ ಮಾಡ್ತಿದಾರಲ್ಲ, ಎಲ್ಲ ಮಾಡ್ತಿದಾರೆ. This is what we are seeing.
ಸ್ಟೇಷನ್ಗೆ ಅಡ್ಮಿಟ್ ಮಾಡ್ಕೊಂಡು ನಾವು ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದೀವಿ.
ರೆಕಾರ್ಡಿಂಗ್ ಮಾಡ್ಬೇಕು, ವಾಯ್ಸ್.
Section 8 ಕೆಳಗೆ Section 8 ಒಂದು performance. ಕಂಪ್ಲೇಂಟ್ ಎಲ್ಲ ಬರ್ದು ಇವ್ರಿಗೆ ದುಡ್ಡು ಕೇಳ್ತಾರೆ ಮಾಡಿಲ್ಲ. ಅದಕ್ಕೊಂದು ಅಫಿಡವಿಟ್ ಹಾಕೊಂಡು ಕಂಟೆಂಟ್ ಅದನ್ನ ಎಲ್ಲಿ ಪ್ಲೇಸ್ ಮಾಡೋದು ಮಾಡಲ್ಲ, ಅದನ್ನ ಕೊಟ್ಟಿರ್ತಾರೆ.
My lord, kindly see P33 punch witness statement, my lord, page 56.
No, even the magistrate, learned magistrate has observed so.
Yes, man.
PW2, PW3 have
Yes.
spoken so.
He has seen taking
But
money.
it turns it takes a different turn because the standard of proof required there is different.
Yes.
Before
Can there be a presumption ಅಂತ ಹಂಗ ಹೋಗ್ತಾರ ಅವರು?
Before Lokayukta complainant, my lords, at page number 48, the complainant accepts, my lords, may I read the second parallel. ಆಸಾ ನೌಕರನ ಅಂಗಿಯ ಜೇಬಿನ ಭಾಗವನ್ನು ದ್ರವಣದಲ್ಲಿ ತೊಳೆದಾಗ ಗುಲಾಬಿ ಬಣ್ಣಕ್ಕೆ ಬದಲಾಯಿತು ಅಂದ್ರೆ ಸರಿ.
Page number?
Page number
48.
48? ಯಾರ್ದಿದು?
ಇದು ಡಿಪೋಸಿಷನ್ ಆಫ್ ದ ಕಂಪ್ಲೇನೆಂಟ್.
Complainant.
In cross examination.
Party ಸವಾಲ.
Party ಸವಾಲ್.
ನೀವು
Yes, my lord.
ಬೈ
Prosecutor.
ಪ್ರಾಸಿಕ್ಯೂಟರ್ ಅವರು ಕೇಳಿದಾಗ ಒಪ್ಪುತ್ತಾರೆ. ಆಸಾ ನೌಕರ ಅಂಗಿ ಜೇಬಿನ ಭಾಗವನ್ನು ದ್ರವಣದಲ್ಲಿ ತೊಳೆದಾಗ ಗುಲಾಬಿ ಬಣ್ಣಕ್ಕೆ ಬದಲಾಯಿತು ಅಂದ್ರೆ ಸರಿ.
ತನಿಖಾಧಿಕಾರಿ ಆಪಾದಿತ ನೌಕರರ ಹತ್ತಿರ ಹಣದ ಬಗ್ಗೆ ಕೇಳಲಾಗಿ, ಅದು ಓದಿ ಅಲ್ಲಿಂದ. ಸೆಕೆಂಡ್ ಪ್ಯಾರಾಗ್ರಾಫ್.
ಕೇಳಲಾಗಿ ತನ್ನ ಅಂಗಿ ಕಿಸೆಯಲ್ಲಿ ಇರುವುದಾಗಿ ತಿಳಿಸಿದೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಸಾಕ್ಷಿ ರಾಜು ಅವರು ನನ್ನ ಮೂಲಕ ಹಣವನ್ನು ಕೊಟ್ಟು ಆಸಾ ನೌಕರ ಅಂಗರ ಕಿಸೆಯಲ್ಲಿ ತೆಗೆದು ವಶಕ್ಕೆ ಪಡೆದಿದ್ದಾರೆ ಅಂದರೆ ನೋಡಿಲ್ಲ. ನಾನು ನನ್ನ ಪ್ಯಾಂಟಿನ ಎಡೆ ಕಿಸೆಯಲ್ಲಿದ್ದ ಹಣವನ್ನು ತನಿಖೆಯರಿಗೆ ವಾಪಸ್ ಕೊಟ್ಟ ಬಗ್ಗೆ ಸುಳ್ಳು ಸಾಕ್ಷಿ ನೀಡುತ್ತೇನೆ ಅಂದರೆ ಸರಿಯಲ್ಲ. He accept that he has given back to the enquiry officer. The next line, my lords, he says, ಆಸಾ ನೌಕರ ಅಂಗಿ ಜೇಬ ಭಾಗವನ್ನು ದ್ರವಣದಲ್ಲಿ ತೊಳೆದಾಗ ಬಣ್ಣ ಗುಲಾಬಿ ಬಣ್ಣಕ್ಕೆ ಬದಲಾಯಿತು ಅಂದ್ರೆ ಸರಿ.
Then how did it
ಆಮೇಲೆ
go there?
DDP ಕಚೇರಿಯಲ್ಲಿ
When, it is this version, my lord, that when it is given, my lord,
ವಾಪಸ್ ಬಂದಾಗ
my lord, he has pushed away and my lord, he has not taken it. And late,
Then how can the shirt pocket turn pink?
my lord, in every other, my lord, case, my lord, when it is recovered, my lord, they
This
again,
is what we are saying. In every other case, this is what we are seeing.
ಅದು
Imagine the
ಅದು ಆಮೇಲೆ
complainant
recover-
himself turning hostile.
ನೋಡಿ ಆಮೇಲೆ ಅದು ರಿಕವರಿ ತೋರಿಸ್
Go to the ಲೋಕಾಯುಕ್ತ.
maybe that he is having a genuine complaint about that his work has not been done.
Then how can it turn
But
hostile?
it necessarily, my lord, it cannot be, my lord, always, my lord, the now in the case on and, my lord, the accused, my lord, the DJO himself. There may be other persons in the office, my lord, who may be responsible for, my lord, this, my lord, act also. And, my lord, in my case, my lord, as, my lord, even, my lord, the investigation officer and even, my lord, the PW2, that, my lord, my work part has been done. And, my lord, it was, my lord, lying on the table of the manager. That was the version. Now, my lord, here,
Who has given that statement?
my lord, my lord,
From where did they get that information?
please,
From where did the criminal court get that information?
my lord, from the, in the cross-section PW as well as the
Page 48 my lord.
page 180.
ಕಚೇರಿಗೂ ವಾಪಸ್ ಬಂದು ನನಗೆ ಸಂಬಂಧಪಟ್ಟ ದಾಖಲೆಗಳನ್ನು ತನಿಖಾಧಿಕಾರಿ ವಶಕ್ಕೆ ಪಡೆದು ಸರಿ ಅಂತ ಒಪ್ಪಿ ಅಂತ. Page 48
Next line ಅಲ್ಲಿ ಇರ್ಬೋದು.
Investigation officer, page 186. In, my lord, there is a note of accused on
186.
page 186, paragraph
Again
55.
reading from the,
Same.
sir, from the report, where do you find this information that the work was not pending before you? Please show. ಅದಕ್ಕೊಂದು ಪ್ಯೂನಿಟಿವ್ ಪ್ರಾವಿಷನ್ ಇರ್ಬೇಕು. ಈ ತರ ಹಾಸ್ಟೆಲ್ ಟರ್ನ್ ಆದ್ರೆ ಅಲ್ಲಲ್ಲ, ಈ ಆಕ್ಟ್ ಅಲ್ಲೇ ಇರ್ಬೇಕು. ಅದು ವಿಲ್ ಹ್ಯಾವ್ ಟು ಗೋ ಬ್ಯಾಕ್ ಫಾರ್ ಎವಿಡೆನ್ಸ್ ಆಕ್ಟ್, ಅದು ಇದು ಅದಲ್ಲ. when the entire statute is made only for this purpose, to consider the complaint being given by a person.
But the main thing, my lord, complainant has accepted the ingredients of his complaint, my lord. In page number 45, second para. ಆತನೊಬ್ಬರು ನನಗೆ ಸಂಬಂಧಪಟ್ಟ ಕೆಲಸವನ್ನು ಬೇಗ ಮಾಡದೇ ಇದ್ದ
ಒಂದು ಪ್ರಾವಿಷನ್ ಮಾಡಬೇಕು,
ಬೇಗ ಮಾಡದೇ ಇದ್ದ ಕಾರಣ ದಿನಾಂಕ
ಇಂಪೋಸ್ ಮಾಡಬೇಕು, ಅವಾಗ್ಲೇ ಅದು ಸರೋಗೋದಿಲ್ಲ.
ಬೇಗ ಮಾಡದೇ ಇದ್ದ ಕಾರಣ 10/10/2014 ಲೋಕಾಯುಕ್ತ ಪೊಲೀಸ್ ಠಾಣೆಗೆ ಹೋಗಿ ವಿಷಯ ತಿಳಿಸಿದಾಗ ಅಲ್ಲಿದ್ದ ಸಿಬ್ಬಂದಿಗಳು ನನ್ನ ಮಾಹಿತಿ ಮೇರೆಗೆ ನಿಶಾನೆ P1ರಂತೆ ದೂರ ಬರೆದಿದ್ದು ನಾನು ಆ ಅಂಶಗಳನ್ನು ಓದದೆ ಸಹಿ ಮಾಡಿದ್ದೇನೆ. ನನ್ನ ಬಳಿ
ಓದದೆ ಸಹಿ ಮಾಡಿದ್ದೆ. ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ ನಿಜ, ಅದ ಏನ್ ಬರ್ಕೊಂಡ್ರು ಅಂತ ನಾನು ಓದ್ಲಿಲ್ಲ, ಹಂಗೆ ಸಹಿ ಮಾಡ್ಬಿಟ್ಟೆ.
ಬಟ್ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿನ ಅಂತ ಹೇಳ್ತಾರೆ, ಕೆಲಸ ಮಾಡದ ಕಾರಣ ಹೋಗಿದ್ದೆ ಅಂತ ಹೇಳಿ ಅಕ್ಸೆಪ್ಟ್ ಮಾಡ್ತಾರೆ.
Page 64, page 64, paragraph 5.
No, we'll pass same orders. ಅದು ಯಾವ ಇನ್ನೊಂದು ಮಾಡಿದ್ವಲ್ಲ, ಅದು ತಕೊಡ್ರಿ, you will do the same.
20.28
because exactly same ಇದು. There also the KT had rejected the application. Same. Yes.
But since, my lord, in the case on hand, my lord, there is in, my lord, criminal proceedings and, my lord,
ಎಲ್ಲ ಅದೇ ಸೇಮ್, ಅದ್ರಲ್ಲೂ ಹಂಗೇನೆ
ಅಂದ್ರೆ
ಸೇಮ್ ಸ್ಟ್ಯಾಂಡ್ ಇಸ್ ಟೇಕನ್. ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಅಲ್ಲಿ ಅಕ್ವಿಟಲ್ ಆಗಿದೆ, and same set of charges, same witnesses. Yella adene.
And my lord, here they have waited for the outcome of the my lord, criminal proceedings. Here, my lord,
Agli.
the matter, my lord,
Agli. Even if the person is acquitted, it doesn't bar discipline proceedings,
it does.
even to be commenced, let alone proceed further. Fresh commence ಮಾಡ್ಬೋದು.
Yes, sir, but
Even after acquittal order being passed by the criminal court.
but my lord, the time taken, my lord, 2014, my lord, this was reported, and my lord, 2019, my lord, I was my lord, acquitted. My lord, now, my lord, this charge memo, my lord, the charge memo, my lord, was in the year 2016 itself. Now, my lord, the order, my lord, passed, my lord, after these many years, my lord, my lord, now in the year 2000, my lord, 22, 23. My lord, since from my lord 2016, my lord, it was my lord kept pending. My lord, and my lord, the outcome of the criminal proceedings were awaited, and thereafter, my lord, this order was issued.
All right.
And this one decision, my lord, lordship, my lord, in the other matter also, my lord, may I, my lord, the same, my lord, which, my lord, lordship are aware, my lord, even in the other matter also, my lord, had produced. With regard to, my lord, the
What is
honorable
honorable acquittal?
honorable acquittal.
We have considered this also. In that judgment, we have considered this also.
Yes.
Yes.
And that, my lord, in that matter, my lord, all of the, my lord, the witnesses were, my lord,
In
they have-
fact, there is a judgment of the Supreme Court, more than one, as to what is honorable acquittal. And you people are citing this division bench judgment of our court.
ಅಲ್ಲ, ರಾಮ್ಪಾಲ್ ರೆಫರ್ ಮಾಡಿದ್ದಾರೆ.
What is honorable acquittal? ಇದ್ಯಾವ್ದು ಇದು? ಅದಲ್ಲ. What is honorable acquittal ಅನ್ನೋದನ್ನೇ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ. Yes.
ಇದು ಕೂಡ ಎಲ್ಲ ಅಬ್ಸರ್ವ್ ಮಾಡಬೇಕು.
ಇದು ನನ್ನ ಕರೆಕ್ಷನ್ ನಾಳೆ ಅದರಲ್ಲಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹ್ಯಾಸ್ ಸೆಡ್ ದಿಸ್ ಅಬೌಟ್ ಆನರಬಲ್ ಅಕ್ವಿಟಲ್ ಅಂತ ಒಂದು ಪ್ಯಾರಾಗ್ರಾಫ್ ಇದೆ, ಅದನ್ನು ತೆಗೆದು ಇದಕ್ಕೆ ಹಾಕಿ. ಎಸ್. Dismissed. Yes.
Seal number 42 BC Jaka.
Infirm order challenged by the petitioner, my lordship. Declaration of result. Result and challenge ಮಾಡಿದ್ದಾರೆ. The infirm order dated on.
ಇಲ್ವಲ್ಲ, there is no one on the other side. ನೀವಾ? You are appearing.
Sri BC Jackor. The petitioners, my lords.
42.
We are working as Gramin Dak Sevak, branch post masters, my lords. They have appeared for limited department competitive examinations, my lords. Examinations were called for both together Gulbarga, Kalaburagi division as well as Yadgiri division. While announcement of results, my lord, divisions have been bifurcated, and I was deprived of one job. That's only submission. And CAT has
rejected my claim.
Yes. Where is the impugned order?
Yet, Kanekshar Mahaswami. See, my lords, page 138. Relevant portion is at my lords. Para 9, 140, page 140, my lords. Last page, my lords. The number of vacancies notified on 25/11/2022, 49 posts for Kalaburagi division and 7 posts for Yadgiri division exceeded the vacancies notified earlier on 18/11/2022. 40 posts for Kalaburagi division and 5 posts for Yadgiri division, and the vacancies indicated on 9/1/9/2022. 25 posts for Kalaburagi and nil posts for Yadgiri. The revision of the number of vacancies available in Yadgiri division has shown upward trend only and does not possibly render any disadvantages to applicants. Keeping the above points in view, there is no merit in the application filed by the applicant seeking quashing of the result published by the respondents by memo dated 25/11/2022. The OA is accordingly dismissed in limine. Para 8 is also relevant, my lords. The notification dated 15/7/2022, by which the LDC examination has been held, clearly indicated that the number of vacancies for postman bar mail guard will be notified later. The respondents have consequently finalized the candidates based on their preference for the competitive examination held on 4/9/2022 and the DEST held on 23/10/2022 based on the final vacancies notified on 25/11/2022 for Kalaburagi and Yadgiri division separately. Only ground is that, my lords, after appearing for examination, results were announced after bifurcation of both the divisions. That's all.
How is it considered? Paragraph 4.
Paragraph A to 9 is relevant just now, which I have read.
Paragraph number 7.
7, in para 7, my lord, I have contended that the contention of the applicant that since there was no separate indication for the vacancies in Kalaburagi and Yadgiri division, and hence the results of the LDC examination for the post of postman in respect of these two divisions is not in order.
You admit that in the year 2022, there was a bifurcation?
Yes.
Hello.
Yes.
You admit that there was a notification issued and there was a bifurcation?
Yes.
Huh?
How?
You people continue to be in
Yadgiri division.
Yadgir. Avaga, you had no difficulty.
So, that's
Huh? But when the notification was issued to fill up the vacancy by way of promotion,
departmental exemption.
After conducting departmental examination,
they called invited application for those posts together for both the divisions. Later on, they bifurcate it, which will, by contention is that deprive me from.
How can it be deprival? Can you now be sent from Yadgir to Kalaburagi?
Yes.
There was a division in the year 2022 itself.
Yes, ma'am.
This notification was issued in July 2022.
Yes.
The bifurcation has taken place in February 2022.
Yes.
So you continued in Yadgir.
Yadgir divisions.
So even if such a notification is issued to fill up the vacancies
by way of lower departmental examinations,
how do you expect that even the post lying vacant in Kalaburagi should be open for you?
ಎರಡು ಒಟ್ಟಿಗೆ ಇದ್ದಿದ್ರೆ ನಮ್ಗೇನೋ ರ್ಯಾಂಕಿಂಗ್ ಬರ್ತಿತ್ತು ಅಂತ ಇವ್ರ ಆಸೆ ಸ್ವಾಮಿ.
ಇದ್ದಿದ್ರೆ it is an admitted fact that there was a division in the year 2022
before invitation of
before the
examination
was conducted.
Yes,
the examination notification was issued in July.
ಹೌದು ಸರ್.
Bifurcation took place in February.
I have already explained it to the petitioner, my lord,
Ah.
without recording my concession, my lords.
And it is also indicated that the number of vacancies
For Yadgir were more anta
will
ಬರೆದಿದ್ದಾರೆ.
be notified later ಅಂತ
Later ಅಂತ
ಹೇಳಿದಾರಂತೆ.
ಬರೆದಿದ್ದಾರೆ sir.
ಮತ್ತೆ
ಅದೇ ಅವು ಎರಡು ಒಟ್ಟಿಗೆ ಇದ್ದಿದ್ರೆ probably they could have selected.
ಇದ್ದಿದ್ರೆ ಪ್ರಶ್ನೆ ಬರೋದಿಲ್ಲ. ಯಾಕಂದ್ರೆ
My lords, only that settled principle that once game has been begun ಅಂದ್ಮೇಲೆ they cannot change the rule.
ಇಲ್ವಲ್ಲ. There is no change in the rules.
My contention, my lords.
Perfect. The petitioner who was one of the applicants before the Central Administrative Tribunal, Bangalore bench, in original application number 170/00487 of 2022, is before this court aggrieved of the impugned order passed by the tribunal. Full stop. Next para. The applicant is working as GDS BMP, in the postal department.
Gramin Dak Sevak branch post manager, my lords. GDS for Gramin Dak Sevak.
Gramin Dak Sevak.
Sevak. BPM means branch post master.
In the office of the branch
postmaster. He
Postmaster.
himself was working as a branch postmaster for Gramin Dak Sevak. Gramin GDS anta irutte sir. That is a separate wing, and
the applicant is working as branch post
master
master of the Gramin Dak Seva,
Sevak. Gramin Dak Seva ante. Correct.
Yadgir district.
Yadgir district for more than 5 years.
For more than 5 years. Good stop. After bifurcation of Kalaburagi district and Yadgir district being carved out as a separate revenue district, a declaration was issued by the Department of Posts in terms of memo dated 11/3/2022 that with effect from 1/4/2022, Yadgir will be a new postal division. Full stop. Thereafter, notification dated 15/7/2022 was issued by the department inviting applications for eligible candidates to appear in the limited departmental competitive examination, bracket LA for short LDCE, for filling up inter-alia posts of postman from the GDS employees who have completed 5 years of service. Full stop. The examination was held on 4/9/2022. Full stop. The petitioner, not being successful, filed an application before the tribunal.
In my lords, in his tatkalika pattiyalli, temporary list alli together ittu Swami.
So,
Later on, when division bifurcation as per divisions adaga, his name was.
last sentence ತಗೊಬಿಡಿ. It is contended by the learned counsel for the petitioner that in the provisional list, the name of the petitioner was
Is-
found.
At serial number 878 in annexure A5, my lords.
Full stop. However, in the final list, since there was a separate list announced for Kalaburagi district and Yadgir district, the name of the petitioner was not found in the list of selected candidates. Full stop. Aggrieved by the fact that the bifurcation and announcement of the selection list has caused the non-selection of the petitioner, it was contended before the tribunal that when such bifurcation was not shown in the notification, dated 15/7/2022, the respondents should not be permitted to bifurcate the list and announce two separate lists for Yadgir district and Kalaburagi district.
Division, my lord. Division.
Huh?
Division.
Division. Full stop. Next para. Learned Deputy Solicitor General of India, draws the attention of this court to paragraphs number 7 and 8 of the impugned order and submits that the tribunal has taken into consideration such contention made on behalf of the petitioner. Full stop. However, it was held that in the notification dated 15/7/2022 itself, it was made clear that the number of vacancies for postman bar male guard will be notified later. Full stop. The respondent authorities have consequently finalized the list based on their preferences or preferences given in the competitive examination held on 4/9/2022 and the DEST ಅಂದ್ರೆ ಏನ್ರಿ?
I too.
DEST held on
Data entry skill test, my lord.
and the data entry skill test held on 23/10/2022 based on the final vacancies notified on 25/11/2022, separately for Kalaburagi and Yadgir division. Full stop. Next para. Learned counsel for the petitioner, however, contends that the rules of the game cannot be changed after the issuance of the recruitment notification. Full stop. It is submitted that even in the latest judgment of the Honorable Supreme Court versus so and so, it has been held that cannot be changed midway through the recruitment process unless the extant rules so permit, or the advertisement, which is not contrary to the extant rules, so permit. Full stop. Next paragraph. Having heard the learned counsel for the petitioner, the learned PSG, and on perusing the petition papers, this court is of the opinion, considered opinion that the tribunal has rightly considered the fact that in the notification dated 15/7/2022, it was clearly indicated that the number of vacancies for postman bar male guard will be notified later. Full stop. The competitive examination was held on 4/9/2022 and the data entry
Skill test.
was held on 23/10/2022. Full stop. The number of vacancies were notified on 25/11/2022, whereby 49 posts were to be filled in Kalaburagi division and 7 posts in Yadgir division. Full stop. In terms of the earlier notification, vacancies notified on 18/11/2022, 40 posts were to be filled in Kalaburagi division and 5 in Yadgir division. Full stop. The petitioner cannot dispute the fact that in terms of memo dated 11/3/2022 and with effect from 1/4/2022, the postal division of Yadgir district was notified and the petitioner continued to be in Yadgir division.
Yes.
Full stop. Therefore, even on facts, it cannot be accepted that the petitioner had a right to seek appointment and postings in Kalaburagi division. Full stop. the notification of the vacancies on 25/11/2022, in terms of the reservation made in the recruitment notification dated 15/7/2022, cannot be said to be a change brought to the rules of recruitment, full stop. Therefore, the contention of the learned counsel for the petitioner that there was a change in the rules of the recruitment, cannot be accepted, full stop. We do not find any infirmity in the impugned order passed by the tribunal, full stop. Accordingly, the writ petition stands dismissed.
So further reading, number 43, J. Augustine.
This matter wherein
My
the
lord,
return
according for
statement is not
appellant
filed. ಅದು ಕೆಳಗಡೆ ಅಪಾರ್ಚುನಿಟಿ ಕೊಟ್ಟರು.
ಆಗಸ್ಟಿನ
ಊರಿಗೆ ಹೋಗಿದ್ದಾರೆ, ಸ್ವಲ್ಪ ಮಂಡೆ
ಹೋಗ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಮಂಡೆ ಇಡ್ಬೇಕಾಗಿ.
He said he'll come up with some judgments.
ಹೌದು,
ಎಷ್ಟು ಟೈಮ್ ಕೊಡಕ್ಕಾಗುತ್ತೆ?
ಫೈನಲಿ ಮೇಲೋಡು
And their
ಅಟ್ಲೀಸ್ಟ್ ನಾಳೆ
lords, the
Lord,
trial court has allowed their application on the say of the plaintiffs that there will be no objections on 22/10/2019.
ಸೆಟ್ಲ್ಮೆಂಟ್ ಬಗ್ಗೆ
ಹೌದು,
ಇಲ್ಲ, ಅದು ಲಾಸ್ಟ್ ಟೈಮ್ ಹೇಳಿದೆ. ಅವ್ರಿಗೂ ಕೂಡ 23 ಎಕರೆ ಗ್ರಾಂಟ್ ಆರ್ಡರ್ ಅಲ್ಲೇ ಗ್ರಾಂಟ್ ಆಗಿದೆ ಅವ್ರ ಫ್ಯಾಮಿಲಿಗೂ.
ಅವ್ರಿಗೂ ಬಂದಿದೆ.
ನಮ್ದು ಈಗ ಅವ್ರ ಮನೆಯಲ್ಲಿ ಈಗ 3-4 ಜನ ಮಕ್ಕಳಿದ್ದಾರೆ, ನಾವ್ ಒಬ್ರೇ ಇದ್ದೀವಿ. ಒಬ್ರೇ
ಇದು ಬಿಟ್ಟು ಬೇರೆ ಲ್ಯಾಂಡ್ಸ್ ಇದೆ ಅವ್ರು.
ಇಲ್ಲಿ RTC ತಗೊಂಡ್ಬಂದು ಕೊಟ್ಟಿದ್ದಾರೆ ಕ್ಲೈಂಟ್.
ತಪ್ಪಾಗುತ್ತೆ. All right, we'll pass orders.
I have given one judgment, my lords.
My lord, I am for
Para
respondent number
14.
2 and 3, my lord. The different number 1 and 2 before the trial court, my lord. The suit of the plaintiff was declared only on the observation that WS not filed by the defendants. my lord.
ಅಪೀಲು ಫೈಲ್ ಮಾಡಿಲ್ವಲ್ರಿ?
Sorry, my lord.
ನೀವು ಅಪೀಲು ಫೈಲ್ ಮಾಡಿಲ್ವಲ್ಲ? You are not supporting.
I am supporting appellant, my lord.
ಅದಕ್ಕೆ ಹೇಳ್ತಾ ಇರೋದು.
ಹಂಗ್ ಬರಲ್ಲ.
ಎಲ್ಲಿದೆ ನಿಮ್ಮ ಅಪೀಲು?
We have not filed.
ಮತ್ತೆ how can you stand on the other side and say no, I will support
No, due to the,
appellant?
due to not,
You are also a defendant,
yes, 1 and 2.
like the appellant herein.
Yes, they are the.
You are not preferred in the appeal.
Yes,
Then
only on the observation with not filed the WS, the suit of the plaintiff was declared.
ಹೌದ್ರಿ,
Yes, yes.
ಒಂದು ಆಪರ್ಚುನಿಟಿ ಕೊಟ್ರು ಫೈಲ್ ಮಾಡಿಲ್ವಲ್ಲ, ಏನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ ನಾವು?
Matter may be remanded back, my lord.
My lords,
The opportunity
now
to file a WS and
the-
fresh.
ಎರಡೆರಡು ಸರಿ ಕೊಡಕ್ ಬರೋದಿಲ್ಲ.
the reason is
After the amendment. No.
the reason is, my lords, why now they have come up with that. Your lordships have expressed the opinion. Now this person also encroached 4 acres of land. This is belong to the another branch. That is why all this problem has not started, because he is the single person holding the 20 acres and they are 3-4 persons, not their branch. For that reason, now they are encroaching the land of this. ಇಷ್ಟು ಬಿಟ್ರೆ ಮತ್ತೇನು?
ಜಾಗ ಇದೆಯಲ್ರಿ, ನೀವು ಅದನ್ನ ಅನುಭವಿಸ್ರಿ ಸಾಕು. ಬೇರೆಯವ್ರ ಜಾಗಕ್ಕೆ ಯಾಕೆ ಹೋಗ್ತೀರಾ?
ಎಲ್ಲರಿಗೂ ಸೇಮ್ ಗ್ರಾಂಟ್ ಆಗಿದೆ.
Yes.
Lord, ನಾಳೆ
2018 part 6 SCC 639 judgment I have given notes already regarding order 8 rule 1 of CPC.
ಯಾವ್ದದು?
ಇದು Atcom Technologies Limited versus YA Chunwala Company and others. ಅದರಲ್ಲಿ relevant para 14 to 16, 14, 15 and 16. Salem Advocate Bar Association
ಅದೇ
judgment.
ಇದ್ರದ್ದು ತಾನೇ
ಹೌದು.
ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್.
ಹೌದು.
ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್. Yes. ಏನು
my lord,
ನಾಳೆ citation ಹಾಕ್ಬಿಟ್ಟು ಇದು ಮಾಡ್ತೀವಿ. Finally one time ಕೊಡಿ, please.
All right. At the request of learned counsel for the appellant, finally release this matter tomorrow. Okay.
Bill number 45, final hearing matters. R.S. Siddhapurkar.
One ನಿಮಿಷ ರೀ.
Sir, boli.
We'll have it on Tuesday.
18th.
Please. What's in the at least top of the list, you feel. Because of the
17th.
reason that
17.
top of the
17.
list, because it may not reach because there are so many matters are date given.
ಇಲ್ಲ further hearing ಅಂತ ಇರುತ್ತೆ, so you can mention. If it does not reach also, in the end or 2:30 you can mention.
I will mention
Yes.
at 2, please. Thank you.
Seal number 45, R.S. Siddhapurkar.
Matter is called out. There is no representation for either of the parties. List this matter after winter vacation.
Seal number 50, Vikram Vijay Kumar.
Same order.
Seal number 51, Ejimat.
Same order.
Seal number 52, Narendra M. Reddy.
Same order.
Number 53, R.S. Siddhapurkar.
Same order.
Seal number 55, Ratnayan Shivayogimat.
My lords. Short point involved, my lords. My lords had heard almost 1 month back, my lords, that the adoptive son is adopted. In this case, my lord, partition suit has been filed by the wife and daughters against the husband, who he claims to be adoptive son. And the trial court has held that since he is an adoptive son, hence he cannot be treated as a co-partner, and he denied relief of partition. Now he has died, my lords. Academically, otherwise we are his LRs and we will be getting his, we will step into his shoes, my lords. And during his lifetime, he has sold some portion of land to the respondent number 2, my lords. Against the 2 appeals were preferred by me, my lords, against non-grant of relief and further declaring the he sold it as valid. And 2 appeals were preferred by me, my lords. That earlier, my lord, ನೀವು ಕೇಳಿದ್ರಿ ಸ್ವಾಮಿ, ಅಡಾಪ್ಟಿವ್ ಸನ್ ಅಂದ್ಮೇಲೆ ಅದು ಕರೆಕ್ಟೇ ಇರುತ್ರಿ ಅಂತ ತಾವು ಏನಾದ್ರು ರಿಸರ್ಚ್ ಮಾಡ್ಕೊಂಡ್ ಬನ್ನಿ ಅಂತ ಹೇಳಿದ್ರಿ. I had made research, but thrice it has not reached, my lords. This coordinate bench of this honorable court in the year 2017 itself has held, my lords.
ಯಾರು ಇಲ್ಲ ಅದರ್ ಸೈಡ್.
ಇಲ್ಲ, ಅವ್ರ ಹತ್ರ ನನ್ ಕ್ಲೇಮ್ ಏನೂ ಇಲ್ಲ ಸ್ವಾಮಿ. ಬರೀ ಅವ್ರ ಪೋರ್ಷನ್ಗೆ ನಾನು ಇದು ಮಾಡ್ತಾ ಇಲ್ಲ ಸ್ವಾಮಿ. ಆಲ್ರೆಡಿ ಸೇಲ್ ಆಗ್ಬಿಟ್ಟಿದೆ. ಐ ಆಮ್ ನಾಟ್ ಕ್ಲೇಮಿಂಗ್ ಆನ್ ದಟ್ ಪೋರ್ಷನ್. ರಿಮೈನಿಂಗ್ ಪೋರ್ಷನ್ ಆದ್ರು ನಂದು ಅಂತ. ಇಲ್ಲ, ಏನು ಗೆದ್ರು ಅವ್ರಿಗೇನು ಹಾನಿ ಮಾಡ್ತಾ ಇಲ್ಲ. ಹೌದಾ?
ಕೂತ್ಕೊಳ್ಳಿ, ಹೋಗಿ.
My husband had sold some portion of land to the respondent number 2, my lords. That is his during his lifetime. His our share, to the extent of his share, he is bound by his share. ಅದಂತೂ ಇರುತ್ತೆ ಸರ್. ಅದರ್ ರಿಮೈನಿಂಗ್ ಏನಂದ್ರೆ
ಅದರ್ ಸೈಡ್ ಯಾರು ಇಲ್ವಲ್ಲ ಈಗ.
ಹೌದು ಸರ್, ಹೇಮಕ್ ಕಿಣಿಯವ್ರು ಇದ್ದು ಸರ್. ಇಲ್ಲ, ಆಯ್ತು ಕಾರಣ ಒಂದ್ ಎನಿ ಶಾರ್ಟ್ ಡೇಟ್ ಕೊಡ್ತೀನಿ.
ಇಂಡಿಯನ್ ಶಾರ್ಟ್ ಡೇಟ್. Matter is called out. There is no representation for the respondents. Release this matter on 18th of December. Let us see.
Seal number 56, Ravi B. Patil.
Same order.
Seal number 58, Babu H. Metagudda.
This time argument time, milad accident between milad 2-wheeler and milad parking.
ಎಲ್ಲಿ ನಿಮ್ ಫ್ರೆಂಡ್
ಫೈನಲ್ ಕೂತಿದ್ರು ಸ್ವಾಮಿ. ಅದು ಜಜ್ಮೆಂಟ್ ಕೂಡ ತಿಳಿದಿರ ಸ್ವಾಮಿ. ಸ್ಟೆಪ್ 2 ಪಿಲಿಯನ್ ರೈಡರ್ ಮಂಡೆ ತಂದಿದ್ದಿಲ್ಲ ಸ್ವಾಮಿ. ಮೊನ್ನೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡೋ ಮುಂದೆ ಅದಕ್ಕೆ ಇವತ್ತು 2 ಪಿಲಿಯನ್ ರೈಡರ್ದು ಜಜ್ಮೆಂಟ್ ಕೂಡ ತಿಳಿದಿರ ಸ್ವಾಮಿ. ಅದು ತಂದಿದ್ದೀನಿ. ಅದೊಂದೇ ಮಿಲಾಡ್ ಪಾಯಿಂಟ್. ಅವರು ಅದು ಪಾರ್ಕ್ ವೆಹಿಕಲ್ ಸಿಂಗಲ್ ಬೆಂಚ್ ಅಲ್ಲಿ ಎಂಟೈರ್ ಲೈಬಿಲಿಟಿ ಪಾರ್ಕ್ ವೆಹಿಕಲ್ ಮೇಲೆ ಆಗಿದೆ ಸ್ವಾಮಿ. ಸೆಕ್ಷನ್ 128 ಪ್ರಕಾರ ತಾವು ಜಜ್ಮೆಂಟ್ ಕೇಳಿದ್ರಿ ಅದಕ್ಕೆ. ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಸ್ವಾಮಿ ನಮ್ ಇದು ರಿಲೆವೆಂಟ್ ಪ್ಯಾರಾ 13 ಅಲ್ಲಿ ತಾವು ಡಿಸ್ಕಷನ್
ಅಲ್ರಿ, what is running in the mind of this court is that in a two-wheeler, only 2 persons can travel.
header.
Insurance is accordingly done.
Correct.
Now, you are claiming in respect of a third person. What should happen?
It is a
Forget about the fact that merely because there is a violation of a provision of law, that by itself cannot be said to be the cause for the accident. May not be so. Adre insurance, what should happen to the
claimant is claimed against the two-wheeler. Insurance company two-wheeler, then
you understood. You understood what is the line of thinking? Insurance for a two-wheeler is done for the rider.
Only at pillion rider. I agree, my lord.
1 pillion rider.
Only 2 cases filed. One rider and 2 pillion. 1 pillion. Only 2 cases is filed, my lord, in this case, my lord.
Filing of the case alla. Now kelodu. There are 3 persons.
3 persons. I agree.
Admittedly 3 persons. Then what should happen to the policy?
But each the negligence aspect is
only limited difference, except the difference they cannot all these helmet ಇಲ್ಲ ಸತ್ತೋದ
ಅದೇ ಅದನ್ನ ಬಿಟ್ಬಿಡಿ.
ಇದು ಅಷ್ಟೇ ಮಾಡಿ 128 violation ಇದೆ. Though this is an offense, but it cannot take difference.
No. They are not talking about the offense part of it. That is what I am saying. Yes, it is not regarding the offense part of it for which criminal prosecution. Policy is issued by an insurance company.
Yes, in respect
sorry, my lord. One sorry, section
except 149, 47 old act.
My lord, para ತಾವು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಪ್ಯಾರಾ 13 ಓದ್ಬೇಡಿ ಸ್ವಾಮಿ, ತಾವು ಪೂರ್ತಿ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್ ಆಗತ್ತೆ. ಮಿಲಡ್ ಸಾರಿ ಮಿಲಡ್, ಪ್ಯಾರಾ 13 ತಾವು ಒಂದ್ಸರಿ ನೋಡ್ಬೇಡಿ ಸ್ವಾಮಿ, ಒಂದ ನಿಮಿಷ. ತಾವು ಪ್ಯಾರಾ 13 ಆಫ್ ದ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಜ್ಮೆಂಟ್ ನಿಮ್ಗೆ ಕ್ಲಾರಿಫೈ ಆಗತ್ತ ಮಿಲಡ್.
ಎಸ್,
ಪ್ಯಾರಾ 13 ನಮ್ಮ ಡಿವಿಷನ್ ಬೆಂಚ್ ಜಜ್ಮೆಂಟ್ ಅದಾವ ಸ್ವಾಮಿ, ಬಟ್ ಇದು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ತಾವು ಕೊಟ್ಟಿದ್ದೀನಿ ಸ್ವಾಮಿ.
ಆಯ್ತು.
But the above reason in our view is played. The fact that the deceased was riding on a motorcycle along with the driver and another may not by itself, without anything more, make him guilty of contributory negligence. At the most of it would make him guilty of being a party to the violation of the law. Section 128.
See, it has not been looked into in another angle. Now, let us see what is.
Accident, that is a distinction.
Why I am saying it is not about violation of the provision. Adalla ನಾವು ಕೇಳ್ತಾ ಇರೋದು. An insurance policy is done.
In policy ಯಾವಾಗ ಅಪ್ಲೈ ಆಗುತ್ತೆ ಸ್ವಾಮಿ? ತಮ್ಮ ಕೋರ್ಟ್ ಕ್ವಶನ್, ಈ ಟೂ ವೀಲರ್ ಮೇಲೆ ನಾವು ಕ್ಲೇಮ್ ಮಾಡಿದಾಗ ಅದು ಅಪ್ಲೈ ಆಗುತ್ತೆ ಸ್ವಾಮಿ. ವೈಲೇಷನ್ 128 ಮಿಲಾಡ್. ಇದು ನಮ್ದು ಟೂ ವೀಲರ್ ಪಾಲಿಸಿ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಮೇಲೆ ಕ್ಲೇಮ್ ಮಾಡಿದಾಗ
you are claiming
ನಾವು ಅಗೇನ್ಸ್ಟ್ ಪಾರ್ಕ್ ವೆಹಿಕಲ್ ಮೇಲೆ
from another
ಎನದರ್ ವೆಹಿಕಲ್ ಮೇಲೆ ಪಾರ್ಕ್ ವೆಹಿಕಲ್ ಮೇಲೆ ಲಾರಿ ವೆಹಿಕಲ್ ಮೇಲೆ ಕ್ಲೇಮ್ ಮಾಡ್ತಾ ಇರೋದು ಸ್ವಾಮಿ. ಅದ್ರ ಮೇಲೆ ಕ್ಲೇಮ್ ಮಾಡ್ತಾ ಇರೋದು ಸ್ವಾಮಿ. ನಮ್ಮ ವೆಹಿಕಲ್ ಇದ್ದಾಗ ತಾವು ಕೋರ್ಟ್ ಕ್ವಶನ್ ಕರೆಕ್ಟ್ ಇದೆ ಸ್ವಾಮಿ. ಅದೇ ಪ್ಯಾರಾ 13 ಅಲ್ಲಿ ಅದೇ ಡಿಸ್ಕಷನ್ ಮಾಡಿದಾರೆ ಸ್ವಾಮಿ. ಆಮೇಲೆ ಕೆನಾ ಕೇಸ್ ಪ್ರಕಾರ ಕಾಂಪೋಸಿಟ್ ನೆಗ್ಲಿಜೆನ್ಸಿ ಒಳಗೂ ಬರ್ತಾರೆ ಸ್ವಾಮಿ. ಇದು 2 ಅಪ್ಲೈ ಆಗುತ್ತೆ ಸ್ವಾಮಿ.
ಕಂಪೋಸಿಟ್ ಬರಲ್ಲ ಇದೊಳಗೆ.
ಇಲ್ಲಿ ಬರ್ತೀವಿ ಪಿಲಿಯನ್ ರೈಡ್ ಅದು ನಮ್ಮ ಟೂ ವೀಲರ್ ವೆಹಿಕಲ್ ಮೇಲೆ ಕ್ಲೇಮ್ ಮಾಡಿದಾಗ ಅದು 128 ಬರುತ್ತೆ ಸ್ವಾಮಿ, ಇಲ್ಲ ಅಂತ ಹೇಳಲ್ಲ.
Amendment section.
Sir, old act ಕೊಡಿ sir.
Old act.
Old act ನಲ್ಲಿ ಇವ್ರದ್ದು liability ಬಗ್ಗೆ.
One 47, old.
147.
So this is a claim against the offending vehicle.
Appending
Park.
vehicle, my lord.
Which is another vehicle.
Another vehicle, my lord. Comes under third party, my lord.
That is already decided single.
Already decide ಆಗಿದೆ ಸ್ವಾಮಿ. Entire liability fixed on the ಲಾರಿ my lord. ಅವ್ರದ್ದು ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ ಅಪೀಲ್ ಸ್ವಾಮಿ. ಇದರಲ್ಲಿ ನಮ್ದಲ್ಲಿ ಬೇರೆ ಜಜ್ಮೆಂಟ್ 2 ಜಜ್ಮೆಂಟ್ ಆಗಿದೆ ಸ್ವಾಮಿ. ಒಂದರಲ್ಲಿ 50% ಮಾಡಿದ್ದಾರೆ, 50-50. ಒಂದರಲ್ಲಿ ಎಂಟೈರ್ ಲೈಬಿಲಿಟಿ.
ಓನ್ಲಿ ವೆಹಿಕಲ್ ಇದ್ರದ್ದು ಅದು ಪರಾದಿಲ್ಲ ಅಂತ ಹೇಳಿ ತಮ್ದು ಒಂದು ಜಜ್ಮೆಂಟ್ ಇದೆ. ರಾಮ್ ಖಿಲಾಡಿ ಇಫ್ ದ ವೆಹಿಕಲ್ ಇಸ್ ಓನ್ಲಿ ಸಿಂಗಲ್ ವೆಹಿಕಲ್, that principle apply.
So there will be a claim against the same
vehicle.
ಸೇಮ್ ವೆಹಿಕಲ್.
ನಾವು ಒಂದು ಡೀಟೇಲ್ ಜಜ್ಮೆಂಟ್ ಬರ್ತೀರಿ ಆನ್ ದಿಸ್ ಪಾಯಿಂಟ್. ಸಂಗೀತ ಅಂತ ಹೇಳಿ ಬರ್ತೀರಿ ಒಂದು.
ಅದು ಸ್ಟಾರ್ಟಿಂಗ್
ಲಾಟ್ ಆಫ್ ಪೇರೆಂಟ್ ರಿಟರ್ನ್ ಆನ್ ಸಂಗೀತ ವರ್ಸಸ್ ಯುನೈಟೆಡ್ ಇಂಡಿಯಾ ಏನೋ ಇದೆ.
ಓನ್ ಆಕ್ಸಿಡೆಂಟ್.
ಎಸ್
ಅದು ಸೆಲ್ಫ್ ಆಕ್ಸಿಡೆಂಟ್, ಅದು ಬೇರೆ.
ನಾಟ್ ಫ್ರೀಜರ್ ಅಂತ ಹೇಳಿ ಹೆಲ್ಡ್ ಮಾಡಿ ರಿಲೈಂಗ್ ಅಪಾನ್ ಸೋ ಮೆನಿ ಜಜ್ಮೆಂಟ್, ನಿಂಗಮ್ಮ ಅಂಡ್ ಆಲ್ ಮಾಡಿ ಅಂಡ್ ರಾಮ್ ಕಿಲಾಡಿ ಮಾಡಿ ಡಿಟೇಲ್ ಜಜ್ಮೆಂಟ್ ಬರ್ತೀರಿ.
ಸೊ ಇವಾಗ
ಹಿಯರ್ ಇಸ್ ಎ ಕೇಸ್, there is another vehicle is there.
ಅಂಡರ್ ವೇ ಡಿಫರೆಂಟ್ ಪಾರ್ಕ್ ವೆಹಿಕಲ್ ನೆಗ್ಲಿಜೆನ್ಸ್ ಆಲ್ರೆಡಿ ಅಪೇಲ್ಡ್ ಆಗಿದೆ ಸ್ವಾಮಿ. ಎಂಟೈರ್ ಲೈಬಿಲಿಟಿ ಅಂಡ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಜ್ಮೆಂಟ್ ಪ್ರಕಾರ ಅವ್ರದೇ ಬರುತ್ತೆ ಸ್ವಾಮಿ ಪಾರ್ಕ್ ವೆಹಿಕಲ್.
ಸೊ ನೌ ಯು ಆರ್ ಓನ್ಲಿ ಆನ್ ದ ಕ್ವಾಂಟಮ್.
ಓನ್ಲಿ ನೆಗ್ಲಿಜೆನ್ಸಿ ಅಂಡ್ ಎನಾನ್ಸ್ಮೆಂಟ್ ಇದೆ ಸ್ವಾಮಿ. ಈಗ ನೆಗ್ಲಿಜೆನ್ಸಿ ಸಿಂಗಲ್ ಬೆಂಚ್ ಅಲ್ಲಿ ಅಪೇಲ್ಡ್ ಆಗಿದೆ ಸ್ವಾಮಿ. ಲಾರಿ ಲೈಬಿಲಿಟಿ ಆಗಿದೆ ಸ್ವಾಮಿ. ಲಾರಿ ಮೇಲೆ ಎಂಟೈರ್ ನೆಗ್ಲಿಜೆನ್ಸಿ. ನಾವು ಕ್ವಶನ್ ಈಸ್ ಮಿಲಡ್ ಎನಾನ್ಸ್ಮೆಂಟ್ ಲಾರಿ ಮೇಲೆ ಆಗಿದೆ.
ಚಾರ್ಜ್ ಶೀಟ್ ಇರೋದು ಲಾರಿ ಮೇಲೆ
ಇಲ್ಲ, ಇಬ್ಬರ ಮೇಲೆ ಆಗಿದೆ ಸ್ವಾಮಿ. ಅಬೇಟೆಡ್ ಚಾರ್ಜ್ ಶೀಟ್ ಪ್ಲಸ್ ಲಾರಿ ಮೇಲೆ. ಒಂದು ಜಜ್ಮೆಂಟ್ ಎಂಟೈರ್ ಲೈಬಿಲಿಟಿ ಪಾರ್ಕ್ ವೆಹಿಕಲ್ ಆಗಿದೆ ಸ್ವಾಮಿ. ಆಸ್ ಪರ್ ಜಜ್ಮೆಂಟ್
ಇದು ಈ ಜಜ್ಮೆಂಟ್ ಆಗಿದ್ ಮೈ ಹ್ಯಾಂಡ್ಸ್ ಆರ್ ಟೈಡ್ ಅಪ್, ಅದರ್ವೈಸ್
ಲಾಸ್ಟ್ ಟೈಮ್ ಕೊಟ್ಟಿದ್ದೀನಿ ಸರ್. ತಾವು ಇನ್ನೊಂದು ಕಾಪಿ ಕೊಡ್ತೀನಿ ಸರ್.
ಅಲ್ಲ ಇದಲ್ಲ,
ಅಲ್ಲ ಜಡ್ಮೆಂಟ್
ಇನ್ನೊಂದು ಕಾಪಿ.
ಯಾವ್ದು ಅದು?
ಸಿಂಗಲ್ ಬೆಂಚ್
ತಾನೆ ಇದೇನಾ?
ಹಾ ಮಿಲಡ್ ಅದೇ ಸರ್. ಅದರಲ್ಲಿ ಅವ್ರ ಅಪೀಲ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದಾರೆ.
ಗನ್ನಾಬಾಯಿ ರಾಥೋಡ್ ಇದೇನಾ?
ಹಾ ಮಿಲಡ್, ಹಾ ಗಂಗಾಬಾಯಿ ಮಿಲಡ್, ಐದು ಗಣ್ಣಾಬಾಯಿ ಮಿಲಡ್ ರಾಠೋಡ್. MAP 201020/17. ಇದು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಜ್ಮೆಂಟ್ ಫಾಲೋ ಮಾಡಿದ್ದಾರೆ ಸರ್. ಅರ್ಚಿತ್ ಸೈನಿ ಮಿಲಡ್ ಫಾಲೋ ಮಾಡಿ ಅವ್ರ ಅಪೀಲ್ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ. ಪ್ಯಾರಾ 5 ನಲ್ಲಿ ರೆಫರ್ ಮಾಡಿದ್ದಾರೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಜ್ಮೆಂಟ್.
So the entire liability is on
ಪಾರ್ಕ್ ವೆಹಿಕಲ್ ಲಾರಿ ಮೇಲೆ. ಈಗ ಓನ್ಲಿ ಎನಾನ್ಸ್ಮೆಂಟ್ ಅಷ್ಟೇ ಉಳಿದಿದೆ ಸರ್.
United India.
Yes.
United India.
Yes.
This appeal filed by United India Insurance Company has been dismissed.
Yes.
ಡಿಸ್ಮಿಸ್.
So in this judgment also full liability is.
Yes, mastermind.
ಆಯ್ತು. Now what else now?
Quantum or ಜಾಸ್ತಿ
Quantum milad is injured, claimant is injured milad. So many fractures are there milad in this case milad. In my synopsis milad, he is about 10 fractures milad. 9 fracture and 1 loss of eye witness. Eye vision milad, left eye vision. It milad. He is milad due to unable to speak about before evidence milad. His wife is given evidence milad. His loss of memory power and
ನಾನ್ ಟ್ರೀಟಿಂಗ್ ಡಾಕ್ಟರ್, ಈ ಡಾಕ್ಟರ್ ಅಗೇನ್ಸ್ಟ್ ಸ್ಟ್ರೆಚರ್ ಪಾಸ್ ಮಾಡ್ಯಾರ ಎಲ್ಲ ನಮ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ. ಡಿಸಬಿಲಿಟಿ ಸರ್ಟಿಫಿಕೇಟ್ ಸ್ಟ್ರೆಚರ್ ಪಾಸ್ ಮಾಡಿದಾರೆ. ಸರ್ಜನ್, ನ್ಯೂರೋ ಸರ್ಜನ್ ಕೊಡ್ತಾರ, ಥ್ರೋಟ್ ಕೊಡ್ತಾರ, ಆರ್ಥೋಪೆಡಿಕ್ ಕೊಡ್ತಾರ, ಎಲ್ಲ ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಡ್ತಾರ. ಅಂಡ್ ದ್ಯಾಟ್ ವಿಲ್ ಕಾಂಟ್ರಿಬ್ಯೂಟ್ ಟು ದ ಮೆಡಿಕಲ್ ರೆಕಾರ್ಡ್ಸ್.
Milad, our memory power loss agidrinda na milad, his wife is milad appeared on behalf of the claimant, injured claimant.
No, that's all right. He can't find fault on that ground that his wife has come and led adalla heltaradu. Not that.
In
the certificate is given by a non-treating doctor.
Non-treated, I agree. Milord, in observation of the trial court in page number 29, last 3 line, Milord, then. Milord, 1, 2, 3, 4, 5, 6, 7, last, Milord, 6th line alli observation ಮಾಡಿದ್ದಾರೆ. Page number 19, 29 alli, judgment alli. If little improvement is seen, then also due to neurologically problems, the hemiparesis occur and he is not in a position to carry out agricultural work. Even as a labor, he cannot do work, can be gathered. Therefore,
please come to issue number 3. Alinda Odi.
Issue number 3.
Previous page. Other paragraph, previous page. Paragraph number 11.
11. Oh. Issue number 3, parallel. PW1 in her evidence has stated that arising out of the accident, her husband Chinnareddy has sustained fracture injuries his upper and lower limb, over right hand, neck bone, face, left temporal bone, injured to his left eye, and brain injury, for which he took treatment in Baswa Hospital, Raichur. Thereafter took treatment in Yashoda Hospital, Hyderabad from 30th 3 2016 to 9/3/9/4 2016 as inpatient. Again, her injured husband was shifted to Saint Mary Hospital, Ballari. Took treatment for more than a year conservatively. She has incurred expenses to the tune of rupees 8 lakh for her husband treatment and surgery. Testing etc. Wound certificate produced exhibit P2 from Baswa Hospital shows that multiple hemorrhagic contusion in the left temporal context, larger contusion measuring 2.6 and 2.7 centimeter with adjacent post-traumatic edema, acute subdural hematoma, SDH in the left temporal parietal context measuring 7 mm thickness at its maximum diameter, pneumocephalus, the left temporal parietal cortex, diffuse cerebral edema, mass effect in the form of midline shift towards right side measuring 3 mm, segmental fracture in the squamous part of left temporal bone with fracture fragment in the left temporal lobe and fracture in the lateral wall of left orbit. Therefore, he had suffered severe head injury arising out of the accident, can be gathered from the initial wound certificate from Baswa Hospital. Therefore, the injured suffered the petitioner are grievous in nature. This tribunal is of the view that petitioner is entitled to get compensation under the following heads. Next, as per exhibit P2 wound certificate and discharge card.
What is the disability cost? ಇಷ್ಟೆಲ್ಲ ಹೇಳಿದಾರಲ್ಲ, what is the disability cost?
Disability cause
or is it only towards medical expenses?
Kindly say medical evidence.
Right eye vision ಹೋಗಿದೆಯಾ?
Lordship.
Right eye vision ಅಂತ ಹೋಗಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ PWT. Right eye vision.
Vision partial loss of vision.
Partial.
Partial.
ಪೂರ್ತಿ ಹೋಗಿಲ್ಲ.
ಪೂರ್ತಿ ಹೋಗಿಲ್ಲ ಸ್ವಾಮಿ.
35% ಕೊಟ್ಟಾರೆ.
ಅದೇ ಸ್ವಾಮಿ ಅವರು ಟೋಟಲ್ ಕೊಟ್ಟರು ಸ್ವಾಮಿ PW2.
ಅವರು 56%. ಒಂದು ಬಾಡಿ. ಇದು
ಇನ್ಕಮ್ ಏನು ಅಗ್ರಿಕಲ್ಚರಲ್ ಕೂಲಿ. ಇನ್ಕಮ್ ಏನು?
2016 8,750 ಇದೆ ಸ್ವಾಮಿ, ಬಟ್ ಅವ್ರು 6,000 ತಗೊಂಡಿದ್ದಾರೆ. ಆಮೇಲೆ ಅದರ್ ರೇಟ್ಸ್ ಸ್ವಲ್ಪ ಕಡಿಮೆ ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ.
ಯಾವಾಗ? 2016
16 ಮಿಲಾಡ್
8,750.
ಹಾ ಮೇಡಮ್.
8,000.
ಎಲ್ಲಿದೆ ಡಿಸ್ಕಷನ್?
ಇಲ್ಲಿ ಪೇಜ್ 36 ಅಲ್ಲಿ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಮಾಡಿ 6,000 as considered.
ಪೇಜ್ ನಂಬರ್ 26 ಅಲ್ಲಿ ಲಾಸ್ಟ್ 2 ಲೈನ್ ಅಲ್ಲಿ ತಗೊಂಡಿದ್ದಾರೆ.
ಇಲ್ಲಿ 18% ಅಂತಾರೆ.
No.
Page number 37 of the judgment. Ink page number.
Page number 18, madam.
ತಪ್ಪಿದೆ ಇದು. ಇದು ಟೇಬಲ್ ಆಗಿ ಬರೆದಿದ್ದೀರಲ್ಲ. For loss of future earning on account of disability suffered due to the extent of 18% to whole body ಅಂದ್ರೆ.
ಇಲ್ಲ 35% ತಗೊಂಡಿ.
ಅದು 35 ಆಗ್ಬೇಕಿದೆ.
ಇಲ್ಲ
ಇಲ್ಲಿ
35
ಇದೆ.
ಇಲ್ಲ 35 ತಗೊಂಡಿ.
ಇಲ್ಲಿ 18 ಅಂತ ಹಾಕ್ಯಾರೆ. Internal judgment page number 31 table.
31.
ಹಾ ಮೇಡಮ್, ಹೌದು ಕರೆಕ್ಟ್. ಇಲ್ಲಿ 35 ತಗೊಂಡಿದ್ದಾರೆ ಸ್ವಾಮಿ, ಇಲ್ಲಿ 18 ಅಂತ ಆಗಿದೆ. ಲಾಸ್ ಆಫ್ ಫ್ಯೂಚರ್ ಅರ್ನಿಂಗ್ ಆನ್ ಅಕೌಂಟ್ ಆಫ್ ಡಿಸಬಿಲಿಟಿ.
ಮಿಸ್ಟೇಕ್ ಆಗಿರೋದು.
ಇದು ಮಿಸ್ಟೇಕ್ ಟೈಪ್ ಮಿಸ್ಟೇಕ್. ಇದು ಅಮೌಂಟ್ ಎಲ್ಲ ಕರೆಕ್ಟ್ ಇದೆ ಸ್ವಾಮಿ, ಅದು ಟೈಪ್ ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ, 18 ಆಗಿದೆ. ಅದೇ ಕಾಪಿ ಟು ಪೇಸ್ಟ್ ಮಾಡೋ ಮುಂದೆ ಆಗ್ತಾವ ಸ್ವಾಮಿ. ಇನ್ಕಮ್ ಪ್ಲಸ್ ಅದರ್ ಎಡ್ಸ್ ಸಮ್ ಡಿಸಬಿಲಿಟಿ ಯಾಕಂದ್ರೆ ಲಾಸ್ ಆಫ್ ಮೆಮರಿ ಪವರ್ ಇದೆ ಸ್ವಾಮಿ, ಸಮ್ ಗಿಡ್ಡಿನೆಸ್ ಅಂಡ್ ಲಾಸ್ ಆಫ್ ಐ ವಿಷನ್ ಇದೆ.
$6,000 ತಗೊಂಡಿದಾರ?
ಹಾ 6,000.
6,000 ತಗೊಂಡು.
So that should be
8,000.
750. ವರ್ಕೌಟ್ ಮಾಡಿದೀರಾ? ವರ್ಕೌಟ್ ಮಾಡಿದೀರಾ?
ಮಾಡಿಲ್ಲ. ಅದೇ ನಾನು ಡಿಸಬಿಲಿಟಿ ಅದೇ ಎಷ್ಟು ತಗೋತಾರ ಅನ್ನೋದು ಸಂಬಂಧ ಮಾಡಿಲ್ಲ. ಈ ಸಪೋರ್ಟ್ ಮಿಲಡ್
ಸ್ಟಾರ್ಟ್ ನಾಳೆ ಹಾಕ್ಬೇಕು.
ಡಿಸಬಿಲಿಟಿ ತಗೊಂಡ್ರೆ ಮಾಡಿಕೊಟ್ಬಿಡ್ತೀವಿ.
Disability is already in higher side.
ಅವ್ರು ಹೋಲ್ ಬಾಡಿ ಕೊಟ್ಟಿದ್ದಾರೆ, ಬಟ್ ತಗೊಳೋದು ಕಡಿಮೆ ತಗೊಂಡು. ಲೆಫ್ಟ್ ಟೆಂಪೋರಲ್ ಬೋನ್ ಫ್ರಾಕ್ಚರ್ ಆಗಿದೆ, ಲೆಫ್ಟ್ ಆರ್ಬಿಟು, ಲೆಫ್ಟ್ ಮೆಡಿಯಲ್ ವಾಲ್ ಆಫ್ ಲೆಫ್ಟ್ ಆರ್ಬಿಟು, ಲೆಫ್ಟ್ ಫ್ರಂಟಲ್ ಬೋನು and left maxillary, left zygomatic arch, left sphenoid bone and right and upper lower limb G3 ಅದು ಗ್ರೇಡ್ ಲೋವರ್ ಇದಾಗಿದೆ.
ಆಯ್ತು, 35% ಅಲ್ಲಿ ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡ್ರಿ.
ಆಯ್ತು.
8,750.
35%
Multiplier.
41, 14 ಬರ.
14 multiplier.
8,750.
ಹಾ.
Into 12. ಎಷ್ಟಾಯ್ತು?
5,14,500.
ಹಾ?
5,14,000.
5,14,500 ರೂಪಾಯಿ.
5,14,500 ಬರುತ್ತೆ. ಟೋಟಲ್ ಆಫ್ಟರ್ ಮೈನಸ್ ಮಿಲೆಟ್ 1,61,700.
14. Into 35%. ಹಾ, ಎಷ್ಟಾಯ್ತು?
5,14,500 ಬರುತ್ತೆ.
14,000. ಇಲ್ಲಿ 3,52,000.
3,52,000 minus ಮಾಡಿ 1,61,700
35 ಮಾಡಿದಾರಾ?
ಹಾ, ಅಲ್ಲೂ 35 ಮಾಡಿದ್ದಾರೆ.
35.
14 multiplier.
14
multiplier.
ಅಲ್ಲಿಗೆ ಬರುತ್ತೆ ಸೇಮ್ ಫಿಗರ್ ಮತ್ತೆ
ಅಲ್ಲ, ಇಲ್ಲಿ
5,14,500. ಇದೆಲ್ಲ ಮಾಡಿದ್ರೆ ಅಣ್ಣ
ಹಾ, ಟೋಟಲ್ ಬರುತ್ತೆ 5,14,500.
ಅಲ್ಲಿ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ?
ಅಲ್ಲಿ
3,52,000.
800.
1,61,700 ಎನಾನ್ಸ್ ಆಗುತ್ತೆ.
ಮತ್ತೆ ಬೇರೆ
ಬೇರೆ ಹೆಡ್ಸ್ ಕಡಿಮೆ ಕೊಟ್ಟಿದೆ ಸುಮ್ಮನೆ. ಟೋಟಲ್ ಮಿಲಡ್ 7 ಫ್ರಾಕ್ಚರ್ಸ್ ಆಗಿದೆ ಸುಮ್ಮನೆ. ಅದು 40,000 ಕೊಟ್ಟಿದ್ದಾರೆ ಪೇನ್ ಅಂಡ್ ಸಫರಿಂಗ್. ಅವೆಲ್ಲ ಜಾಸ್ತಿ ಆಗುತ್ತೆ. ಈ ಟೇಕನ್ ಹೈದರಾಬಾದ್ ಹಾಸ್ಪಿಟ್ಲು, ರಾಯಚೂರು, ಬಳ್ಳಾರಿ ಎಲ್ಲ ಕಡೆ ತಗೊಂಡಿದ್ದಾರೆ.
ಲೆಫ್ಟ್ ಐ is on 1 lakh.
ಆಯ್ತು. ಇದನ್ನ ಪೇನ್ ಅಂಡ್ ಸಫರಿಂಗ್ 1 lakh.
ಮೆಡಿಕಲ್ ಎಕ್ಸ್ಪೆನ್ಸ್ ಕರೆಕ್ಟ್ ಐತಲ್ಲ?
ಅದು ಸರಿ ಇದೆ.
ಕರೆಕ್ಟ್.
ಅದು ಕರೆಕ್ಟ್ ಇದೆ.
ಅಟೆಂಡೆಂಟ್ ಚಾರ್ಜಸ್
ಅದನ್ನು 25,000 ಮಾಡಿ.
ಅದು
ನರ್ಸಿಂಗ್
ಸ್ವಲ್ಪ ಅಟೆಂಡೆನ್ಸ್ ಚಾರ್ಜಸ್ ಯಾಕಂದ್ರೆ ಬಳ್ಳಾರಿ ಪ್ಲಸ್ ಹೈದರಾಬಾದ್ ಪ್ಲಸ್ ರಾಯಚೂರು ಎಲ್ಲ ಕಡೆ
25 ಮಾಡಿದ್ರು.
ಅಟೆಂಡೆಂಟ್ ಚಾರ್ಜಸ್ 25.
ಆಯ್ತು.
ಇದು ಎಕ್ಸ್ಟ್ರಾ ನರಿಶ್ಮೆಂಟ್, ಸ್ಪೆಷಲ್ ಡಯಟ್, ನರ್ಸ್
10,000.
ಅದನ್ನು 25 ಮಾಡಿ. ಲಾಸ್ ಆಫ್ ಅರ್ನಿಂಗ್ ಈಗ ಇದು ಚೇಂಜ್ ಆಗುತ್ತೆ. 8,750 ಇಂಟು 3 months ಮಾಡ್ರಿ. ಅದು
26,000.
8,750 ಇಂಟು 3
26,250.
26,250. ಫ್ಯೂಚರ್ ಮೆಡಿಕಲ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್
25.
ಲಾಸ್ ಆಫ್ ಮಿನಿಟ್ಸ್ 25.
25 ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಸ್ವಲ್ಪ ಇನ್ನೊಂದು ಸ್ವಲ್ಪ ಹೆಚ್ಚು.
ಸರಿ, 1 lakh. ಇದು ಲಾಸ್ ಆಫ್ ಅಮ್ಯುನಿಟೀಸ್ 1 lakh. ಎಷ್ಟಾಯ್ತು ಲೆಕ್ಕ ಹಾಕು.
ಎಷ್ಟಾದ್ರು 5 ಲಕ್ಷ.
Eight lakhs 15,750. 8,15,750.
ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಇಲ್ಲ ಮಿಸ್ಟೇಕ್. ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ.
ಏನೋ ಮಿಸ್ಟೇಕ್ ಆಗಿದಿಲ್ಲ.
ಹಾ.
2,66,000 ಬಿಟ್ಬಿಟ್ಟಿದ್ದೀವಿ.
ಮೆಡಿಕಲ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್.
ಮೆಡಿಕಲ್ lakh
ಅಂಡ್ ಫ್ಯೂಚರ್ ಮೆಡಿಕಲ್ ಫ್ಯೂಚರ್ ಮೆಡಿಕಲ್ ಎರಡು ಕೊಟ್ಟು.
ಆಮೇಲೆ ಫ್ಯೂಚರ್ ಮೆಡಿಕಲ್ ಎಕ್ಸ್ಪೆನ್ಸ್
ಅದು 25
ಅದು ಅದು ಮೆಡಿಕಲ್ ಒಂದೇ ಕೊಟ್ಟು.
ಇದೊಂದು ಬಿಟ್ಟೋಗಿತ್ತು ಅಷ್ಟೇ. ಸೊ ಇಟ್ ವಿಲ್ ಬಿ 10,81,830.
ರೈಟ್.
10,81,830.
ಹಾ.
Yes.
Number 59, government advocate.
My lord, after occasion,
Negligence. Respond.
Negligence 100%.
ಆಯ್ತು.
ಆ judgment ಪ್ರಕಾರ.
Okay.
Not
after
case of regularization, my lord, they have, most of them have reached the age of superannuation. There is no compliance of 17B also, my lord. Now, my lord, without raising the point, my lord, of maintainability in the appeal now wanted to urge the ground of maintainability of.
State has filed this.
State.
yes,
After 25 years of service, my lord, their application for regularization, my lord, endorsement was issued, stating that they cannot be regularized. Learned single judge, my lord, has scrutinized, my lord, the entire material placed on record and has given the relief. From 2022, my lord, it is difficulty, my lord, of daily wages. My lord.
ಏನ್ರಿ? ready
My
ಇದೀರಾ?
lord. Earlier, AG is appeared, my lord.
AG.
Yes, Vijay Kumar, sir. He has request to adjourn matter after occasion.
ಏನ್ ಬರ್ತಾನೆ ಇಲ್ಲ ಅವ್ರೀಗ?
ಇಲ್ಲ, ಅವ್ರು ಇವತ್ತು ಒಂದು ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ನಲ್ಲಿ
ಆಗೋಯ್ತಾ?
ಬಿಸಿ ಇದ್ದೀನಿ, ಇವತ್ತು ಬೇಡ ಅಂತ.
But the relevant portion, my lord, is at ink page number 27. Internal page, typed page number 15 of the order passed by the learned single judge. Paragraph number 3, my lord. Petitioners in all these petitions,
ಎಲ್ಲಿ paragraph?
my lord,
Para?
para 3, my lord, internal page number 15, typed page number 15, running page number 17 of the petitioners in all these petitions are all employees of first respondent KBGNL and erstwhile employees of the Department of Irrigation, out of which the KBGNL is created. In all these cases, there are appointments are prior to 1/7/1984. The reference to 1/7/1984 is made in the light of the fact that every employee who has been appointed prior to 1/7/1984 have been regularized in terms of the government order dated 6/8/1980 on completion of 10 years of service. The petitioners in these cases had all given representation seeking regularization of their services on completion of 20 years of service with the respondent state and later with KVJNL. These respondents were directed to the representations were directed to be considered by this court in the aforesaid writ petitions within an outer limit of 12 weeks. This claim came to be declined by the first respondent on the ground that the petitioners do not fulfill the conditions stipulated in government order dated 6/8/1990 and are now claiming regularization of their services both on the strength of the earlier government order dated 6/8/1990 and in terms of the judgment of the apex court in the case State of Karnataka versus Sumadevi. Heard Sri so and so learned counsel and Sri so and so for the respondents and Sri so and so appearing for the KBJNL. Sri P. Vilas Kumar learned counsel appearing
So
for the
this should have been 6/8/1990.
Please.
Oh, sorry, sir. ಆಯ್ತು.
Monday, if lordship.
ಬೇಡ ಬೇಡ. ಇದನ್ನ we can't conclude. ಅವರು ಏಜ್ ಅವ್ರು ಬರ್ಬೇಕು ಅಂತ ಹೇಳ್ತಾರೆ.
Monday, ಮಲ್ಲ?
Monday. ಮುಂದೆ ಆಗೋದಿಲ್ಲಪ್ಪ. At the request of learned AGA, release this matter on 18th of December, Wednesday.
My lords, serial number 60, my lords. The last matter, my lord, serial number 60.